Good morning. Welcome. I remain Jessica Malugin of the Competitive Enterprise Institute on day 2 of the Tech Freedom and CEI conference surrounding issues of free speech and federal agencies and their constitutional limits. Today, we are going to focus on the Federal Communications Commission, but I am going to let the illustrious Baron Soka of Tech Freedom fill you in more about that. For now, thank you so much for being with us.
Well, thanks, Jess, for having us. Thank you for hosting us here at CEI. Tech Freedom's very happy to be doing this event. I hope you'll all tune in to watch yesterday's discussion of the First Amendment and what the Federal Trade Commission and the Department of Justice can do. Today we're talking about the Federal Communications Commission, which was long ago dubbed by some wit the Federal Censorship Commission. So these concerns are not entirely new, although today maybe they've been taken to the next level. But I'm very pleased here today to have with us for a fireside chat FCC Commissioner Ana Gomez. Ana, you've been speaking very forcefully about these issues, so let's hear what you have to say as a longtime communications lawyer and expert in this field. Thanks for coming.
Thank you, Baron. Thank you for having me. Good morning, everyone. Our current political moment poses challenges unlike anything I thought I would face as an FCC commissioner. This administration has been on a campaign to censor and control since, well, before day one. And since day one, the FCC has been implementing the will of the administration and undermining the First Amendment at every turn. In fact, battling the administration's campaign of censorship and control is the theme of the First Amendment tour I announced last month. I have been honored and humbled by the amount of support I have received while talking about these issues. And I felt the need to start taking our message in defense of our fundamental First Amendment rights and freedoms outside of Washington because I have been alarmed by recent actions by this administration. And those who know me know I am not an alarmist. But here is what concerns me. The First Amendment has protected our fundamental right to freely speak and to hold power to account since 1791. It is foundational to our democracy. And yet today, the greatest threat to that freedom is coming from our own government. Silencing dissenting voices is not a show of strength. It's a sign of weakness. It comes from a place of fear. Fear that opposing views rather than presidential decrees will win out in the public debate of ideas. As you all know, the FCC has targeted the editorial decisions of news networks, independent reporting by public media, and internal labor practices by private companies. These are dangerous and unprecedented actions by an independent government regulator. And groups across the ideological spectrum agree with this assessment. Over the last few months, I've found myself aligned with voices with which I never imagined I'd agree. However, we all share a belief that the First Amendment is fundamental to democracy and is worth fighting for, even and especially when it's politically inconvenient. The actions this FCC has been taken threaten a free and independent press, undermine the First Amendment's free speech protections, and exert undue pressure that compromises the autonomy of private enterprises. And more broadly, actions across the federal government have demonstrated a disturbing pattern of silencing dissenting voices. Here are just some of the most egregious examples. They have initiated investigations and floated debilitating rate regulation schemes that target national network broadcasters for their newsrooms' editorial decisions, harassed private companies for their diversity, equity, and inclusion efforts, and threaten tech companies that respond to consumer demands for content moderation and fact-checking. Separately, they have attempted to shutter Voice of America and sought retribution against lawful residents that protest administration policies. They are banning books and seeking to erase history from public record and from our national museums. And they are targeting law firms, unions, and all those who have the skill and the will to stand up for the victims of this campaign of censorship and control. And of course, I cannot leave out the fact that they have been firing presidentially appointed, Senate-confirmed commissioners of multi-member independent agencies. The administration seems intent on targeting anyone who dares to speak up and disagree with its extreme agenda. Today, I want to talk about the FCC actions that are antithetical to the Communications Act, the remit of the agency, and the guarantees of the First Amendment. Let's start with broadcasting. The FCC's licensing authority is being weaponized to chill speech and to punish the press. We are witnessing a dangerous precedent, the transformation of an independent regulator into an instrument of political censorship. This FCC has made clear that it will go after any news outlet that dares to report the truth, if that truth is unfavorable or inconvenient to this administration. This isn't the first time the FCC has faced administration pressure to weaponize its broadcast licensing authority. Both FDR and Kennedy attempted to pressure the FCC chairs to silence voices that criticized the president and his administration. In both cases, the FCC chairs stood up for the integrity of the agency and refused to capitulate. That is what courage looks like. FCC chairs refusing to wield the agency's licensing authority as a weapon in contravention of the First Amendment and the Communications Act, even in the face of political pressure. Now I want to be clear. The consequences of silencing broadcasters go beyond undermining informed civic engagement. There are serious health and safety implications. Local news provides life-saving information during emergencies. It serves veterans, seniors, and rural communities. But partisan politics is now putting these resources at risk. The FCC should not be in the business of controlling access to vital local information. We should be promoting free and open access to the news. Unfortunately, the administration's efforts to censor and control appear to be working. Some media outlets are finding it easier to retreat in the face of government threats, veiled or otherwise, than to be responsive to their audiences. As I'm sure you're all aware, last month, Bill Owens, the executive producer of 60 Minutes, resigned because he no longer felt he had the independence that honest journalism requires. This is deeply concerning. We need journalists who feel free to report the truth, even when it cuts against our political biases. And corporate parents should give journalists an independence they need. A free press requires free journalists. On the international front, Voice of America and Radio Marti were once models of press freedom, in contrast to propaganda regimes like those of Russia and China. Efforts to shutter these institutions or to undermine their independence sends a global message. America no longer practices what it preaches. The press is the fourth estate. The delicate system of checks and balances upon which American democracy is built does not function without a free press. Another area of concern is online speech. With digital platforms now serving as the proverbial town square, government efforts to censor and control have also moved online. I'm talking about the efforts to reinterpret or undermine Section 230. Just as the administration is attacking journalists that hold it to account, it is also attacking digital media platforms that provide fact-checking and content moderation that users want. Claiming such user-supported moderation constitutes censorship, the administration has pressured social media companies to stop these practices. Now, the Supreme Court has been clear on this issue. Content moderation by private companies is itself a form of speech protected by the First Amendment. Fact-checking, filtering, and moderation are all legitimate responses to user demand. The government's duty under the First Amendment isn't to second-guess these market offerings. It's to stay out of the way. I acknowledge that there are many valid concerns about online safety, and Congress may well determine Section 230 needs reform. Until that happens, however, Section 230 plays a critical role by enabling digital platforms to establish rules of behavior in their own little corners of the market. FCC proposals to weaponize Section 230 are not efforts to solve the problems with online platforms. They are attempts to increase government control of online speech by exposing platforms that want to facilitate user-supported fact-checking or create welcoming online environments to debilitating lawsuits. This is not about reining in big tech. This is about censorship and control. And finally, in the vein of government control run amok, I want to talk about one more critical topic. We must protect the independence of independent agencies. The FCC is supposed to make decisions based on law, facts, and technical expertise, not politics. We take our direction from the Constitution, the law, and the public. That is what Congress intended. Specifically, it affirmatively declined to place the vast power of media regulation in the hands of a single individual. After thoughtful deliberation, Congress concluded that a multi-member, multi-party commission was the best choice. The relationship between the power vested in the FCC and the duty to uphold the First Amendment was unambiguous from the inception of the agency. While commissioners have had policy disagreements across the agency's history, by and large, we've understood the responsibility of ensuring that those on the outside look to us as a stable, independent, and expert-driven regulatory body. Problematically, as we've seen at other independent agencies such as the Federal Trade Commission, the Consumer Product Safety Commission, and the Equal Employment Opportunity Commission, today, when minority commissioners dissent, they are fired. It is vividly illustrative that even when this administration holds so much power, it cannot tolerate disagreement or dissent. As a commissioner, I feel it is my responsibility to respond to these attacks on the First Amendment. I refuse to stay quiet while the government chips away at fundamental rights by weaponizing our regulatory authority. This is how I'm using my voice. I encourage you to use yours too. And if I'm removed from my seat on the commission, let it be said plainly. It wasn't because I failed to do my job, it's because I insisted on doing it. Thank you.
Thank you so much, and thank you for doing your job. It really is, it's a testament to the principle that you bring to the office, that you're willing to stand up for the First Amendment, and as indeed that you found agreement across the political spectrum, which is really what we're going to talk about today. We're going to play a clip after you from Commissioner Mike O'Reilly, who sounded many of these same concerns back in 2020. And indeed, as you said, he was essentially fired for that. His term had expired. He was not renominated. His pending renomination was revoked because the administration even then was unwilling to tolerate any kind of dissent from their agenda, even when it was stating longstanding conservative principles. So my question for you is, so given all this, what is to be done? What can ordinary people do?
So first of all, again, thank you for inviting me to be here. You and I have known each other for a long time, and we don't always agree on everything, but it's always nice when we can. So I have embarked on this First Amendment tour, defensive First Amendment tour, in order to call out what I see as this alarming campaign by this administration to control and censor. And I'm doing it because I think it's important that we raise awareness, because it is very much a threat to our democracy if we allow this to continue. But also because, as Dina likes to say, freedom isn't free. People die for our country and for our values. So it is important to have the courage to speak up and speak out when we see this trampling of the First Amendment protections. So I want people to be informed, and I want to encourage people to speak out, because if we simply become compliant, that also begets compliance. Instead, I hope courage begets courage.
Well, there isn't much of that in Washington these days, and in part it's because there aren't enough people like you speaking out. So thank you for doing it. You noted that the commission may change. The president may fire you. Legally, the reason I think that hasn't happened yet is the commission needs 3 votes just to function, to have a quorum. And right now they're sitting at 4. Your fellow Democrat has said he's going to resign. in the spring, and the third Republican is just awaiting her final confirmation vote. So we could very soon be in a situation where there are 3 Republican votes on the commission. At that point, I don't expect that the administration would be willing to tolerate having any dissent on the commission. What do you think is lost? We talked about this yesterday. Just setting aside the legal question of whether the president has the right to fire commissioners, what do you think is lost from the commission when there aren't a diversity of voices and a back and forth?
Yeah, your question is exactly the right question. Why do we have more than one administrator of the Federal Communications Commission? The reason we have more than one is because a diversity of experiences, voices, even political ideologies is important to making good policy. When we surround ourselves with yes people, it actually leads to poorer outcomes. And that is what the fear is here, right? We have an administration that has decided that there is no such thing as an independent agency, and that anyone can be fired if they don't support and think exactly the same way as they're being told to think. Well, at that point, there's really no point in having multiple commissioners, is there? Because we won't have this strength that comes from having a diversity of experiences and of ideologies.
Well, I want to take questions from the audience, but I want to ask you one more question while people are thinking about their questions. For years, Republicans, free market organizations, groups like Tech Freedom, have encouraged the courts to overrule the Chevron doctrine, or at least rule that it doesn't apply in questions that involve vast economic and political significance. That's what the court did in the Loper-Bright case. It essentially said that agencies will not get broad deference in their interpretations of ambiguous statutes, and instead that the agency's interpretation will be judged in part on the quality of its reasoning and how well it's considered all the facts in the record. Mm-hmm. It seems ironic.
It did say that we would get respect.
Indeed. So skid more deference is the term, and the degree of respect would depend on how well the agency had done its job. Mm-hmm. It seems ironic now that even as the agency, Republicans have essentially won this prize, they're the dog that's caught the car, they seem to be undermining themselves. It would seem to me that you'd be in a better position as an agency, having had both sides hash out an issue, having had a minority voice, a dissent, having had to improve the reasoning in an order to explain the commission's position. It would seem to me that you'd literally be better off in court, even if you're taking a hardline conservative position, having had someone there to disagree with you and being able to say to the court, well, we considered those arguments and we've already addressed them. And so now they're going to walk into court without the benefit of that reasoning. Aren't they shooting themselves in the foot?
You know, it really is a shame when we lost Chevron deference for a lot of reasons, not the least of which for everything that you just raised. But you're absolutely right. And what's really interesting is this commission so far is actually taking most of its actions through enforcement and not through rulemaking. Why is it doing so? Because you cannot appeal a threat. You can't appeal a letter that accuses you of bad acts. You can't appeal a letter that tells you to stop content moderation or using a particular tool for fact checking. None of that is appealable. All of that is meant to chill speech and to control behavior without any consequences in the legal in legal consequences. But there will come a time when, in fact, the FCC will act. Section 230 is a good example. Whether it's an interpretation or a rulemaking, I've heard both are possible. I don't see how that survives either Loper or major questions.
Yeah, we're going to talk about this today in some detail, but for those that are just watching this, Section 230 is the law that's made the internet possible. It really created today's interactive internet, as opposed to services like Netflix that just serve you content that they want to show you. It makes it possible for websites to host content generated by users by preventing the American legal system from being weaponized against that content. In 2020, the Trump administration proposed to reinterpret Section 230 to make it very easy to sue websites when they moderate content or to sue them for hosting content if they moderate content in ways that someone thinks are unfair politically or biased or whatever. So that's the rule that's about to drop now. It's very plain what they're trying to do. They're trying to favor some kinds of content moderation, that is content moderation to protect kids, for example. That's in the statute. That would be favored, but what would be disfavored would be all the other things that people remove today, hateful speech, misinformation, and we're not just talking about small lies or who won the last election. We're talking about removing neo-Nazi speech, speech that's perfectly lawful, that today websites just don't want to host, responsible websites, but under this version of Section 230, they would be coerced into doing that by the threat of litigation. So what's really at stake here? What do you say to ordinary people who may think that Section 230 is some kind of favor to big tech companies?
Yeah, you said that very well. One of the things and just one thing to point out is that the analysis under the first Trump administration on Section 230 relied heavily on Chevron and lack of competition amongst providers, which I think both have been debunked by now.
With TikTok emerging out of nowhere, for example, or X. Yeah.
Blue Sky, Mastodon, I forget, Threads. So yes. I think what's really important to understand about well, there's several things that are important to understand about Section 230. The first is that it's actually based in the First Amendment, right? It is meant to prevent having private companies exposed to debilitating lawsuits. But these private companies have a First Amendment right to have a product and to moderate that product in any way they want. They can themselves become a neo-Nazi website, and they are protected in that right. They can also become a whatever far-left website it would be, and they would be protected. They could also be the grandma's knitting circle that has decided to have an online chat to talk about the right kinds of yarn to use in their products. And that is their right. And they may say, much like Pinterest, this is all we want to talk about, and we will take down any content that criticizes the president, for example. And that is their right. It is their First Amendment right to do so, and the Supreme Court has said so. So just from a broad perspective, from a freedom of speech perspective, this is what I worry about, is being told that you cannot take down content, in other words, that you have to host speech, is itself as much of a violation if the government tells somebody also that they cannot speak.
On that point, I wanted to just quote before we go to the audience. There's a great line from 1960 FCC order where they said that hosting content. Let me find this. Essentially, it says that interfering in speech markets in the name of encouraging speech is no different from censoring speech directly. It doesn't matter if you can frame the justification as being pro-speech, which is what the administration claims to be doing online. Yes. It's still government interference in the media. As you noted, the Supreme Court said last year that the First Amendment applies equally to the internet. It protects the right of websites not to host speech if they don't want to host that speech. And as you know, without Section 230, that right is effectively meaningless because you'd have to litigate that in every case. And if you host billions of pieces of content, and everyone can sue you very easily, your First Amendment right would be essentially meaningless if you didn't have Section 230 to vindicate it. It's not like tort reform, something Republicans used to be for.
Yes.
Well,
that's a good point. But I was going to say, most recently the Supreme Court also said, it is not government's job to balance the marketplace of ideas. Which is similar to what you heard in 1960. Yes.
The court's been saying that for decades.
But I do worry, by the way, yes, that it's, yes, we don't want the large companies subjected to well, I don't care, but the large companies can defend themselves when they get subjected to these types of lawsuits. It's the smaller, nascent providers that would be the ones that suffer. And that's why we had Section 230 to begin with, right? Is Congress said, wait a minute, there's something here that is off balance, and we want to make sure that we can promote these types of online platforms. So it is what it is.
Well, indeed, the law applies equally to all providers and users of interactive computer services. President Trump himself has invoked Section 230 when he was sued for retweeting someone else's content. So it's ironic that they're now trying to unravel the law. We have a lot of expert telecom lawyers from a range of perspectives in the audience, really across the political spectrum. I wonder if anyone has a question for Commissioner Gomez. And if you'd like to ask a question, you need to come up to the mic so the audience can hear your question. So Harold Feld here from Public Knowledge is going to ask, I'm sure, a great question. And he'll be on our panel about broadcast licensees later today. If you come over here.
Which one?
Over here.
This one? Okay.
Thank you. So, first of all, oh, sorry, I need to be on camera. Okay.
Yes, you do.
So, first of all, thank you very much, Commissioner Gomez, for everything that you're doing, for being willing to stand out there. And I agree with Barron. I think that unfortunately, once Olivia Trustee, who is a perfectly fine nominee, and this has nothing to do with her, but once she is on, we all have a sense of what's likely to happen. I have a question, actually, and Barron will cringe when I say this, about net neutrality, and specifically that one of the things some of us argued about in terms of why we needed net neutrality protections was our concern about political manipulation, that it would be tempting for people in office to lean on the broadband providers and say, hey, how about just a little bit of messing with folks when they try to give contributions to the other side, just let the connection hang just a little. Not anything big and obvious, but stuff that just makes it harder for folks on the other side to campaign. This is something the FCC at its roots goes back to with the regulation of radio. You read the legislative history, there was a lot of concern about, will the ability to influence licensing, create government control of radio. After the Sixth Circuit's opinion, is there anything that can be done if this turns out to be the case, or should we just expect that there's going to be pressure on ISPs to put a thumb on the scale when it comes to these political websites?
Yeah, I'm glad you asked that question. First of all, you just reminded me why I hate the term net neutrality so much, because, and part of the reason, and forgive me for this, and this is why I prefer open internet, but even that is worrisome, is because we were accused of trying to control the internet when we were proposing to have guardrails on the conduits to the internet, which is what you're talking about. We wanted to make sure that consumers were protected and that they have the guardrails around the services so that they benefit from the service in a pro-competitive manner. But instead we were accused of controlling the internet. Now this administration is trying to control the internet. When you talk about controlling the internet, you're talking about controlling access to the content of the internet. And that is exactly what we're talking about here with Section 230. And the fear that you raise is a good fear, because we are seeing this administration pull every lever that it can in order to silence and to control information. Unfortunately, we've seen many ways that we have lost in losing the open internet protections that we adopted. This is yet another, and hopefully by calling it out, the companies will think twice.
Well, the Sixth Circuit decision that Harold referred to was a federal court of appeals finally saying under Loper-Bright that the FCC's interpretation of its Title II authority went too far, that it did not comport with the statute, that it could not regulate broadband providers as common carriers, which seems to be really the end of the FCC's ability to impose net neutrality rules on the basis of Title II. But it leads me to a question I wanted to ask you. Harold and I... Well, Harold notes that maybe it'll go up to the Supreme Court.
Yes.
I don't think that's going to go very far, but you could try, Harold. Go for it.
Hey, hope springs eternal.
Sure. Good luck, Harold. But to me, this has always been a kind of a fool's errand, right? Because when this question got litigated at the D.C. Circuit after the 2015 order, which reclassified broadband as a Title II service for net neutrality rules, the First Amendment question was raised. And the judges that wrote the opinion upholding the FCC's order dismissed First Amendment arguments and said there is no First Amendment problem here because the FCC's reclassification of broadband as a Title II service only applies insofar as those services hold themselves out as offering an uncurated service connectivity to all internet endpoints. And if they wanted to meddle in online speech, and if they did so clearly, well, they wouldn't be a broadband internet access service, they'd be some other form of internet access, and they wouldn't be subject to Title II. Now, where that line was drawn was not clear, but there was a back and forth between those judges and then Judge Kavanaugh, who insisted that the First Amendment would apply. But so we don't know exactly how that would have played out because it got short-circuited, but it suggests that in the scenario that Harold posits, where broadband companies may be under pressure, if they really did start meddling with online content, if they did so clearly in the way that, for example, X is at least somewhat clearly meddling with online content today, that they would never have been covered by the net neutrality rules to begin with. So if that's true, well, what was the point? What was that all about?
Well, I mean, let me just say also, though, that even that analysis was counteracted by the court's, the Sixth Circuit decision. Not directly, I understand, because it wasn't on the First Amendment necessarily, but it certainly was on what the nature of broadband internet access service is that makes it not a Title II service. So I don't know the answer to that. For me, fundamentally, I think that consumers lost when they lost their open internet protections. And they did so simply because we went from analog to IP.
Well,
it makes no sense.
One other point about Title II, it's amazing that Republicans have spent all these years arguing that broadband services shouldn't be common carriers, when broadband services themselves always held themselves out as offering connectivity to all endpoints, as offering an uncurated service, which again, the court said could be subject to Title II. And now the exact same people at the FCC and their allies are now arguing that the services that have always said they offer a curated experience, the online social media, that those are the real common carriers and that they're biased and they should be subject to common carrier regulation, but not the broadband companies. It doesn't make any sense at all. I simply cannot get my mind around it. How do you fathom that level of inconsistency?
Well, it's the ends justifying the means, right? They're trying to control and censor content, and that is how they are going about it. And this is administration-wide. Again, this is not just the FCC. We are seeing the Federal Trade Commission going after any parties that want to
exercise their First Amendment rights?
Exercise their First Amendment rights. We've seen the White House talk about this. They call it the censorship cartel, which is ironic given that it's neither. I like, Linda Richmond from Saturday Night Live. Censorship cartel, it's neither censorship nor a cartel. Discuss amongst yourselves. Censorship requires government to impose regulations or regulatory actions in order to halt speech or to promote other types of speech. That's censorship. And it's ironic, but what I'm saying is it doesn't matter if there's intellectual inconsistency. It's discordant, but it gets to the end result that this administration wants, which is to censor and to control.
Any other questions from the audience? Jess from CEI.
Hi, thank you for being here today. I really enjoyed your remarks. You talked a little bit about the current FCC not, passing new rules but kind of acting outside those official actions, right, with letters that are intimidating and public remarks, things said in speeches. And we talked a lot yesterday about job owning at other agencies, and it seems like that's par for the course now at the FCC as well. And at CEI, in our work, we talk a lot about something we've named regulatory dark matter. Mm-hmm. And that's things that, no one votes on, no commission approves, but yet they're happening and they shape people's behavior in a way that seems to us to be pretty politically unaccountable. And I just wondered whether it's from this administration on the right now that we're talking about, but for any future administration of any political stripe, can you talk about what your thoughts are on that kind of unofficial pressure that agencies can push, and how you might, especially in light of recent events, think about ways to rein that in or make that a more transparent process? Thank you.
Yeah, there absolutely is a chilling effect when you have this job owning. But this is not, I really want to be clear about this, because I get a lot, well, the Biden administration and COVID and masks, I don't remember. So you're a hypocrite that you're raising these concerns. Those are false equivalencies. Even the Supreme Court, or the court, has found that government agencies can, in fact, express opinions, for example, to save lives, by encouraging companies not to spread anti-vaccine hoaxes. But we have a regulatory agency here that is wielding its regulatory licensing power. It is threatening companies in order to get them to either change their news practices, their news reporting, or change their diversity and equity and inclusion practices. And let's be clear, diversity, equity, and inclusion involves First Amendment speech. It involves freedom of association. It is not in and of itself illegal. It is not anti-civil rights. Everything is in how you implement, obviously. But my point is, you have a regulatory agency that is saying, we will not grant transactions that corporate parents desperately want unless you kowtow to us. That's not a raised eyebrow. That is chilling and immediately a violation of the First Amendment, and it's dangerous.
Well, I think you really put your finger on the problem earlier. If the agency can make these threats, and these threats don't get litigated because companies just give way, where are we? How does the rule of law survive here without the courts to hold the agency to account if no one else can sue?
Yeah, I like to say capitulation begets capitulation. And we see that. We saw that with the law firms that initially just caved immediately to administration pressure in order to not represent parties that the administration doesn't like, or to punish particular partners who had, I don't know, served on Jack Smith's team. Once you saw that immediate caving, then a lot of law firms followed suit. And then a few law firms actually had the courage to say, wait a minute, this is a violation of our rights. This is a violation of our ethical obligations to our clients. So we're going to stand up. Courage begets courage. And that is what we need from these companies, even though their shareholders may want something different. And I think and I hope that it's not just the corporate executive offices, but the corporate boards that stand up and realize that this is history we're talking about. History will not judge well those that capitulate and harm our First Amendment, and in doing so, our democracy.
Any final questions for the commissioner? Jim Dunstan, my colleague here at Tech Freedom, veteran telecom lawyer.
Thanks. And Commissioner Gomez, thank you so much for being here. Obviously, it's going to take decades for us to figure out what Skidmore deference is going to look like. It took us decades to find out what Chevron deference looked like. But my question is, let's hypothetically say that we end up with a commission that has 3 of one party. I think we're going to see a Skidmore step 0 in which the court's going to ask, is this the expert agency? And my question is, without any dissenting views on things other than technical, spectrum and things like that, could there be a legitimate challenge that the FCC really on sort of basic policy questions, take your pick, net neutrality all the way up to, Section 230, is no longer an expert agency simply because it doesn't have the diverse views that's left? Do you kind of foresee that as a possibility?
Absolutely. Realize, the Communications Act doesn't just require 3 commissioners for a quorum. It requires that there be 1 member of a minority party. And that in and of itself could weaken whatever defense that a future FCC may have if there is no such single minority party member.
Well, you spoke about history. Timothy Snyder, the historian of authoritarianism, in his book on tyranny, writes, most of the power of authoritarianism is freely given. In times like these, individuals think ahead about what a more repressive government will want, and then offer themselves without being asked. A citizen who adapts in this way is teaching power what it can do. I mean, this is the flip side of courage begets courage. This is appeasement, not just begetting appeasement, but enabling authoritarians to coerce. How do we deal with this problem, given the stakes?
Again, everyone needs to speak up. We need to be very clear about what is the danger here. It is our democracy that's at issue. One of the things that we've also seen from this administration is even appeasement doesn't benefit those that have sought the appeasement. They still end up getting targeted because there is always more control to be had there. So unless you are absolutely standing in line and doing exactly what this administration wants, you are going to be the target no matter what you do. Much like any bully, though, if you push back, that bully will stop. And that is what we need, is we need pushback to that bullying in order to protect our democracy.
Well, Commissioner Gomez, thank you so much for coming here to speak to us today. We look forward to including you in more of these programming, whatever happens in the future. And I would just say in closing that we're having here today at Tech Freedom and CEI at our summit, we're having leading Republicans from past administrations, people who really were involved in the Reagan administration's efforts to end government meddling in media, speak here today. These are concerns that Republicans and conservatives and libertarians used to have, and now we feel like the people who are carrying the banner supposedly of freedom just don't care anymore. And it's very sad to us to see that that really keeping the government out of media has suddenly become a partisan issue. So again, thank you, and please join me in thanking Commissioner Gomez for coming today.
Thank you.
Fowler and Dennis Patrick, and a former director of the National Association of Broadcasters. So Jerry's here to talk to us about the Fairness Doctrine, why the Reagan administration ended its enforcement, and the history of the idea and its long-term implications. We're going to have a panel discussion with my colleague Jim Dunstan and Paul Matzko, who is a historian of the radio right and the experience of the Fairness Doctrine and how its repeal made possible today's vibrant media ecosystem. But before we do that, I just wanted to set the stage for this conversation about the Fairness Doctrine by explaining to people why it still matters and why it looms so large in the conservative imagination. And no one put that better than Commissioner Mike O'Reilly. I mentioned this in our discussion with Commissioner Gomez in our last fireside chat, but I want to play this clip from Mike O'Reilly from 2020. So this is during the COVID pandemic. So at the Media Institute, they had their annual communications forum virtually, and they had Commissioner O'Reilly speak, and he was talking in general about conservative approaches to regulating media. And here's what he had to say about the analogy.
Hi, my name is Eric Goldman, and I'm a professor.
It says 2111, I think.
For my last moments, I want to discuss one of the primary missions of the Media Institute, the exercise and defense of First Amendment rights, specifically freedom of speech. Many of you have heard my past passionate criticism in speeches or statements of instances in which the First Amendment was being violated or was at risk of being undermined. Naysayers have, of course, attacked me over the years, often in bad faith and without directly engaging my arguments. That's par for the course for those of us in public life who seek to protect one of the core tenets of American democracy and society. Today, I'd like to address a particularly ominous development in this space. To be clear, the following critique is not in any way directed towards President Trump or those in the White House who are fully within their rights to call for the review of any federal statute's application, the result of which would be subject to applicable statutory and constitutional guardrails. Rather, I am very troubled by certain opportunists elsewhere who claim to be First Amendment's biggest heroes, but only come to its defense when it's convenient and constantly shift its meaning to fit their current political objectives. The inconsistencies and contradictions presented by such false prophets would make James Madison's head spin were he alive to witness them. The First Amendment protects us from limits on speech imposed by government, not private actors, and we should reject demands in the name of the First Amendment for private actors to curate or publish speech in a certain way. Like it or not, the First Amendment's protections apply to corporate entities, especially when they engage in editorial decision-making. I shudder to think of the day in which the Fairness Doctrine could be reincarnated for the internet, especially at the ironic behest of the so-called free speech defenders. It is time to stop allowing purveyors of First Amendment gibberish to claim that they support more speech where their actions make clear that they would actually curtail it through government action. These individuals demean and denigrate the values of our Constitution and must be held accountable for their doublespeak and dishonesty. This institution and its members have long
2 days after the administration proposed to reinterpret Section 230 and asked the FCC to issue a rule rewriting the statute to essentially break content moderation they didn't like. He compared it to the Fairness Doctrine, and for that, as I mentioned in our chat with Commissioner Gomez, his pending renomination for his seat at the FCC, which he had then held for 7 years as a stalwart conservative, his nomination was revoked, and he was replaced by one of the authors of that petition to the FCC to reinterpret Section 230. So he was talking about the Fairness Doctrine and shuddered to think of a day when the Fairness Doctrine could be reincarnated for the internet, especially at the behest of so-called free speech defenders. So what was the Fairness Doctrine, and why were conservatives so against it for so long? There's no one better to explain that than Jerry Fritz, who really led the effort to unravel the Fairness Doctrine in the 1980s. Jerry, why did you do that, and what was the problem with the Fairness Doctrine?
Well, first of all, thank you for having me here. Reliving the Fairness Doctrine is something that I try not to do very much, but keeps raising its head, and you want to get that wooden stake and sort of knock it through its heart, but it keeps coming back. The Fairness Doctrine sort of dates back to actually 1949, back in the editorializing report, that for the first time permitted editorializing by broadcast stations. It overruled a previous case called the Mayflower case, but it enforced fairness. So fast forward 18 years, you get to 1967. The Fairness Doctrine was finally incorporated in the FCC regulations by a Republican chair, Rosal Hyde. This is the first Rosal Hyde Commission, as opposed to the second one after Newton Minow left and Bill Henry left, and President Johnson re-elevated a Republican to become the chair of the FCC. And ask yourself what the first decision of the new Rosal Hyde Commission was. It was a multiple ownership waiver. Anybody care to guess the market? This was Austin, Texas, the famous Seeing Eye Blind Trust of Lyndon Johnson. But that was Rosal Hyde. Rosal Hyde incorporated the Fairness Doctrine in FCC regs, and 2 years later, Red Lion was decided by the Supreme Court, sort of institutionalizing the Fairness Doctrine, but importantly, the Fairness Doctrine decision by the Supreme Court in Red Lion had an out, and the out was that they invited a reconsideration of the effect of reducing volume and quantity of opposing viewpoints. If the commission or if anybody could prove that, then they might reconsider the constitutionality of the Fairness Doctrine. So 4 years later, Dick Wiley was chair of the FCC, and he told me recently there were 2,500 Fairness Doctrine complaints filed at the FCC. The commission had 109 rulings. So I asked myself at the time, what happened to the other 2391, right? Somebody had to spend a lot of money on lawyers to defend themselves at the FCC for these 2,500 complaints. It's what Glenn Robinson, a former commissioner at the FCC, called interim control. That's a new form of jawboning. So it's a new form of control. So for 8 years later, we're sitting in, actually 8 years to this is May 16th, right? So May 16th, 1981, we're in my living room at my house. Mark Fowler had been nominated to the FCC, and he was getting his staff together, and we had a meeting at my house, and we were coming up with the principles of how he was going to regulate or how he was going to run the FCC. And he came up with 5 what we call MBOs, management by objectives. And it was unregulated competitive environment, marketplace, elimination of unnecessary regulations, efficient and expeditious service to the public, and promoting international communications for the United States. But then Mark insisted, I mean, I see him clearly in my mind, insisting that we have a fifth objective, a fifth principle, and that was that everything had to be viewed through the prism of the First Amendment. He was so stalwart in requiring that we would eliminate any actions infringing on the First Amendment. So his very first directive as chair of the FCC was to accept the Supreme Court's invitation to open a proceeding on the practical impact of the Fairness Doctrine, and to show that it actually had the effect of lessening voices and rather than enhancing debate. The next year, in 1982, Meredith Corporation had a television station in Syracuse, WTVH, and they ran a nuclear power plant paid commercial advertisement. The Syracuse Peace Council didn't like it, and they filed a complaint at the FCC under the Fairness Doctrine. So a couple of years later, the commission had gone through, the Broadcast Bureau had gone through its machinations, and lo and behold, it was a violation of the Fairness Doctrine. So it came to the commission found this violation, but the very next year, because remember Fowler had started this proceeding, the commission comes up with the 1985 Fairness Report. And it talked about the chilling effect of the Fairness Doctrine, but because politics being what they were, it deferred to Congress and the courts to actually get rid of the Fairness Doctrine. But it had it accepted the Supreme Court's invitation to demonstrate this, but it was up to Congress and the courts to get rid of the Fairness Doctrine. 2 years later, the D.C. Court of Appeals, Judge Silberman, essentially raked the commission over the coals. It had unloaded on the commission in the Meredith case for enforcing a policy that it didn't believe in. And it remanded the case back to the FCC to consider these constitutional issues of First Amendment. The politics being what it was, 2 months later, the Congress stepped in to codify the Fairness Doctrine into law, and with our everlasting appreciation, President Reagan, in one of the few times of his 2 terms, vetoed that bill. So we were in good shape in that veto. So I guess it was 38 years ago, Fowler announced his resignation. Mark Fowler has been the chairman of the FCC, the longest chairman in the history of the FCC. To this day, served longer than any other chairman, and he was tired, and he announced his resignation. President Reagan announced that Dennis Patrick was going to take over, and I went to Mark Fowler and I said, Mark, we've teed up the Fairness Doctrine. Do you want to get rid of it on your last meeting as chair, or do you want to give it to Dennis in his first meeting? And Mark said, I don't care. He was tired. He had 1 foot out the door. So I went to Dennis and I said, Dennis, you want to off the Fairness Doctrine? He said, yeah, let's off the Fairness Doctrine. So his very first meeting, he offs the Fairness Doctrine, and then all hell broke loose. John Dingell, was running the Commerce Committee in the House, called him a lickspittle, and Fritz Hollings refused to have a hearing on the 2 Republican vacancies at the FCC. By this time, the commission had reduced in size from 7 commissioners to 5 commissioners, and it left Dennis with a majority Democratic commission. He had Jimmy Quello, Bob Gordon Revera's boss, Jimmy Quello, and Patricia Diaz-Dennis, 2 Democrats, and Dennis as the lone Republican. The Congress attempted to revive the Fairness Doctrine in 1991. President H.W. Bush threatened a veto, and it never saw the light of day. And in 2011, Chairman Janikowski, a Democrat, finally removed it from the FCC regs, and so it was gone. What were the results of that? The results of that were Rachel Maddow and Rush Limbaugh and Al Franken and Sean Hannity and Laura Ingraham, Michael Savage, Bill O'Reilly, and Dennis Patrick with a 2-to-1 Democratic majority. That was the effect of eliminating the FCC. And multiple attempts by Congress and other administrations in the ensuing years to bring it back. But the sword of Damocles still hangs over the head of broadcasters, and we'll talk a little bit more about that. But that's sort of the Fairness Doctrine in a nutshell.
And can you just explain what exactly did the Fairness Doctrine require?
2 things. It required you to air controversial issues of public importance, and when you did that, you had to give the other side. That's the sort of two prongs of the Fairness Doctrine.
Well, I'm going to read you words that you'll remember because you probably wrote them. 1985, the FCC's report on the perverse results of the Fairness Doctrine found that second prong is itself a government regulation that inexorably favors orthodox viewpoints. And the Fairness Doctrine in operation, even though it had intended to increase the diversity of media and include all viewpoints, in operation, it inexorably involved the Commission in the dangerous task of evaluating the merits of particular viewpoints. and that it allowed people to claim that some controversial viewpoints were being screened out in favor of the dreary blandness of a more unacceptable opinion. It was often the licenses of broadcasters who aired opinions in which many in society found to be abhorrent or extreme. Their licenses were placed in jeopardy due to allegations of fairness doctrine violations.
Well, and in many cases, it was the hard right Republicans that were in favor of the fairness doctrine because they wanted to use it to punish the Democrats. We had a big contingent of Republicans. Phyllis Schlafly was one, and several others who were advising President Reagan that we wanted to keep the fairness doctrine. So it was a Sisyphean task to push that rock up the hill.
Well, let's talk about the politics, but just you talked about President Reagan's veto of the congressional effort to reinstate the fairness doctrine, and I love this line. I've quoted this so many times. He notes here that the doctrine had, as the FCC had said, in fact inhibited broadcasters from presenting controversial issues of public importance and thus defeated its own purpose, and that the obvious intent of the First Amendment was to promote vigorous public debate and a diversity of viewpoints in the public forum as a whole, and not in any particular medium, let alone in any particular journalistic outlet. History has shown, President Reagan said, that the dangers of an overly timid or biased press cannot be averted through bureaucratic regulation, but only through the freedom and competition that the First Amendment sought to guarantee. I mean, how can you beat that?
And it was funny. We talk about how much the administration has a control over regulatory agencies today. We were pilloried by briefing for Mark Fowler to go up to the White House in 2 instances to brief the president on outstanding FCC issues. One was on financial interest and syndication. We were pilloried. How dare this creature of Congress go up to the White House and advise the president on this pending matter? And the second one was the fairness doctrine, us talking to the president about the fairness doctrine. Fast forward to 2025, and you would think that the FCC and the other regulatory agencies are part of the White House staff.
Well, much has been made recently of justifying regulating broadcast content under the public interest standard. What do you think?
I think that the public interest, convenience, and necessity standard was one of the great power grabs of the 20th century. Herbert Hoover, when he was Secretary of Commerce in 1927, was a very, very smart guy, really smart guy. He chose licensing over private property. He locked in this metaphor of thinking about broadcast frequencies as airways, as something to own. And that was despite what the courts were doing at the time. There was a famous case in Chicago called the Oakleaf Broadcasting case, where the courts were in fact assigning private property rights to Spectrum based on a trespass theory. Left to their own devices, the courts would have assigned an intangible private property right to broadcasting. But Hoover was smart. Hoover said that he recognized that who controls the airwaves controls content, and it was a difference that he could exploit because he didn't have that control over newspapers. It's been used by multiple FCC chairs, notwithstanding what Commissioner Gomez said. It's been used by multiple FCC chairs to meet the cause of the day. I just made a list of myself here. Chairman Fly, during World War II, limited the networks in chain broadcasting rules on the basis of the public interest. Newton Minow in the 1960s gave the perfect example of jawboning when he gave his famous vast wasteland speech. And of course, the Kennedy administration was renowned for using the fairness doctrine to harass right-wing broadcasters. Dean Birch in the 1970s had topless radio. Dick Wiley in the 1970s had family viewing hour. Reed Hunt impose kidvid rules, right? That was based on the public interest. Michael Powell in the 2000s, in the famous Janet Jackson nanosecond of a Super Bowl reveal, used the public interest standard to fine the networks, what was it, $325,000? $550,000. It was $325,000 was an NYPD Blue, but the same issue. But it was public interest standard on indecency, and of course here we are in 2025 with Chairman Carr on news bias. So the public interest standard has been the bugaboo of broadcasting, but it dates back to this fundamental decision by Hoover back in 1927 to say we're going to do licensing, we're not going to have private property rights.
Well, you've noted that this is an issue of power, not of law. What do you mean?
So Chairman Carr is among the smartest lawyers I know. He really knows his stuff. I agree wholeheartedly with him, and I made a list of some of the things he said. I agree with him when he says the following: second-guessing broadcasters is a chilling transgression of free speech rights that every media outlet in this country enjoys. He was right. He also said a newsroom's decision about what stories to cover and how to frame them should be beyond the reach of any government official not targeted by them. I agree with that, right? He rejected efforts to, quote, inject partisan politics into our licensing process, correctly calling it a deeply troubling transgression of free speech. He went on to say, if there were ever a time for a federal agency to show restraint when it comes to the regulation of political speech and to ensure that it is operating within the statutorily defined bounds of its authority, now would be that time. The FCC, he said, should not operate as the nation's speech police. Look, everybody in this room knows that Chairman Carr clearly gets the constitutional issues. This is not a difficult thing to understand here. He gets it. I suspect that he knows that public interest is not a free pass to bypass the First Amendment. Not a free pass to bypass. But that's really not what this is all about. What this is all about is just another, and I've been thinking about this is my 57th year in the business, right? I've become much more philosophical about this. And I would tell you that this is just another manifestation of the battle between power and principle. And I talked about Colonel Revere before. It's principle and it's the process of restraint. So it's power versus restraint. Just another manifestation. This has been going on for a long, long time. The public interest licensing concept provides this umbrella facade, if you will, to the exercise of power. That's what this is all about. It's just more about the exercise of power. Candidly, that's what government does. It uses its power for its own ends. Eventually, that's going to get curtailed by the courts. It's going to be a lot of brief writing in courts, and it's going to go up to the Supreme Court, and it's going to have lots of different manifestations, and maybe it finally survives until we get the next iteration of the government for it to go away. It's going to go away. The broadcasting industry is going to win these constitutional battles. I don't think there's any question about that. In the meantime, it's the exercise of power. And he gets to exercise the power because his boss won the election. That's the bottom line here. I suspect that's exactly where this ends. Make no mistake, I've seen this play before many, many times. It will be back. Until then, anyone can hang the sword of Damocles over the broadcasters, and that's exactly what's going on here.
Well, indeed, on that note, I'll welcome up our fellow panelists, Jim Dunstan and Paul Matzko. And while they're joining us, I'll just quote Glenn Robinson, who taught me telecom law at the University of Virginia. He described the regulation by the lifted eyebrow as the sword of Damocles, as you mentioned. And he said, if the sword does not often fall, neither is it ever lifted. And the in terrorem effect of the sword's presence enables the commission to exercise far-reaching powers of control over the licensee's operations.
The power of the sword of Damocles is not that it falls, but that it hangs.
Precisely. Well, that's exactly what we're seeing today. So, Jim, we have been And Bob Korn-Revere is also joining us. Forgive me. Bob Korn-Revere, also a leading practitioner of telecom law and free speech law, and indeed wrote the paper that I was just quoting from.
And
as
one
you
of the
heard yesterday.
stalwarts at the FCC as advisor to Commissioner Coelho during the Fairness Doctrine debates in the 1980s.
Well, Jim, I have to go to you first, not just because you're my colleague and I've known you now for 20 years, but because you were there at the origin of all of this. Tell us your personal connection to this story and what you took away from your experience.
Yeah, Commissioner Gomez talked about courage begetting courage, and I think the Meredith WTVH case really exemplifies what happened and, frankly, what has to happen again. And Jerry sort of laid out, the case. It was a nuclear advertising that was taken by Meredith station WTVH in Syracuse. It was after the 9 Mile 2 plant had been approved by the New York State Commission, and it essentially was a sort of a jobs. It was a recruiting ad by the power plant. And the Syracuse Peace Council said, well, we want to say no to it. And Meredith said, well, no, this has already been decided. It's been approved. It's going forward. And it's not it's not a controversial statement. So you talked a little bit about how the case went. I came into it on a Friday afternoon. Mike Bader walked into my office and said, you took constitutional law, didn't you? And I said, yeah, I took it from Tom Krattenmaker at Georgetown. He said, well, Meredith has just approved us to go after the Fairness Doctrine on constitutional grounds. I said, well, great. And when's this due? He says, well, it's due Tuesday. And so, good luck on the weekend. And this was, you have to understand, this was a reply to an opposition to a supplement to an application for review. So literally, it was the 11th hour, 57th minute, the last possible chance to take a shot at it. And so I drafted the constitutional argument, and I drafted it as a unconstitutional as applied argument, with the argument being, having seen what happened, the conclusion was you would never know a Fairness Doctrine violation until you were told it was a Fairness Doctrine violation. It literally can only be seen in the rearview mirror because it doesn't become a controversial issue until somebody complains about it. And therefore, it's just got to be unconstitutional because nobody can possibly do it. And so, I got to draft it, and obviously, it went up. I was a second-year associate at that point, and it went up and got changed a lot, and ultimately, Floyd Abrams got to argue the case. But the one thing that went into that was very interesting because one of my partners was a Korean War vet, Dick Reel. He still limped, from the shrapnel he still had in his leg, which, under the GI Bill, he went to law school. And we were, talking about, well, how can we sort of force the commission at this very late date to take this up? And he said, well, don't underestimate, the obligations of a commissioner and their oath of office. This is coming from a Marine, who almost died in Korea. And so we talked about it and we said, wow, that's great. And at the time, my office was right next to former FCC Commissioner Ken Cox. And Ken Cox loved the Fairness Doctrine. He was a Democrat, and he really he didn't want us to take the case. By the way, NAB didn't want us to take the case because it was a nuclear case, and so they said you could never win a nuclear case. And so I walked into Ken's office, and I sort of ran this oath of office by him, and he said, oh my God, you've just taken down the Fairness Doctrine. And sure enough, when Dennis Patrick announced it, his quote was, I have to obey my oath of office, which means I have to take this constitutional issue up, which is exactly what the court told him to do. And Jerry, you're referring to, the court just lambasted the commission for saying, how are you defending, something? And so that's how I kind of got into it. And again, this courage begets courage. I mean, it was all because Bill McReynolds, the head of Meredith Broadcasting, said, screw it, because they'd let Meredith off the hook, right? They didn't fine him. They didn't give him a short-term renewal. They said everything's fine. But Bill said, no, this is wrong. I'm going to go after it. And
but the politics behind that when Jack Smith, who was the general counsel of the FCC at the time, was arguing the case in the Court of Appeals, we told him, Jack, do a good job, but remember, we want to lose this case. we're being set up here. Go ahead and take your licks. Thank you, sir. May I have another? Take your licks here, because we don't want this to survive. We want to lose this case. So that was the politics.
Yeah. Well, and one of the exchanges was, it came up at oral argument where he was trying to explain the reason they were taking it. He goes, Your Honor, this isn't exactly textbook law here. And the court did not treat that response very kindly.
No. And look, and it was all about the politics of the day. We can be all good lawyers and whatnot, but when you're sitting as the chief of staff of the FCC, you're thinking about the practical politics. And you have the Democrats that had the House and the Senate, and they were telling you, you're a creature of Congress, you are going to do what we tell you to do, or else we're going to cut your funding. At the same time, we knew the courts were on our side here. How do we orchestrate this strategically so that we ultimately win this case? And that was how we ended up.
Well, I think we've covered the origin story of the Fairness Doctrine ending, or rather, technically, its enforcement. The rule stayed on the books and was removed finally, years later, by a Democratic FCC chair in 2011. How did that happen? How did we go from Democrats trying to restore the Fairness Doctrine, having President Reagan veto that bill, to Democrats agreeing?
It was a mere formality. The commission had not and didn't have the power to enforce it anymore. Julius, as every single chairman who takes that job, Brendan Carr notwithstanding, has gone on this rampage to clean out unused regulations, and it was just part of Julius's effort to purge the commission of rules that weren't enforced anymore. So it was just a technicality.
But Democrats also said at that point that they insisted they weren't trying to bring the Fairness Doctrine back. This was a thing that had continued. It was in the Republican Party platform, election after election. Democrats, my perception was, but you tell me, all of you, my perception was Democrats they didn't want to be accused of trying to meddle in the media, and they wanted to put this issue to rest once and for all.
And look, they were as much a beneficiary of the lack of Fairness Doctrine as the Republicans. Sure, Republicans had Rush Limbaugh and Mike O'Reilly, but then the Democrats had Rachel Maddow as well. And so I sort of hearken back, and this was a quote that Mark or Dennis, I can't remember which one, they hearkened back to John Milton in the 14th century in Areopagitica, when we were talking about licensing of printing presses. He said, I'm paraphrasing here, but put truth and falsehood in a battle. Whoever knew truth put to the worst in a free and open encounter. And that was the to Julius's Janikowski's best legal mind. That was how he viewed the Fairness Doctrine. He didn't need it anymore.
Well, Paul, you wrote the book about this topic. What do you have to add here as a historian?
Well, I'm struck, same with distinguished lawyers. My historian's brain is going through the story not as a matter of political possibility or of what jurisprudential sense. It's how the cases got there, right? So like Red Lion, it's dirty pool, right? So Fred,
1969.
In 1969, which validates the Fairness Doctrine essentially. Fred Cook, who's the complaint. He was, unbeknownst to the court, they were hoodwinked, unbeknownst to the court, he was being paid by the Democratic National Committee. They were paying for his health insurance. They were sponsoring him to write anti-Goldwater books several years prior, to write an article called The Hate Clubs of the Air. They were feeding him intelligence about which radio stations were broadcasting, a right-wing broadcaster named Billy James Hargis, who was criticizing Cook because Cook had criticized him, a tit for tat. So the whole thing was a con job, right, being run secretly by Democratic operatives in the summer of 1964 to help Lyndon Johnson beat Barry Goldwater. So what was funny to me is that when the court makes its ruling, well, if you find evidence that this is having a chilling effect, the entire case was expressly intended to have a chilling effect on right-wing speech and pro-Goldwater speech during election season. So that's always interesting to me, is the extent to which the courts are reliant on fact finding, but if they get bad facts, they they do bad fact finding, they do bad rulings as a result. So it's that element that I think really interests me. Something Commissioner Gomez mentioned, and I really appreciated her comments about how we've had multiple presidents attempt to abuse FCC regulations, including the Fairness Doctrine. She mentioned FDR, she mentioned JFK, you could add Nixon, you could add first term Donald Trump. But what I was struck by was she said, well, the FCC stood strong, the FCC chairman stood strong. And the reality is that that's not the case. So in the time of FDR, one of the fellow FCC commissioners said that the president put the blowtorch on Larry Fly, and Fly complied. Fly was actually a very consistent civil libertarian, but he complied by using a kind of an early idea of a cross-media ownership ban to discourage the president's critics in the newspapers from being allowed to buy radio station licenses, in particular FM radio station licenses, for multiple years. In the JFK, he turns to Bill Henry, who's his newly appointed FCC chairman, and says, hey, Bill, quote, it is important that stations be kept fair. And of course, the implicit final clause there is to me, right? He's not interested in a general sense of fairness. And essentially this is because Kennedy allies in the labor movement, the Ruther brothers at United Auto Workers, had put together a memorandum several years earlier saying that your reelection is going to hinge on your ability to weaponize the Fairness Doctrine against right-wing radio critics.
Let me just put a little footnote here about Bill Henry. Bill Henry is the youngest chairman in the history of the FCC. Newton Minow stayed for long enough to give his vast wasteland speech and left, and they put Bill Henry in, who had been general counsel, and Kennedy put Bill Henry in. We called him Chairman Batman because he was shown at a Halloween party in Broadcasting Magazine wearing a Batman costume, and that was when Batman was on the air. So he stayed. Now this is I'll give you a little inside story here. When Lyndon Johnson was vice president, everybody told jokes about the sitting vice president, including Lyndon Johnson. Lyndon Johnson, big ear jokes, sort of like Dan Quayle potato jokes, right? Everybody told jokes about Lyndon Johnson. Bill Henry was overheard telling one of these jokes about Lyndon Johnson, and it was overheard by somebody on Johnson's staff. And lo and behold, as serendipity would have it, the next week, Kennedy was assassinated, and you'll recall that everybody flew back, Jack Valenti with Lyndon Johnson on Air Force One, and Johnson gathers everybody at the FCC, at the White House, and he said, everybody stays in place. The country's in a state of mourning. All of Kennedy's people stay in place. There will be no changes, except that son of a bitch at the FCC. He's gone. He fires. No, this is true. He fires Bill Henry. You talk about Trump firing Michael Riley. He fires Bill Henry and re-elevates a Republican, Rosal Hyde, who was chairman, had stepped down but stayed on the commission, re-elevates Rosal Hyde as chairman, and then of course he has the famous Seeing Eye Blind Trust decision right after that. So I just want to give you that little historical footnote to Bill Henry and it was not the first time a president used his power over an FCC commissioner.
And just to be clear, so the statute gives the president the right to designate the chair and to change that designation at any time.
Right.
Which could happen today if it were necessary. So what lasting principles, Bob, do you think that Republicans drew from these experiences about the role of the FCC?
It's hard to answer that question by keeping the word principles in the sentence. It seems like the one lasting lesson is that power prevails. Former Commissioner Lee Lovinger, who was a Democratic commissioner, he had been on the Minnesota Supreme Court, came to Washington with the Kennedy administration, and was an FCC commissioner during the mid-1960s, basically said that to the extent that in business there is a profit motive, in government there is a power motive, and that those people who have those positions of power tend to use it in ways that benefit themselves. And he was a fabulous commissioner, very principled. What we see is that where these precedents get created, whether it's the fairness doctrine or we can talk about the news distortion rule or whatever, they will be used by the administration in power in ways that they consider to be politically beneficial. Chairman Carr has been quite vocal in interviews saying all he's doing is really using prior precedents, and it's the Democrats that created those precedents, and so he will simply use them, and one of those is the news distortion rule, which is a sort of bastard child of the fairness doctrine that has no reason still to exist. But I think that's the prevailing lesson. And in First Amendment terms, the lesson is that governmental power over speech, when you deploy it, it's like poison gas. As former ACLU President Ira Glasser has always said, yeah, it's a fine weapon until the wind shifts and it's used by your political opponents. But that's been the ongoing lesson that I think we've seen, how power has been misused by different administrations and for different reasons.
Well, we're going to have a panel right after this about broadcast licenses, so you can get into the specifics of all that. But for now, really, this was just intended to explore the lessons of the experience of the fairness doctrine and the analogies to today. So I'll go back to Mike O'Reilly. Mike O'Reilly saw a clear parallel between the experience of the fairness doctrine and what he was being asked to do in 2020. And remember, he was being asked by the administration to reinterpret Section 230, an immunity for website operators and users against liability for hosting or moderating user content. That idea really turned on the idea of fairness. The idea was that you would lose your immunity under Section 230, both for hosting content and for moderating content, if you didn't operate fairly, to simplify vastly. We'll talk about the details of that this afternoon. And he criticized that idea, or some of the people supporting it, as essentially embracing a new fairness doctrine for the internet. What do you think about that parallel? Was he right?
Oh, yeah, he was absolutely right. And it's, again, trying to use the power of government to balance the scales. Or as the Supreme Court said last term in the Moody decision, saying that there is no more greater threat to free speech than when someone is trying to use it to conform the marketplace of ideas to their notion of basically free speech nirvana. And I think that parallel, regardless of what you want to call the policy, whether it's the fairness doctrine for broadcasting or trying to leverage Section 230 to create the same kind of obligation, it's the same problem.
Well, I've quoted that line from 1960 a few times already in FCC reports, where the FCC said that it was no better to manipulate the marketplace of ideas in the name of promoting free speech as to directly regulate free speech. It was essentially the same thing. Paul?
Well, it is, but the problem is that statement in 1960 was done at a time when the FCC was solidifying its power to require community ascertainment. Right. And so...
so they weren't practicing what they were preaching?
Well, no, and because at the time the constitutional review of what the FCC did was rather relaxed, and it really did depend on the FCC's own sense of restraint, which is expressed in policy statements like the 1960 en banc programming policy statement. And you'll see that from time to time in other decisions where you'll have nice language. But the reality is the FCC has been given a degree of flexibility to regulate media in ways that traditional media and now newer media don't.
So Paul, as a historian, what do you see from the FCC's inconsistency? What lessons would you draw to respond to the chair today who says, well, they did it first, and so I'm going to do it too?
Yeah, no, it's, it's the shoe on the other foot test, right? That you get an opportunity to use and really abuse these regulations. The other side will as well, and there's no guarantee that they won't use it better than you will. I'm reminded of Fred Friendly. He wrote a book about the abuse of the fairness doctrine in the 1970s, famous CBS newsman and so on. And he went around and interviewed all the folks involved in the Kennedy administration's fairness doctrine censorship campaign. Really the most remarkable episode of government censorship that almost nobody remembers, except for folks on this panel.
And Commissioner Gomez, right? Who brought it
yes,
up
who brought it up to her great credit. And he interviewed a bunch of them, and they all said, well, and he's interviewing them after Nixon. And they all said, oh, we didn't think the other side would get to do what we were doing. And so, and if you go and you can see the internal correspondence among Nixon's operatives, Haldeman and Colson and so on, and they're all saying, hey, the Kennedy administration used these tools, the Fairness Doctrine, to intimidate and to get better news coverage of the administration. Let's do the same thing. And they went and met with the networks. The networks all said, okay, you got it. We're used to doing this, right? So I think that's the cautionary tale, is that people only think about the current structure, the current political landscape, and not about the potential for future abuse against them and theirs. And we can see this with the news distortion policy. There were never Trump Republicans who pushed to use news distortion to go after Fox News station affiliates for 2020 election lies. And but now we see news distortion being used by Chairman Carr to go after criticism of Donald Trump and editorial decisions by CBS.
There's a non-discussed aspect of what happens at the Supreme Court if all of this gets to the Supreme Court. And the Supreme Court has been anxious for several years. I think Bob would agree with me that this whole notion of scarcity that was articulated in Red Lion may go away, especially with forget cable and satellite, and now you have the internet with the number of voices. Glenn Robinson used to talk about the Red Lion decision as creating scarcity as a matter of law, as opposed to a matter of fact. As if it's a matter of fact, if scarcity is no longer the operative principle that underlies licensing, what happens to licensing, right? What happens to licensing? Maybe you don't have scarcity as justifying all of the FCC's power anymore, and then where are you? And so I think there's a lot of players that have to rethink their positions in their industries. If scarcity goes away and the commission's power to license, and the government's power to license broadcasting as opposed to licensing AT&T or broadband or something like that, or even under the internet providers in Section 230, if scarcity goes away and there's no more content control, where are we? And do we risk is in quotes there, do we risk undermining the entire structure of license regulation if it gets to the Supreme Court?
Well, I mean, the Supreme Court has been reluctant to weigh into this area. And now think of the time scale between Red Lion in 1969 to the 1985 Fairness Doctrine report, at which point the Commission concludes scarcity, to the extent it ever existed, certainly no longer exists. Now, that was in 1985 when cable was essentially in its infancy, years before we'd see internet and all of that. Now, it has been now, 56 years since Red Lion, and the world is now completely unrecognizable in terms of what media is available, access to media by individuals, and so on. And so if there were a time for the Supreme Court to rethink this justification for regulation, which, by the way, from its inception was flawed, as Jerry was pointing out earlier, then now would be the time. But they have been continuously reluctant to do so. And this even happened in, what year was it? 2010 or so, when the indecency cases were up in front of the Supreme Court. And at that point, Justice Alito asked, why do we have to deal with this now? Can't we just wait for broadcasting to die?
I've been waiting for a half a century for this to happen. I was in 1970. I was an undergraduate. I was telling Bob earlier. I was an undergraduate at Northwestern, and I was in a TV management class. And the chairman of the department of the radio, television, film was having a discussion about the Fairness Doctrine, about Red Lion that had happened the year before. And I was working at WGN part-time and saw that this is crazy. We shouldn't be doing this. And the professor, the chairman of the department, said, let's have a debate about the Fairness Doctrine. And it ended up being Jerry Fritz versus the rest of the class. And so we're going on and on. About 20 minutes into the debate, the professor says, stops the debate. He goes, Mr. Fritz, if you are so juvenile that you don't understand the necessity of regulation in this industry, then perhaps you deserve to be in a different major. This is the chairman of my department. So I say after class, and I say, I apologize, Professor, but you're the one that set the terms of the debate, not me. And he said, well, write me an extra credit paper. exactly what I wanted to do. And so I did, and I wrote this paper, proposed, abolish the FCC. I was a, undergraduate. And so fast forward, I'm in private practice, and I'm working for Reagan Bush, and I'm interviewing for Mark Fowler's job as his lawyer. And I told him this story, and he goes, "You didn't do that." And I said, "Yeah, I did." He said, "No, you didn't." So I went home and I found that paper, and I had it copied, and I had it hand delivered. And this is a true story. He calls me up that afternoon. He says, "Jerry, you're hired." And here it is, 50 years later, that when Bob is talking about maybe this goes away, I'm vindicated. A half century later, I'm vindicated.
Exactly. More or less.
Never throw anything away.
But Baron, the question I always come back to is, okay, let's say Red Lion goes away eventually. What becomes then of the statutory language of the public interest standard? What becomes of that? I mean, is it now strictly, are you interfering with someone else? Is it a Hooverian, approach to licensing?
Think more broadly. Think beyond content. The public interest concept has always been, at least in the broadcaster context, has always been thought of in terms of content, right? Mm-hmm. There's other ways that broadcasters could provide public interest, meet their public interest responsibilities. For example, the broadcast BPS, broadcast positioning system, which is a complement to the satellite GPS system. Broadcasters can use a fraction of their spectrum under ATSC3 next gen broadcasting to use a portion of their spectrum for national security purposes to complement the GPS system. That's in the public interest. Nobody would argue that that's in the public interest. Maybe you can figure out a way to say, let's go beyond content to see how licensees can provide the public interest without content.
But I don't think you have to go that far. I don't think you have to say that there are some conditions we can demand as an exchange for the free use of the spectrum. I mean, the fact is, broadcasters provide a free programming service, sort of on a universal basis. Why isn't that exchange sufficient?
Mm-hmm. Can I add something, Barrett? Like, we're coming up on the 100th anniversary of the Federal Radio Commission, the FCC's predecessor. And so, for the 100th year, it seems like it's a good time for root and branch reform, right? And part of that, a component we haven't discussed here, is the need, I think, for locking in the form greater agency independence. So like taking, say, the Federal Reserve as a model, so not having a situation where the FCC chairman can be swapped out just like that, immediately able to do the president's potentially partisan will. You get more policy stability, so rather than whiplash over net neutrality, flipping back and forth in a suboptimal way. So having a larger commission with more independence guaranteed by statute, I think that would insulate a lot of this kind of partisan abuse.
Well, there's the elephant in the room here. We talked about this a little bit with Commissioner Gomez. The FTC commissioners have, of course, just been fired, the two Democrats. The president claims the power to do so, arguing that Humphrey's executor, that 1935 case that upheld the removal protections in the FTC Act, arguing that provision is unconstitutional. The Communications Act doesn't contain any removal protections for the commissioners. It's simply something that the courts have inferred for those commissioners. It seems to me pretty clear that whatever happens at the FTC and at other agencies that have explicit removal protections, that if the president fires Commissioner Gomez, and I expect him to do so, that will be upheld in court because there simply isn't a controlling legal standard. The interesting question is, how should these statutes be rewritten? People are starting to think about this. It depends exactly what the courts say, and these statutes are different. The National Labor Relations Board commissioner was fired recently. She's challenged her dismissal. That case should provide some interesting analysis because the NLRB statute is different in one very significant respect. It says that the enforcement decisions, the prosecutorial function of the NLRB is not handled by the commissioners, it's handled by the general counsel. The commissioners at the NLRB, the board members, have removal protections, the general counsel does not. So the general counsel is clearly exercising an executive function, according to most analyses, and that function is directly subject to control by the president. Maybe that's going to be enough. Maybe the court will say that that statute, as it's written, is constitutional, that it does fall into the realm of Humphrey's executor. If that's so, that maybe gives us a roadmap for what other agencies might look like, about how these statutes could be rewritten to uphold removal protections. What do you think, Jerry?
Look, as a practical matter, it doesn't make any difference. Elections mean something. Trump was elected. He gets to appoint who he wants to appoint. Whether or not he keeps Commissioner Gomez or not is irrelevant, because he's going to have 3 Republicans here. Even if she left and it's just the 3 Republicans, the statute, the way the statute reads, is no more than 3 commissioners can be of a political party, and he just has to slow roll. He doesn't have to appoint anybody. He could just be there, and there could be 3 Republicans. So as a practical matter, whether she stays or goes, he's still going to have his guy, Brendan Carr, in there making decisions. Whether or not those are constrained ultimately by the courts or not, who knows, depending on what comes up. But as a practical matter, it doesn't make any difference.
Well,
And secondly,
change the outcome. But don't you think there's something lost when there isn't another voice there?
so this whole concept of a unified executive has been debated for at least 40 years, since Bruce Fein was was general counsel of the FCC, who claimed that the FCC was not an independent regulatory agency. The whole concept of independent regulatory agencies, where you combine executive, judicial, and legislative functions in a creature of Congress, sort of bastardizes the Constitution, right? The Constitution has 3 branches, and they're all amalgamated together in a regulatory agency. For the Congress or for the president to say, no, we're going to treat this solely as executive for enforcement purposes, or solely as legislative for rulemaking purposes, or solely as judicial for enforcement purposes, you meld them all together. And there's no, the courts have approved independent regulatory agencies, but as you point out, the factions, the 3 separate decisions, 3 separate silos of the FCC can be seen as legislative, executive, and judicial.
Well, my point is just they could be separated in terms of who's doing what and who is subject to removal protections. That is a legislative response. Jim, do you want to add anything to that? You've said pretty well that this is helpful.
I think for me, what I hope we get out of this day is, Commissioner Gomez talked about it, we all talked about it, is that, and I think, Jerry, you said that, Carr claims that he's merely applying his existing precedent. In some respect, that's true. I mean, I sort of see this as this pendulum, and that unfortunately, rather than sort of regressing to the mean of straight down, is now actually oscillating, more and more. And I think both parties are to blame for this. And so to sort of, paint this administration as completely out, in right field, coming out of nothing, is just simply not the case. I mean, somehow we've got to figure out how to get this pendulum back towards, the center, fundamental, which is we shouldn't mess with the First Amendment rights of people.
Well, I would agree with you up to a point, and that is both parties and the administrations that they headed are to blame for this. But there's a big difference between what was going on in the Kennedy administration, when the Democratic National Committee was running its campaign to go after right-wing radio preachers, and even the Nixon administration, when it was doing things, and it was only when it was pulled out during the Watergate hearings that Nixon had an enemies list. In those times, it was surreptitious and it was a shameful secret, whereas now it's being shouted from the rooftops, that it's being heralded as this is simply the way power works in Washington. And it's the idea of those previous administrations being a cautionary tale. Caution has been thrown to the winds.
But it is all about power. It's not about the law. It's all about it. Jessica Rosenworcel, when she queered the Tegna takeover, was ultra vires. There was no reason for her to do that other than the fact that she had power to do that. She cratered that deal by just sitting on it, right? Power is what chairwomen and chairmen have because of the election. I think our discussion here in this panel and your whole day about the principle of the First Amendment, as I pointed out, I think Brendan Carr gets that. He understands the principle, but he also understands that he has the power,
So
and he's
Jerry,
going to use that.
So how would you rewrite the Communications Act if you were to try to deal with this problem?
I've been asked this question many, many times, and my answer is to go back to say that there ought to be private property rights for spectrum. You ought to be able to own it and do with it as you will.
And get the government out of
And
this
get the government
role of
out.
licensing. Jim, what do you think as a practitioner?
Be very interesting. The problem, I think, it comes from sort of the rent sinking and the fact that spectrum would instantly devolve into who could pay the most money for it.
Is any marketplace.
Oh, I know, but I think one of the great things about the Communications Act is the role that the Commission has in protecting present and future, spectrum uses. I mean, I'm an outer space guy, right? And I wrote an article in 1994 when the FCC was taking away a whole bunch of space spectrum, and it can happen again. If you auction everything off, it's going to go to who can spend the most money today. Notwithstanding in the Necropony switch, which says every generation things that were on wire go over the air and things that are over the air go over the wire. And so I think we have to be careful of placing too much, I'm a definitely free market private property guy, but I think there is a role of cordoning off spectrum for particular uses to protect it for the overall public good.
Well, we still have property rights and zoning, so I mean, they're not mutually inconsistent. You could have that without a licensing model necessarily.
I would note that because you lost that argument, we have these, right? Like that spectrum went to something arguably was more in the public interest than, the potential future use for space applications, right? So
Mark Fowler famously said that let the public interest define the public's interest.
Yeah.
Well, we're going to turn to the next panel, which will include Jim and Bob. Jerry, thank you for coming. Do you have any final words?
I don't. Other than the fact that I've been looking at this philosophically for many, many, many years, and I see the pendulum swing back and forth and back and forth. I'm heartened by people like Anna Gomez, and I'm heartened by people like Bob Cornrevere and others, and you all for taking the principled approach to the First Amendment. And I know Mark Fowler and Dennis Patrick would as well. My guess is we're going to come out of this all right in the end, but it's going to take a little struggle to do.
Well, let me ask you one final question, Jerry. Why do you think there aren't more people speaking out against what's happening today at the FCC?
Because you all look at this in isolation, in a silo, and there are so many other things going on in the industry. For example, broadcasters are looking for Chairman Carr to relax ownership rules. They're looking for Commissioner Carr to do something on ATSC 3.
Approve mergers.
Approve mergers. There are so many other things. You think CBS is not weighing the issue of the practicality of getting the Skydance merger approved versus the impact on the First Amendment? It's always useful to look at this not so much in a silo, but holistically, what else is going on.
Well, that's industry, but why not people who've been veterans? Why not people who believe in these principles? There are not a lot of people speaking out the way that Chairman Sykes did. He did this great op-ed recently with former Chairman Wheeler. Commissioner Chong signed a brief recently on these issues in the news distortion case. What would you say to these former Republicans who haven't yet spoken out?
Well, I'm not going to speak for any of the former chairs of the FCC or commissioners. They have their own, a lot of them say, after 10 years, Dick Wiley, after, been in the public forum, he's 90 years old, maybe give him a chance to take a breather. Maybe they don't want to get involved in the day-to-day, because ultimately this, as I say, is a pendulum. It's going to resolve itself. It's going to come back. We're going to win this case, the case of but in the interim, there's going to be some power struggles.
Well, Jerry, we look forward to having you at an event in the future, maybe, in fact, this fall. We'll see what happens. But thank you very much for coming.
Thank you.
I'm going to turn things over to Jenna from ACLU, who's going to moderate our discussion about broadcast licenses. We'll then have a lunch break and talk about the FCC's manipulation of its review of media transactions and messing around with market structure, and then close by talking about the rewriting of Section 230, the FCC's authority over tech companies, and as we did yesterday, what's next in terms of the agency's ability to engage in investigations, jawboning, and other tools of power. So Jenna, up to you, and we'll break around noon for lunch.
Always leery of being the panel before lunch.
Yeah, exactly.
All right, I guess let's get started a couple minutes early. You guys ready? No one needs a break. I think the room needs a break. Okay, we'll get started anyway, even though the room generally appears to need a break after that. So we're here to talk about broadcast licenses today, right? And I think that this has been underpinned in a lot of the other panels, but we're going to talk about it more sort of concretely in this one. There has been a lot happening on broadcast and broadcast licenses lately, and sort of underscoring all of that is the constitutionality of broadcast licensing to begin with. But I think it sort of, why don't we start today with some of the more sort of active policy debates that are happening in the broadcast license space before we kind of go on to like, okay, but is all of this constitutional in the first place? Because I think this is something that even people that aren't sort of involved in the law, but people that are just focused on policy or people that are focused on politics, it has sort of this attention that it hasn't had before. Underscoring this, I think, is the administration's, general attempts to control, frankly, the broadcast media. So, introducing our panelists. Folks just want to go down the line and introduce, and some of you have been on the panel before, so everyone knows who you are, but in case someone's tuning in for the first time.
Hi, I'm Bob Korn-Revere. I'm Chief Counsel for the Foundation for Individual Rights and Expression.
Clay Calvert from the American Enterprise Institute and Professor Emeritus at the University of Florida.
Jeffrey Wesley, American Action Forum.
Jim Dunstan, Tech Freedom.
Great. So I think we're going to do this. I feel like all of you are going to want to comment on all of these, so I'm going to do an open question, not direct anything to anyone, and then I'll just try to move us on if we're getting too long in the time. So I want to start with the equal time rule. I think a lot of you have been following this. Basically, Kamala Harris, she went on 60 Minutes. She did a skit with Maya Rudolph, I think.
Or Saturday Night Live.
Yeah, Saturday Night Live.
Saturday Night Live.
Yeah, 60 Minutes is news distortion. We'll get there.
Don't worry.
They thought that was comical, though. So anyway.
Everything's comical. She went on an actual comedy show with Maya Rudolph. And there's an equal time rule. So President Trump was like, what? Someone want to talk about, like, the actual equal time rule and what it requires and how justified President Trump and his team were in being, what? And, President Carr went on, or, oh my God, Commissioner Carr.
Freudian slip.
Freudian slip, guys. Does this mean he's gonna like me now?
Maybe.
Commissioner, if you're watching this, I had a Freudian slip.
Don't bank on it.
Chairman.
See? Telling you.
Promoting hogging him all through the administration.
The hole's getting deeper. That's okay.
This is why I'm going to let the panelists talk. Who wants to share a little bit about what the equal time rule is?
First of all, the Equal Opportunities Rule is embodied in Section 315A of the Communications Act. It provides that if there is a candidate, bona fide candidate for public office, that they have a right to use equal amounts of time or equal opportunities for time on broadcast stations that provide airtime for their opponents. And so once someone is a bona fide candidate, have to make available the opportunity for equal amounts of time for purchase, or if they provide free time for candidates, that they have to provide the opportunity for equal amounts or equivalent amounts of time for the opponents. There are exemptions for newscasts, news doctrine and fairness kinds of principles, basically saying that you can't really essentially falsify the news. But at the time that it made those pronouncements, the FCC was really quite clear in saying that this doesn't mean we have the authority to micromanage news programming, and it doesn't mean that we're going to be the role of the nation's policeman. That would, speech policeman, that would be an absolute quagmire, and quagmire was the term that the FCC in fact used. You know, and at the time, Dean Birch, as chairman of the FCC, had been chairman of the Republican National Committee, and he was on the commission at the same time as Nicholas Johnson, perhaps the most liberal commissioner ever. And the two men could not agree on anything. In fact, they hated each other. But the one thing they could agree on is that you would never apply the news distortion policy to something like, how do you edit an interview? That was one thing on which they agreed.
Yeah, and that's, I guess, the real question is, under the First Amendment, you know, editing is for editors typically. Miami Herald versus Tornillo. It's a different medium. That's print, yes. But nonetheless, when we think about editorial control and autonomy and discretion and what goes into that story and how it's edited, that's really what we're talking about. And now we're dealing with a micromanaging, essentially, by the FCC and intermeddling in those news judgments. So as we set this up, that's correct. It was one single interview, and both answers, the one on Face the Nation, which was the promo one, right? Both answers came from the same interview to the same in the same question. So they were answers to the same question. So there was no deliberate distortion. So if you look at the FCC's website today,
there's no distortion at all.
Yeah, there's no distortion. It's exactly what was said, the same to the same question, the response. They just said, here's part of it, here's part of it. They fit the format, right? So you're going to tease it out on Face the Nation, then you're going to have a longer interview on 60 Minutes, and that's going to be part of that, right? So there was no distortion whatsoever. So under the FCC's, you said policy, right? Online today, it says deliberate distortion. And then we get 47 USC 326, which basically says that the FCC shall have no power, right? Power to censor, and it can't create rules that allow for censorship either. So it's really two prongs under 326, that the FCC does not have the power to censor, and it doesn't have the power, it's not given the power to create rules that allow for censorship. And then Carr comes in, and you can see this, you know, symbiotic relationship, right? So here's the complaint, here's the lawsuit, and now we're going to leverage the power of the FCC to prop up and help Trump in that lawsuit. I mean, that's one way of looking at what's going on. All these moving pieces kind of come together in this situation, and then the causes of action that are being used are not your typical media privacy defamation, right? We're going after things like consumer fraud, unfair trade practices. So, but the Supreme Court has made it pretty clear in cases like Snyder versus Phelps, Hustler versus Falwell, that no matter what you call the cause of action, if there's there's speech involved and it's a matter of public interest or public concern, there's going to be some First Amendment overlay to kick
Well,
in.
and there's even more of an overlap, because when Trump first filed the litigation back in December, he filed this consumer fraud action in Texas for $10 billion. At the same time, or thereabouts, the Center for American Rights files this news distortion complaint at the FCC. It gets dismissed under Jessica Rosenworcel. 4 days later, after Brendan Carr becomes chairman, it gets reinstated, this public proceeding opened. Trump then files an amended complaint in Texas, now claiming that the damage there is $20 billion. And at the same time, Chairman Carr has announced that he's going to be taking these news distortion issues into account as he considers the Paramount Global and Skydance Media merger. So a lot of regulatory authority is being leveraged to put pressure on CBS and to essentially punish the network because of what the president disliked about how 60 Minutes edits its interviews.
And in that, oh, go ahead. Sorry.
Yeah, 2 points. One is when we filed our comments in response to the public notice on the complaint, my staff said, "You got a typo in here." And I said, "What's the typo?" And they said, "You capitalized edit in editorial." I said, "That's not a typo. That's in there for emphasis. There's nothing more editorial in an editorial function covered by the First Amendment than editing. That's why EDIT is all caps in that caption." But secondly, I think we have to recognize this, that the market actually worked on this one. I mean, let's not forget that. It's not like the editing of that interview went unnoticed. I mean, it was covered widely on it. And so the First Amendment actually really did its function here, in that the other side, the Trump supporters, could come in and say, well, look at this horrible stuff that they did. And and in some exit polling, there were some people who said, I really didn't like what CBS did there.
Or the Fox interview of Donald Trump in the barbershop that aired on Fox News that was widely edited.
Yes.
I feel sorry for journalists these days having to cover politicians and make them sound like they make sense.
Yes.
What I was gonna say was one of those cause of action in the 20 billion, right? Like Mike Myers, the 20 billion is unfair competition, right? And so he's saying that Truth Social, I'm a media competitor, is one of his theories now, right? With CBS and 60 Minutes, and so these are not your standard complaints. Anything I can throw up there, right, and literally or metaphorically, and then hopefully something sticks, and that's what's happening. But it's going to cost money to defend, and that's part of the strategy.
Well, so I want to talk about that a little bit. What impact does this investigation, and this isn't necessarily the only one, what is happening, does this have any impact on other journalists, on other news companies? Is there, essentially I'm getting at, what's the chilling effect, and is there one?
I mean, it goes back to the power discussion we had in the last panel, right? It's not necessarily designed to actually revoke the license. It's there to cause the change of behavior that they want to see. They want to see better coverage of Trump. They want to see the removal of DEI policies. They want to see all these different things. News distortion is one way to do it. You open an investigation. They have to spend a lot of money on lawyers to defend it. They got to make sure they're covered in their merger transaction. We're going to have a whole panel on mergers, so I won't get too much into that. But I guarantee you, CBS is thinking, how do we make sure this goes through? And if this complaint stays open, it can drag out, and the uncertainty causes costs and loss of the stock value too, right? I think Sinclair had a thing where they were going to air a John Kerry movie. It was going to be a whole thing right before an election, and they got some bad coverage, and it was like the FCC might look into this. Their shares dropped 15%, then they only aired 4 minutes of it, and it was just, that's a change in behavior. Those are the kind of things that can happen even if you don't have the actual license removal on the back end.
Here's my big worry of what's going to come out of this, and that is that we are going to see in the next renewal cycle a cottage industry of people coming in and jumping license renewals with petitions to deny. I have enough gray hair to remember the 1980s and 1990s when virtually every single broadcast license was jumped on EEO grounds. Even stations who had exemplary EEO records were nonetheless a petition to deny. It was just it was a mill that was created, and I think we're going to see the same thing here. And the FCC, Jerry talked about the 2,191 whatever fairness complaints. We're going to see 8,000 petitions to deny on news distortion grounds, which literally is going to grind the FCC to a complete and utter halt.
Right, and it holds license renewals hostage to those complaints. And at the time, you mentioned the EEO complaints, the FCC's procedures created essentially a cottage industry by which people were incentivized to file these things. And they would reach what they called citizen agreements to reform the hiring practices and the programming of stations, and those would be incorporated into the FCC orders renewing the licenses. So you
and there were voluntary contributions as well.
And finally, it had been such a failure, such an embarrassment that the FCC had to end that practice, and by rulemaking eliminated the ability to enter those kinds of citizen agreements.
Right.
And also, like, to that point, I've seen a lot in the news about cutting staff from DOJ, those kind of things. If we do start seeing more of these complaints, the Media Bureau is in the target of losing staff. I think Symington's op-ed really focused on that, and that's just another thing to consider, that like if we do start getting these complaints, we might not even have the staff that we would normally have to handle it. But one question I have, because I think everyone up here is smarter than I am, or at least more experienced, can they go after licenses outside of the renewal process? Can they say, we're going to try to revoke this without a transfer, without a renewal coming up, or does it have to wait for that kind of proceeding?
I mean, technically speaking, you could always file a petition to revoke a license. I mean, it's happened before on a couple of cases. And actually, I went back in preparation for this and looked at some really interesting cases in the early '60s. I mean, there's a WDKD down in South Carolina, where a quote shock jock said a couple of
Uncle Charlie or something.
Uncle Charlie, exactly. Said a couple of things by today's standards you wouldn't even blush over, and yet that license was revoked. Turns out the story behind it was a southern station which sold time to black churches on Sunday morning, and so there was a lot of people who didn't like that. And then, of course, the flip side of that, a few years later, is Lamar Life Broadcasting in Jackson, Mississippi, where they ultimately their license was revoked because at renewal time, because of fairness doctrine violations. But what was really going on was it was a very southern, very white, anti black station, and so the commission does have that power. Less so today because again the WDKD. That license was revoked because of misrepresentations. Exactly. Lamar Life was revoked because of fairness doctrine violations. One thing I have always told my clients, no matter what, do not lie to the FCC. That's right. Because that's the only way you lose your license is if you lose RKO. I mean, all of those cases.
Almost every case in which you have a revocation involves misrepresentation.
Exactly. So just be truthful.
General rule for life.
Yes.
So it's not, just a Republican commission that's done some of these investigations or dismissed them. Rosenworcel as well was involved in news distortion complaints, dismissed them. Someone want to give the background there and kind of say how it's gone for both sides of the aisle and whether they've been abusing the news distortion policy?
Yeah, so I mean, she didn't do as much formally to act on it, but there were petitions filed against Fox. I think someone already brought it up on this panel about just basically the ownership there, saying that they didn't have the character and fitness and they lied about the election and tried to push those complaints out. The interesting thing was that at the end of her term, she dismissed all of these complaints at the same time. And that's a political move. Even though she's probably justified to do that, it was deliberate to make it so that Brennan would have to reopen the ones he wanted to reopen, and that's a move designed to make him act. And whether you're right or wrong to do it, that there is a reason behind it, right?
I think that was my question, because in the the civil rights circles that I work in, there was a lot of people saying, okay, he only reinstated the complaints he wanted to reinstate, and that is the evidence of it being political. And I think I was wondering if people on the other side are like, she was also being political. And
Well,
it seems like your answer is yes.
Yeah, but also keep in mind, I do think that she did take action sort of forcing Carr's hand. Had she upheld the staff dismissals more than 30 days before the inauguration, they would have been permanent. They would not have been able to be reopened. So that's unfortunate that the timing dictated created the ability for Carr to reopen them. But there was a difference in the kinds of issues, kinds of proceedings that these were involved with. The Fox proceeding was a license renewal proceeding where there had been petitions to deny, and that was handled by the Media Bureau. The others were complaints filed by activist groups, the Center for American Rights, that went to the Enforcement Bureau. And so, being on different tracks, they were ultimately dismissed on the same grounds, that there was no basis for them and they violated the First Amendment. But one in the licensing proceeding, that's something that had been going on for years. You can make the argument, although I think it was political, but you can make the argument that there's more reason to finally resolve that matter, whereas these complaints that were filed on news distortion and at equal time were only filed like within a month before they were dismissed. So while I don't think that justifies reopening them, they are in somewhat different categories.
I'm gonna move us on to kind of what I think of as like one of the most active debates in broadcasting, which is red line. Maybe it's not the most active, you guys can tell me what you think, but for red line, is a broadcast license constitutional? The Supreme Court said yes, but do we think that the Supreme Court was right? Who wants to talk about sort of red line's holding and whether it's the correct holding?
This was kind of the prior panel. We talked a lot about it, but about the red line history. You guys want to go back?
Go ahead.
Well, I mean, if I could jump in at the very beginning and just say that spectrum isn't scarce. Spectrum itself isn't a thing. Spectrum is just the frequencies at which radios operate. And so there's this whole, I know we talked about like the property right of spectrum, and I always struggle, what is the property right? Is it the license? Well, what is the license? How do we define the license? What are the bounds? It's a trickier thing to do than just say, well, I have a right in this. But back to red line, it means that one of the ideas behind scarcity is that there's no scarcity there. It's just whether we can operate without harmful interference. And I think as technology improves, even on just the broadcast side, we can be more efficient. We can get more speakers in broadcasting. And obviously that's the side argument, because the real argument is all the different things, cable, social media, the internet, ways of reaching consumers. But I think it's important to table set that a little bit, because it's something that gets lost a lot. We just say, well, spectrum is scarce. It's like, well, what do you mean when you say that? Because it's not a thing. I get so frustrated by that.
Well, that's right. And, I'm glad you asked that sort of baseline question, because it's so often taken for granted that we license these media in a country in which we have a First Amendment that was in part a reaction against press licensing. And so that really is a significant leap from that historical background to this one. And the rationale that was developed was to say, well, this technology is different. Well, in fact, it really isn't. And as you said, spectrum is not a thing like a piece of land. It's not property in that sense. And what essentially happened in 1927 is that the federal government and Congress nationalized the laws of physics, basically because you could use the electromagnetic spectrum to transmit information, that they decided to put control over that. But if you go back and look at the history, you will see how Herbert Hoover tried to manipulate the process so that it would force Congress to act, that the scarcity was essentially a myth even at the time, and has been used to continue the justification of press licensing over time. If you were writing on a clean slate, one approach is to establish some sort of allocation system, and having sort of a property-based system is one. Jerry Fritz mentioned the 1926 decision in Illinois, Chicago Tribune versus Oak Leaves Broadcasting. That was one way that could have developed, but that was cut short by the radioactive 1927.
Bob had an excellent piece in Columbia Journalism Review. It was an open letter to Chairman Carr, basically. And one of the things that he mentioned was, he was almost cautioning Chairman Carr about, don't push it too far, because if these really come up, the court will go ahead and strike these down. And there's your public interest concept, right? And the news distortion rule hinges on public interest, essentially, is what they're going to say. And so if you take Red Lion too far and you give the court a chance to overrule Red Lion, or whatever it may be, you're going to be in some trouble later on, because your public interest, peg on which you're justifying all of these actions, it goes away. And so I think it's a great point about how far do you push that. We've talked about this pendulum swinging back and forth. If you push the pendulum too far, everything on which you're trying to rest your actions may disappear.
I'm going to push back a little bit. The notion that there's not a scarcity issue. I mean, the laws of physics actually do say that there are limits to the amount, and the way that we have licensed broadcast stations, and especially television stations, as the FCC gave really high-powered stations into the metropolitan areas, by the laws of physics, said that they could not allocate the same channel within a certain amount of distance. And so, yes, you could say that there is no scarcity. Let's cut everybody's power, by 10x or 100x down, and we could have 10,000 television stations. Sure, we could do that. None of which would have much value anymore. But so I'm not completely convinced that the scarcity rationale completely goes away.
Well, I mean, you're right. There has to be some method of allocation. I mean, and the same is true in any other economic good. Whether you're talking about a piece of land where you can't build a farm and a parking lot on the same parcel of land, you have to have some way of allocating who's going to use that for whatever purpose. Same is true of spectrum. And what the Oak Leaf Broadcasting case talked about was how you do that through prior use. The other thing about spectrum, and this is unlike other economic goods like land, is that as technology has improved, the ability to get more out of a particular bandwidth has only been magnified, and that continues to develop. So, yes, you have to have a method of allocation. No, that doesn't mean you have to have licensing.
Free for all.
And if I could just add a little bit to the end, I agree with Jim that laws of physics do say there's only a certain amount of throughput you can get for a specific amount of band, but there's ways to get around harmful interference that could be maybe in the broadband space, densifying your network. You can have more antennas with lower power and things like that. So my point was more just that there are ways to limit harmful interference to alleviate some of those scarcity issues, but I agree that they never do go away completely. You're going to have harmful interference. It's going to degrade the service, and that's something that we're trying to manage and figure out.
I mean, there's an argument that when the commission went to digital television in the early 2000s, rather than taking that 6 megahertz and converting it to digital, they should have actually shrunk all the licenses down to 2 megahertz, because you could still get a single HD TV channel with today's technology in that 2 megahertz, and then that would have freed up. You could have then 10,000 or 50,000, but of course, politics being what politics are, NAB and the broadcasters never would have stood for that, of losing 2/3 of their spectrum and yet still ending up in the same place where they were the day before they did the digital conversion.
If I've learned one thing in spectrum policy, is that people will not give up rights that they have.
Well, that is a law of physics.
That's a law of physics.
There's a question over here. Yeah.
Yeah. Or later, we'll save it for the end.
Keep the question, just to.
Okay.
This is an interesting conversation. Can we get most of the way there by just taking Reliance interests a lot more seriously with respect to renewals, license renewals? So say to yourself, okay, I'm worried about the malleability of the public interest standard. I'm worried about a chairman of the FCC who really didn't like my local news editorial that attacked Donald Trump. You could just say, okay, when it's time to renew that license, that station should be able to say, hey, we have spent millions and millions of dollars over the course of the last 60 years in reliance on this license, and we have a very large local
So it was a question on essentially reliance on the public interest standard when things change. Folks want to tackle that?
Well, yeah, let me address the one problem with that is, of course, we have this strange, bizarre line of cases coming out of bankruptcy law, which actually undercuts that. Where basically the FCC had to argue that there is no actual, even an inchoate, expectation of continuation of that license. Otherwise, it would become an asset in bankruptcy. And so there were always, as a practitioner, I'm sure all of us have filed, the no claim of right to the spectrum type of stuff. And so we got that sort of weird outlier that are out there. Now, as a matter of fact, in license renewals, the FCC sort of does default to that expectation of renewal, and it is a pretty high burden. But the problem is not getting there. The problem is the cost and the time that it takes you to get through the process, and which is what I'm really concerned about.
And the process itself, because
becomes the punishment, yes.
Right, where the fact that you can use the complaint process or the petition to deny process as a way to hold up license renewal, and if you have an agency that is, say, inclined to use that process to extract concessions or to impose punishment, they can simply withhold a decision and drive up the cost and the aggravation of getting that renewal.
Okay, we can take one more question, yeah. Harold?
Just kind of quickly, I wanted to ask this on the last panel, but so if scarcity is dead, why is licensing at all constitutional? Why isn't it just, hey, unlicensed, totally how we're going to go, as long as you don't interfere with anybody else, and we've got the technology to do it? Because the whole basis for licensing, which created the scarcity doctrine, was unless the government controls it and limits it to a very small number of people, no one will be able to use it. So,
you kind of
proposed this, 15 years ago, along with the OPEC Bank, but if we're closer to there, or is the alternative, because we still have to do license allocation, there still is some public interest obligation. That's always been the trade-off, and it's not about the number of outlets, it's about the exclusivity.
Okay, Harold's question was essentially what I was going to ask next, which is the constitutionality of licensing to begin with. If we take your argument that there's no more scarcity in the marketplace, and if we, think it is still constitutional, is that because of the trade-off of the public interest standard?
Well, for reasons that I mentioned on the last panel, I think the Supreme Court would be reluctant to address as an initial question whether or not licensing is constitutional. It's been with us since 1927, actually even before that, but it became more ingrained in 1927 and then again in 1934. And so if you were raised that as an initial question writing on a blank slate, you might get a different answer today. But you would have to go back to the history of how that developed and how the FCC, the federal, actually prior to the Federal Radio Commission, the Department of Commerce was in charge of issuing licenses, and there was really a concerted effort to create a justification for a federal radio law. At the time, licenses were essentially freely given, but then there was it the Zenith radio decision, or was it Intercity Radio at the time that decided that the Department of Commerce couldn't prevent someone from having a license even if they interfered. And so Herbert Hoover essentially let that happen and create justification for the Federal Radio Act of 1927. It's interesting when people talk about spectrum scarcity, they forget the fact that once the FCC or the Federal Radio Commission allocated a certain amount of bandwidth for radio, one of the first acts that the Federal Radio Commission did was to cancel the license to broadcast for some 200 stations. And it was the minority and fringe stations that were the first to go, whether they were stations operated by labor unions and others, those were the ones that were canceled.
I mean, ultimately, the license is really who has access to speak in the marketplace of ideas. Really, we talked about the marketplace of ideas on the last panel. We went back to Aeropagetica, right? We talked about Milton. And so really what that's about is who does have the right to speak. In Red Lion, remember, the court focused on the audience's right to receive speech as much, and they focused on that when it comes to the marketplace of ideas and broadcasting, it's really not the speaker's rights who are dominated, but the audience's right to receive a multiplicity of views and different views that comes in. And then that gets us through the public interest concept, right? We get localism, competition, diversity of ideas, the marketplace of ideas. And so then that goes to the concept of the public interest, and how do we define that? And it used to be, I mean, at the most rudimentary level, right, we would think of conservatives as being the marketplace as whatever the market people are interested in, right? Marketplace forces dictate that. This is what the public wants, that's the marketplace of ideas, that's the public interest, versus the public interest is a public good. It's not necessarily what the public wants, it's what the public needs. And then you give somebody, the government, the FCC, the ability to define that concept, and that's the problematic part of this.
Yeah, I think what you said struck me as interesting because the marketplace of idea, I think, is inherently so that people have access to ideas that they don't necessarily want, and that's actually why we have the First Amendment to begin with. So insofar as the marketplace of ideas is very different from an actual marketplace and a free market.
Sure, no, it's speakers' rights versus listeners' rights, and you've got the right to speak and the right to receive speech. And then the public interest concept is being used in the news distortion rule to interfere ostensibly with the speaker's rights. We're going to interfere with your editorial control and autonomy and your decision making about how you present the Kamala Harris interview and chop it up, right? But if you go down the public interest side and say the other, well, it's the right of the audience to receive all of the information possible about this, then you allow that interference.
And it's actually really funny because depending on which end of the telescope you look into, you know, for me, I kind of come at it a different way. If it's the rights to speak, then I think there is scarcity because of laws of physics. If it's the right to hear, then there is no scarcity because we have so many now different mediums, so many different outlets. My ears are exploding, you know, with all the different voices that I can hear. And so I think that's one of the problems with Red Lion is, and I think one of the reasons maybe the Supreme Court has been hesitant is, how do you end up, you know, which end of that telescope do you end up looking into?
Yeah, how do you define the market, and how do you define the marketplace of ideas? Because the marketplace of ideas is vast now, and we're regulating and controlling broadcasters in a very narrow way, whether it's the broadcast indecency standard, which Bob knows not because he's indecent or anything, but he's litigated those cases, right? But you know, that still exists, and everybody else is not regulated by the broadcast indecency standard. Same thing with the news distortion policy. It only applies to over-the-air broadcasters. It doesn't apply to CNN. It doesn't apply to Fox cable channel, right? And so you've got this very small niche that are subject to these really tight controls.
And it raises the question, what exact interest is being served by regulating this one medium? We now think of the marketplace of ideas as being vast because of advances in technology and alternative methods of distributing information to a global audience. What exactly is the government's interest in taking this one medium that most, you know, younger people probably would not know if they're receiving information over a broadcast channel or not? You know, what is the government's interest?
Yeah, and students today, when I would ask that question, you know, I try to explain a cable is a coaxial cable that goes into your, you know, and then somebody mentioned the rabbit ears yesterday, you know, and talking about how they got TV over the top, right, or, you know, free TV, you know, and they didn't think about that. So they draw no distinction whatsoever between ABC, CBS, NBC, PBS over the air, and everything else.
Or streaming.
Streaming, now streaming. And so the marketplace is huge. And so that raises the question, I guess the next one is speaker-based discrimination. Why are you discriminating against a certain class of speakers in over-the-air broadcasting when others are not subject to those same rules?
Well, not even broadcasting too, but social media didn't exist when Red Lion
Yeah.
existed, right? So that's a whole other question of the marketplace being, I mean, is it equal? I mean, this is actually probably a very dumb question, but when you think about the news and the reality that most people get their news online versus broadcast, does that weigh one way or the other for you all in terms of if we should be licensing broadcast stations? Or
Well,
like too controversial?
I guess maybe it shows that even if you, okay, let's take Chairman Carr's defense on this side, even if you use the news distortion rule and vigorously, enforce it to kind of get only the news you want, what big effect does that have in terms of where most people get their news information from? As you just said, social media, other sources. So you can police it in one little realm, but most people are relying on other sources for it. So,
But it comes down to exactly what Jerry Fritz was talking about, and that's saying that it ultimately comes down to power.
Yeah.
These regulations over a sector of the media gives government officials of either party excessive power in controlling how those media sectors operate.
And that's what part of this is. I mean, we're only focusing on the FCC and Trump and Chairman Carr, but really the big picture here is, controlling the narrative, right? That's what we're talking about in the marketplace of ideas, and whether it's denying access to the Associated Press reporters at the White House and the press pool and saying, okay, we don't like it because you use the term Gulf of Mexico AP and you have it in your style book, which is hugely influential on how everybody else refers to it. We're going to deny you access because you're not using Gulf of America. And I live in Florida. We're pretty close to the Gulf of America or Gulf of Mexico, whatever you want to call it.
Isn't it the Gulf of Mar-a-Lago these days?
Oh yeah, Qatar-a-Lago, I heard that was the new term they were calling it. But that's just part of it. It's academia, the attacks on academia, going after the universities, attacks on the law firms. It's the big picture, right? This is just one small niche of the overall, let's control the narrative, deny access to those who we don't like, and then when they have it, then we'll use the news distortion rule and whatever tools we have, including the lawsuits and the synergy between President Trump's private lawsuits, right? Whether you're involved in the Ann Selzer case or FIRE is, right? Whatever it is, we'll try to silence it that way, and we'll leverage whatever regulatory power we can get out of the FCC. That's how I see it.
And I would just add that broadcasters, to your original question of the news and does that change how you think? Broadcasters are competing with all these folks. So to me, as a policy matter, it is better to deregulate the types of content that broadcasters have to air or they can't air, so that way they can deliver what the consumers want. Because at the end of the day, broadcasting is slightly different than these other mediums, right? It's over the air. Theoretically, you don't need to go get a broadband subscription or a cable package. You can just have a television with rabbit ears and get information. So there are unique aspects of broadcast that could maybe make it it's a more competitive product for a certain market. So let's let them compete on the merits and see if that technology is still really valuable. Maybe it turns out that nobody really cares about broadcasting anymore and it goes away, but we should at least let the market
until
decide
the that.
lights
go out.
Yeah.
Until the cable doesn't your broadband doesn't work. Let's not forget the fact that there is some value to free over the air. That's why stations have to do emergency alert tests and all that stuff. They do play an important role, especially during emergency times.
Until we have better broadband networks.
Yeah.
Okay, so we're getting low on time. The last question I'm going to ask is sort of about localism. So Chairman Carr has been really focused on the control that the nationwide networks exert over their affiliates. God bless you. Does it matter? Should it matter? Localism, how important is it?
Well, localism is important, and it really doesn't matter what medium you're talking about, whether or not you're talking about online media and something like Nextdoor, or you're talking about community newspapers, and the fact that we have an increasing number of news deserts, that's important as well. It's also been a significant part of local licensees for broadcasting, whether radio or television. But what you're seeing when you hear Chairman Carr talk about localism and its importance is how can the power of the FCC be leveraged against the networks? I mean, if you follow Donald Trump's tweets on the subject, he keeps talking about how you should take away CBS's license, or you should take away NBC's license, not realizing, I guess, that it's the stations that are licensed and not the networks. And Chairman Carr has been jawboning against the networks, claiming that they need to change their compensation policies between the network affiliates and the networks. But again, all of this is really just the exercise of power to put pressure on the networks as corporate entities as opposed to everybody else. I'm not quite sure it's motivated by any serious interest in local broadcasting.
It's so interesting because Jerry referred to something that I hadn't thought about in many years, which was the old FinCEN rules, financial syndication rules. You know, there was a time when the FCC really got into the market between, going back to chain broadcasting rules, got into the relationship between the networks and their affiliates.
Well, and the companies that made their programming.
And they made their programming, that's right. And it was the Fowler Commission that started that, let's get out of this, let's let the market figure out what that relationship should be between, the network and their affiliates. And I just find it very curious that a Republican would now say, well, let's go in and restructure the relationship between the networks and the local affiliates. Well, why? How is the market broken, other than the fact that you don't like, the content of what that relationship is, producing, which in and of itself isn't even true. But it's just very strange to me that a Republican chairman would suddenly decide that it's time to go back to the old chain broadcasting rules. I mean, I find that just really, when somebody posited that to me right before inauguration, I said, oh, that's never going to happen. This FCC would never get back into regulating that relationship, and boy, was I wrong.
Well, I didn't think in 2025 we'd still be talking about the fairness doctrine.
Well, that's true, too.
I think with delete, and then simultaneously more efforts to control the narrative, I see irony.
Yes.
Yeah. It's also worth noting, though, that this is kind of in line with the Trump quote-unquote Republican side of things, right? Where it's very populist. There's these big companies. I'm sure the FTC discussion yesterday got into this a lot, where they dislike the big firms because they're not friendly to the local mom and pop shop, and that's something that plays very well with this administration. So in that sense, I understand why he would go this route, because it plays well with that side of the party.
I wrote a piece just recently for AAI on that delete, and then how the NAB and Sinclair step in and say, well, let's get rid of the 39% cap on national ownership. And one of their appeals is really a localism on local journalism. So when you read through those, their petitions, their letters to the FCC, what they're saying is essentially scalability here by having larger advertising power, allowing us to reach 100% every household in America, will improve local journalism content, right? And all I tried to point out in that was the irony of you may not get great quality local journalism content if the FCC continues to go after and use the news distortion rule to police that news content. You might end up with propaganda and a public relations on those localism issues.
I think I never want to be the person standing between everyone and lunch. So we have 5 minutes. Yeah. Does anyone have any final thoughts on broadcast before we break?
I mean, my thing is, I just think this is just one sliver of the niche of control the narrative, control access, and it has to be taken with any other voice of dissent in trying to squelch that. And I truly believe that from academia, lawsuits against universities. We didn't even mention really PBS or NPR, Voice of America, whatever it is, the Associated Press, the lawsuits against CBS and Seltzer, Des Moines Register. It's all one big picture, and I think that's the important thing. We're focusing on one slice of it.
Yeah, I'd agree with that, and I also like to echo what Jerry said about being somewhat optimistic about how this will turn out. I mean, as dark as some may paint the picture of what's going on with this administration, for those that have been doing this for a long time, we've seen it before. Mm-hmm. We've seen it come and go, and I think that this too will end up, as the Nixon administration did, as a cautionary tale. And it should be a lesson for those who have been regulatory enthusiasts and in favor of a more muscular FCC to regulate in the public interest, what that can look like when an administration you don't like exercises that kind of power.
Yeah. And echoing off of that, I've lived 2/3 of my life in Washington, D.C., and it just never ceases to astound me how every party that's in power believes that they will never be out of power. And so, I mean, one of my biggest fears coming out of this is what happens in 4 years, and a Democrat, administration comes back. I mean, is it going to then take that pendulum and swing it even higher, oscillate it higher in the other direction? Because, well, that's what Trump did, so now we've got to counteract that. Or can we somehow get this down to regress into the mean, to some sort of, centrist idea of, and back to first principles on First Amendment. So I am optimistic as you are, Bob, because I think cooler heads ultimately prevail. But in the meantime, I think we're going to in for some really wild ride over maybe the next decade.
As the person who doesn't have that much experience, I am less optimistic, but hopefully.
I too am optimistic.
No, but I think the big picture is it does, as Justin Timberlake said, what goes around comes around, comes around, comes around again. Not to bring up the Super Bowl halftime show, but Timberlake might have a point on that. So
We're ending it there. We're ending on Timberlake. Thank you all so much.
exclusive licensing, only we get to.
Yes. All right, welcome back. Thanks to the Tech Freedom crew for lunch. Very enjoyable, we appreciate it. So, coming back out of lunch, we talked this morning. We heard from Commissioner Gomez, we heard from Jerry Fritz, a wonderful sort of trip down memory lane and the Fairness Doctrine. We talked about broadcast licensing, and now we're going to shift gears slightly to media transactions, review, and market structure. And one of the things in that last panel we touched on but really didn't emphasize is the fact that, you know, a broadcast license only comes up for renewal every 8 years. And so the opportunities to jump a license don't occur all the time. And so sure, you can file a petition to revoke a license, but those very rarely ever get anywhere. But one of the real pressure points at the FCC has always been M&A, you know, media mergers and acquisitions, the transfer of license, because under the Communications Act, the FCC has to approve any transfer of a license or acquisition of the assets of a station. And so that has traditionally been the opportunity for folks to come in and sort of do a festivus and their list of grievances on parties. And this is not unique to one side of the political spectrum or the other. You know, it is yet another cottage industry at the FCC of people coming in and trying to extract voluntary agreements from in the context of a merger and acquisition. And you know, we can go back decades. You know, AOL Time Warner. We can talk about, you know, the really wild one that doesn't get talked about much, which was the Sirius XM merger, where there was a condition on it that they had to set aside a certain amount of channels for specific types of programming. They let her sort of drop that when it pretty clearly was going to be unconstitutional. We've had multiple, I think, you know, not only does the FCC often extract conditions in these mergers, but quite often, especially the large ones, the mergers simply fail because the process becomes the punishment. The fact that the commission simply doesn't act. And, you know, we saw it with Sinclair Tribune, you know, and we saw it recently in Standard General, you know, in Tegna. And so, you know, one of the things I always thought about, in fact, is I think that the financing deadlines of all transactions should be proprietary, and the FCC shouldn't have access to that information because they know what the clock looks like, and they know that oftentimes they can run out the clock. Of course, now what we have is an FCC which is, and again, a lot of those conditions are sometimes market structure, sometimes labor, sometimes, you know, rarely have they traditionally sort of focused on First Amendment issues. But now we have an FCC which is already sort of telegraphed, going back to old wireline technology, that it could withhold approval of transactions based on everything potentially, you know, news to DEI policies. And so we're going to really talk about, you know, what are the limits of the FCC, you know, but what has been the practice in the past, and, you know, is this getting worse? Getting back to my sort of pendulum theory, is this pendulum swinging wildly, or is it simply sort of reaction to what's happened in the past? And then finally, we do need to talk about the unconstitutional conditions doctrine and the idea that, you know, that generally speaking, you know, the government cannot extort from you an agreement to forfeit any of your constitutional rights in exchange for getting a public benefit. Unfortunately, the law on this, the cases on this are not well established. They're not, certainly nothing recent, but, you know, we may see it come swinging back around depending on what the FCC does. And again, from a statutory standpoint, The Communications Act requires any applicant to come before the commission and demonstrate that they, that the transaction will is in the public interest to be granted. And the FCC does have the ability to impose restrictions and conditions on such applications. So with that table setting, just want to have the panelists go down and introduce yourself. Harold, you're first.
I'm Harold Feld. I'm Senior Vice President of Public Knowledge.
Hi, everybody. Matt Wood, Vice President of Policy at Free Press.
Baron Soka, Tech Freedom.
So, where do we start? So, what are the limits to the FCC's authority here? Who wants to grab that one first? Yeah.
It's a good question because, first of all, the FCC regulates a variety of different services, and some of them have not traditionally been considered to be about First Amendment issues like common carrier, whereas some of them have been very much about First Amendment like broadcast media. And what is complicated is that the FCC was deliberately invested with a great deal of authority, and until relatively recently, the courts were favorably inclined, even after circuit courts stopped being favorably inclined. For a very long time, the Supreme Court was still even favorably inclined to the FCC being delegated broad authority. Additionally, when the FCC is engaging in the transfer of a license, which all of its merger review is tied to the transfer of either a wireless license or some kind of wireline license, although recently with the certain other types of certification like Lifeline, ETC type certification, there are some things that are not technically licenses that are part of that. Conditions that you accept as part of this, if you choose not to go through the very long process of fighting the merger, are considered voluntary. So it had been very difficult to challenge these conditions that you voluntarily accepted, although there was a case some years back in which Charter had, during the Obama administration, accepted a condition with regard to I forget if it was a retrans or bill debt, and this was challenged, and a particular panel of the DC Circuit was extremely excited to get this case because they not only, in my opinion, really dramatically stretched the standing in order to be able to reach it. They then were, decided we just don't think that was a relevant or fair condition. So there does seem to be an avenue, even after the fact, even if you didn't exhaust your administrative remedies, to challenge some of these things. But traditionally, it's been extremely broad, and sort of anything that might even consider to be vaguely touching on what the FCC is supposed to be doing, which is very broad with regard to I like to characterize the FCC's jurisdiction as narrow but deep. It covers physical infrastructure things, but for the entities that it covers, it can very pervasively regulate.
Yeah, I mean, I'll try to come back to your question, Jim, about the limits of the FCC's authority. I guess my first answer would be I'm not entirely sure, but this administration seems bent on testing them. And it's remarkable for a lot of reasons. I don't think I have to make any news here or tell anybody we live in pretty remarkable political times. Free press, public knowledge for that matter. We've often called on the FCC to examine the public interest obligations of licensees and to test those in transactions. So I think there's, there could be lots of debate about, well, you guys wanted the same thing, and I think we could have distinctions as to that. And we can talk about those questions too, but without being too defensive or backwards looking, I think the remarkable thing about this administration is it's not your father's Republican Party, right? It's not pro-business, it's not deregulatory, it is basically pro-Trump. And there's just no two ways about that. And so when you see people like Chairman Carr, who today says, hey, maybe CBS will have some trouble, it's not even just so much as you said, that people can challenge at license renewal time, and the transactions are a much more fruitful way usually, excuse me, to challenge things or to try to get conditions. It's that they're basically making these incredibly, I think, harmful but vague threats. It's almost like a protection racket. Like, well, you might want to not say that, and we might want to revisit that later when you come before us. So as far as the limits go, as Harold said, there's a lot you can pack into the public interest standard.
Matt, if this isn't a protection racket,
Yeah.
what would be?
No, I'm saying, yeah, all right. I'll try not to speak in qualified terms in authoritarian times. Maybe I should train myself away from being too learned. But yeah, I mean, the shakedown it's remarkable. It's not just what they're asking for, but who's doing it and how they're doing it. So I want to go back to 2021, when at Free Press we filed not even a formal petition at the FCC, but just sort of said, hey, there's a lot of COVID disinformation on broadcast outlets. We think this could be a violation of what's called the broadcast hoax rules, where stations are knowingly causing harm to people's health by letting this information out there. We were slapped down by then, I think Chairman Carr was still then general counsel, but I'm forgetting exactly who was in the chair. It might have been Tom Johnson by then. And even earlier, I think it's in the same time frame, but kind of that COVID era, there were questions raised by some Democratic members of Congress about carriage of Fox and One American News Network and networks like that post-January 6th. So I almost have this one memorized now. Commissioner Carr then, from a minority seat, said the decisions a newsroom makes about what stories to carry and how to frame them should be beyond the reach of any government official. That's 2021 Brendan Carr. Today it's, well, we don't like the way you edited that story, and so therefore we might deny any transaction that comes in front of us. I think the other hook that they've cited obviously is DEI, which is a real thing, but is itself pretty amorphous. And so without having to make any kind of case about actual employment discrimination, they're saying maybe your transaction won't go through if you're engaged in unlawful activity. People rightly talk about the constitutionality of the current administration. I almost think it goes deeper than that. It's like Magna Carta, right? Like you're guilty of a crime and we'll tell you later what it is. And I think that's the real threat that we see now is these guys are willing to test those limits, but they're not actually having, in order to chill speech and to have an effect, to make the case in advance.
So I want to riff on that, and then I'll let Barron kind of start on that. And that is the analysis different for, say, a DEI-related review versus a news distortion review? I mean, Jerry Fritz earlier today, said something I keep coming back to, which is, Brendan Carr really believes that he's acting upon existing precedent, and certainly there have been a lot of petitions to deny transactions having to do with labor issues. And so, isn't Carr correct to say, well, if a prior FCC was able to extract conditions on certain employment practices, can't we do the same thing, just flipping it around, the other way? Is that a different analysis than, say, a news distortion analysis? Barron, you want to start with that?
Well, it depends. I mean, look, I've always been concerned about the agency's ability to regulate through so-called voluntary conditions. They've never really been voluntary. They've always been extorted. It's been a problem that the agency's been able to do things in that process that it may not have had the authority to do directly. But there's a spectrum of those things, so no pun intended. Some of those things are things that the agency could have done through regulation but chose not to, and so the problem there is that they're bypassing the normal rulemaking process and bypassing public comment and other safeguards, and they're applying a one-off rule for a particular company. That's bad. Other times the problem is the agency lacked statutory authority to do something. And so build-out requirements might be examples of either one of those two things. Those are bad. What's much, much worse is the agency doing something that's unconstitutional. That's a form of jawboning that is profoundly dangerous. So I don't really care to engage in this game that Brendan Carr is playing of saying, well, the other side did that, and so now we're going to do the same thing. These were the people, free market types in general have been criticizing this sort of regulation through extortion for many years. I certainly have been consistent in this since I started at the Progress and Freedom Foundation in 2008, and I've been very surprised to see people who claim to believe in free markets endorsing that view. But whatever you say about, again, those first two examples, the last one is really shocking, doing something that the agency couldn't do constitutionally. So the example that I would point to where that happened most clearly was the Sirius XM merger, where in 2000, 8, 2009, the agency simply sat on the application of those two parties to merge for, if I recall correctly, something like 455 days. And lo and behold, when they finally agreed to volunteer that they would set aside channel capacity on the basis of race, then the agency approved the deal. And that even for the FCC, even under that chairman, that was a look that was too gross. And so the agency was able, in some fashion, to get the parties to sort of massage exactly what they had volunteered to do. And so it was reworked to be slightly less obviously race-based set-aside. Of course, that still, I think, would not be consistent with the Supreme Court's decision in Adirondack, so it would have been unconstitutional. And Republicans were mad, right? They understood that that was, if the FCC could do that, what couldn't they do? But now, what Brendan Carr is doing is using the threat of license review, of the agency's ability to supervise transactions involving not just licenses, but authorizations, right? So this is not just broadcasters, it's a wide range of parties operating before the FCC to extort from them changes in their editorial policies. And it's the most profoundly dangerous kind of extra-legal, gangster-like regulation that you could imagine. There's just no way to defend it, and saying that other people have done something similar is just no excuse. But the problem is that if the parties are willing to agree to the deal and won't sue, no one has standing, at least as a general matter, to challenge the deal, so that slips right by. It's exactly what Commissioner Gomez was warning us about this morning, that the courts may not have the opportunity to check the abuse of power here if it happens by extortion and jawboning.
So a couple of things. One is, I wrote an article 25 years ago defending FCC merger review and how this works. And, I still believe that Congress intended these sorts of license reviews because of the nature of communications markets, where things that are not normally on the surface of antitrust are important given the nature of communications. I do think that I also would not have characterized what happened with XM Sirius in quite the same way. Again, that's fine. We have these debates before, but I would argue that what should be a limitation on the FCC's authority are the purposes of the Communications Act as well as the Constitution. The purpose of the Communications Act, which among other things says the FCC shall not engage in censorship, which has been interpreted as very much saying about specifically what you can and can't say. I recently had cause to go review the legislative history of the 1927 Federal Radio Act, and can say there was a lot of concern about the ability of broadcasters to influence what the public knows about and doesn't know about in ways that had been impossible to conceive previously. There were a lot of statements from members of Congress about this, and about the ability of political parties in power to leverage authority, and the safeguards that were supposed to be put in place to prevent that, or to prevent what they called private censorship, meaning one or two individuals being able to control what was and wasn't known. That's difficult. In this particular case, I would say, look, the Communications Act sets up certain principles. They're set up in places like Section 257B, which talk about our concern for diversity of voices, which does not just mean people of color. It means a broad and inclusive set of genuinely diverse and antagonistic views from which the truth is supposed to emerge, and that where the FCC moves to restrict that diversity, meaning telling people how they have to cover things and what they can and can't say, that is a violation of the Communications Act as well as a violation of the First Amendment. But on the other hand, because there's always another hand, there was a concern about, and we do have this idea of
news distortion, which came from the question of, well, the broadcaster just doesn't disclose that they set the whole thing up. There are, there's like one particular case that involved, we now go to a pot party where you will see, and it was staged, it was entirely staged. And that's where, there was okay, in newspaper land, there would be somebody to sue for libel. Well, here, there isn't, so we have this public interest standard that says you can't just out and out make something up that's inconsistent with your responsibility. So, I wouldn't totally eliminate the news distortion idea, but it is supposed to be a very narrowly limited one, and it's exactly this kind of, we're not going to actually do it. It's instead of saying a protection racket, say, look, when the police don't like you, and they decide to, hassle you, come in and check every permit every day, decide that fines and things that are normally overlooked are supposed to be misdemeanors now suddenly are a big deal. That's the kind of stuff that we're seeing going on here, which is extraordinarily detrimental.
I want to talk about the labor versus employment discrimination point for a minute, but also just on news distortion too. I mean, I said to people, I said to broadcast lobbyists at the time, we can debate whether there should still be a news distortion doctrine. We can debate lots of things. We might come to the same place some of the time on those questions. I just think I still, if we have one, know the difference between news distortion, which is defined as intentionally distorting the news and having some extrinsic evidence of that, versus we don't like the way you edited the interview because it made our opponent look too smart. Right? I think that the quote from the CBS, the 60 Minutes now departed chief, who I'm forgetting the name of, was like, when he was asked about this, he said, was it a lawful edit? And the answer was yes, and in journalistic terms, that means it was part of the same answer to the same question, and the two programs on CBS just chose different parts of it. So there's no way in which that can be news distortion. I kind of want to, I think I'm actually going to do this, like get a t-shirt with Brendan Carr's quote on it about not having any sway or say in the ways that newsrooms frame stories. On employment, though, we were not involved in this proceeding, so others in the room or at the dais might know more about this than I do. I don't want to oversimplify it or especially get it wrong, but I do think that the difference between standard general TEGNA, which was denied by the previous FCC, was that for the first time, to my knowledge at least in a serious way, the FCC took seriously claims about the harms to employment from consolidation. In other words, I would say they were transaction-specific or more transaction-specific claims, whether people agree with them or not, that this will reduce the amount of jobs and the amount of newsroom employees, et cetera. That's a very different theory than what I would say is more of a bank shot of, well, we don't like your DEI policies, whatever that might mean to Chairman Carr at this point. And so therefore, the bank shot being, and if you get bigger, those will be even worse, right? Like, you can make those kinds of arguments. I just think that, again, while they're maybe in the same general category, they're pretty far apart, and I don't have much trouble distinguishing between a transaction-specific claim that the merger will make things worse versus we just don't like your existing policies, and so therefore we want to punish you and not let you get bigger, because then those policies will take effect over a broader area.
Baron, any further on that?
Well, I'm reminded of what happened in 2014. If I remember the details correctly, there was an FCC process reform bill that passed out of committee in the House with bipartisan support. And I think, in fact, that even passed the House itself, if I remember correctly. That died, of course, in the Senate, and no one heard of it since. But what was notable about it was the things that were stripped out, the things that were really contentious, were, in particular, two provisions, and one of them would have explicitly limited the FCC in transaction review to imposing only those conditions that it had the authority to impose by regulation. And Democrats were concerned about that at the time. That was stripped out as one of the prices to be paid for getting bipartisan support. I'm just curious, just so I understand your thinking about this, because we have had disagreements on some of these issues, and you've heard some of those today. What do you think of that concept today? Is that something you would support putting into statute? I mean, given that the FCC's authority is fairly broad, I'm not actually sure what that would prevent the agency from doing.
Yeah, I don't actually remember the provision with that. That is to say, I don't know the wrong, but let's assume that my recollection. Let's assume somebody introduced that today as a means of saying, It's one of these things that I believe is already there in the statute, that if you put in and particularly after the charter case, which indicates that you can go back and challenge what you accepted voluntarily for the purpose of getting the merger through, that if you go back to the court and invoke, say, either the unconstitutional condition or that this was contrary to the Communications Act, that the court would say, yeah, that condition goes. You can't sneak something in by a license that you wouldn't otherwise have the authority to do. The fact is, though, as you say, what you have the authority to do by licensing is fairly broad, and I would think that it's tied to the purposes of the Communications Act. So we have build-out obligations, for example, or performance requirements, as they now call them in wireless licensing, where that's pretty clearly connected to a core purpose of the Communications Act to ensure service to all Americans. Price regulation, we promise to give a cheap service for low income. Okay, Section 1 says, at adequate facilities at just and reasonable rates. That seems to be connected. A promise to, spy on, folks where ICE, a promise to cooperate with ICE in order to, take information obtained, that is not protected by Section 222 or the other relevant sections, and to assist ICE in its enforcement of border control to expel, the alien invasion. That I think starts to become more of all right, you don't have a purpose in the Communications Act to affirmatively spy on people or affirmatively help out other agencies in what they're doing. So for me, that's kind of where you would cross the line. I would not be sorry about a provision about provided that we amend, that the additional language that we said with the provision that you're talking about is this provision shall not be construed either to expand or reduce the FCC's existing authority.
I mean, I probably have I don't think we would oppose such a condition or such a statement in a bill. I don't know that we would support it either, which sometimes feels like lawyers playing games, but I don't think it would rise to that level for us at this point. And what I would say is, not that this is necessarily a good answer to the legal question, like at Free Press, this might be one way we've differed from other public interest groups. We've tended not to support conditions. We've kind of been more in the, whether this is still popular or not, thumbs up or thumbs down camp. Let's either deny the deal or approve it. Not because there aren't some good social outcomes that maybe a government we like could engineer, and others on the other side where we'd be like, hey, we don't like those, right? Like, I think that's a kind of dangerous game to play. They're just hard to enforce no matter what they are, right? So we've tended to think, yeah, the conditions look nice on paper a lot of the time, but they're hard to assess, let alone enforce. And so, that's one reason that we have been much more in the let's have a yes or no kind of green light camp, and that colors my answer to what would I think about those conditions. And the thing I would say too, last but not least, is companies have been very much in favor of the conditions game. Maybe they, in a vacuum, rather not have to do it at all. But I remember especially Comcast in 2010 buying an NBC and saying, like, we're going to do this anyway, but we'll offer it up as a condition, and that will look good to the government, and they'll therefore give us a faster or better approval. So I think that they've been gamed for sure, not just by the regulators, but by the companies who, were put into that frame by the regulatory framework we've had.
Well, Matt, of course, you know that there is a longstanding conservative critique of trying to regulate through conditions and trying to, in antitrust cases, in general, not just at the FCC,
Yep.
trying to essentially impose behavioral remedies. I can see both sides of that, but I'm starting to understand more and more that it's not just that those are difficult to enforce, but that they're also rife with mischief, and they create the potential
Yep.
for abuse. So
I don't really disagree. Yeah, I mean,
I think that the interesting question here is just what lessons do we take away from this experience? How would we try to guard against abuse in the future?
And the one thing I want to comment on that is, oftentimes as well, a party will accept a condition assuming that that same condition will get passed down to the next group that comes in, and therefore it actually becomes a form of moat building, because they can absorb the cost of this condition, whereas their competitors in a future transaction might not be able to. And so that's, that's kind of one of the dangers I see. So, Baron, stepping off from where you just ended, I want to kind of talk about what is this going to look like? What do we think this whole landscape will look like? And all the way from what's the process at the FCC going to look like, and then what is the challenge going to look like, and then hopefully we'll end, with whether or not there's an unconstitutional condition in there. But I raised the issue on the last panel about are we going to spurn the creation of an entire cottage industry, this time on the right, which is going to go in and petition to deny every single merger, unless they get their want, which is whatever form of news slanting they want to get. Is that a real danger? I mean, I think it is. Or do we think it's only going to apply to some of the biggest transactions coming down?
In a way, you're asking one of the big questions about this administration. To what extent do they have a plan, and to what extent are they just making it up as they go? Napoleon III famously said that policy consists entirely of making opportunities. In many ways, that's I think how they operate in general. I think they have some ideas, some notions of what their plans are. They have specific goals. But the thing about merger review is it's a series of opportunities that come up. It's someone who suddenly wants to do a deal, and then they need something very badly from the agency, right? It's like going to Don Corleone and saying, "Look, my daughter's getting married. I need a favor from you." And that's how gangsters work. They control by taking advantage of that sort of opportunity, and it just falls into their laps, right? So as we talk about merger review specifically, I think it's difficult to predict exactly what this will look like in terms of what happens. But in terms of what the conditions are, I think that's easier to see. I think, and we talked about this yesterday, I think what you'll end up seeing is that there will be, as has happened at the FTC, so you have, look at net neutrality, that's another example, right, where the FCC was opportunistic in finding occasions on which to apply, to enforce, and require net neutrality as a set of merger conditions, right? They imposed those on Comcast, most notably, or Comcast voluntarily agreed to them. But they were sort of cookie cutter. They knew what they wanted, right? And the FTC has done that in making its common law of privacy and data security. They came up with a set of requirements, then they imposed those when they could in consent decrees. That's a little different. It's not a transaction, but it's similar in the sense that the company just has to agree to get out of jail, right? They have an enforcement action against them. The agency is willing to settle. They agree to something. I think that's the pattern that you'll see here is they'll try to craft what an agenda looks like and then impose it as they go. One example of that we thought we might spend a minute talking about is this proposal from Commissioner Symington and his new attorney advisor to cap retrans fees as a way of addressing big tech power. And he frames that very explicitly as being about the ideological warfare that media giants are waging against conservatives, abandoning any pretense of opportunism, and says capping retrans fees at 30% isn't just a technical tweak, it's a surgical, tactical strike on these bad actors' financial foundations. If we want a media that informs instead of indoctrinates and represents communities instead of manipulating them, we must go upstream to the funding model. It kind of tells you how they're thinking about this. They're looking at opportunities to just squeeze media companies where it hurts, where there's revenue at stake, where they have some leverage. Retrans is another example of that, kind of analogous to merger review. And they'll use that as a way of reshaping the market. So that's not a direct answer to your question, but that's how they're thinking about it.
Baron, do you think then that issue is going to come to a head in a merger scenario? That they, or do you think they're going to do that through rulemaking?
I mean, it could be both.
Okay.
It really depends, what the opportunities are before them. If they have an opportunity to impose that kind of requirement, they will.
But presumably that would only, in a merger context, would only come to play if one of the networks was going to acquire additional stations. Then, right? Because if it's I'm not sure how that would come up in a merger context.
I mean, I've looked at this a bit, and I think it was proposed 2 weeks ago, so it's reasonably brand new. Just to your main question in the beginning, will they do this to only big companies or small ones as well? I think it's just who knows, right? I mean, it's so fickle. If I recall, wasn't the Columbia penalty that Trump imposed basically identical to some amount he thought that Columbia had cheated him out of on a real estate deal, right? It's like it is government by one person's, and that doesn't mean that I think Brandon Carr or Andrew Ferguson are good actors and they wouldn't do similar things in a different regime. It just feels like if you took out the guy in the middle of it all, who knows what would happen, and with him there, frustratingly, also who knows what will happen, because once somebody does capitulate, suddenly they're okay again, right? So will he try to block a merger? I don't know. It probably depends on what he thinks of that outlet's coverage that night with a guy who obviously watches a lot of TV. I just think that, we don't know, and on the reverse retrans thing, Brand said big tech, but it's the old enemies. It's CBS. It's back to the same thing. They don't like the way that the networks, although Fox might be very different for them. We'll see how that goes. How they cover this president, and they think that the affiliates, which tend to be owned by big companies that have a more right-leaning slant, and who would, I think, very much favor this proposal, do it. I just cannot leave this topic, though, without saying, public knowledge, free press, we've never been, it's called reverse retrans, right? Like, this is the money that cable subscribers pay to the affiliate, but then the affiliate has to kick back upstairs to the network. Well, we were concerned about that before it was cool for Republicans to be concerned about it. It's just irksome now for two reasons, and I promise I'll stop. One, to see them casting this as deregulation. We were watching the investor calls last week because it was the end of the first quarter, and my colleague Derek Turner is one of the best in the business of this. We're watching what they say. Praise Chairman Carr for his deregulatory efforts, like regulating the retransmission consent fees that we pay. Okay, that's a nice trick. But two, the thing I just cannot leave this room without saying, because I think it's so important, is that this new attorney advisor, he's the chief of staff for Commissioner Symington, is, I have no trouble saying this, a white supremacist and neo-Nazi adjacent person. I don't know what he thinks in his heart of hearts, of course, but where they published this op-ed was a site called thenationalpulse.com, which I had never heard of before, maybe not surprisingly, and where you find next to the content of this op-ed links to a podcast that has the worst anti-Semitic, anti-immigrant, anti-black, just the worst content you can imagine. So this is where I'm really looking to people who, as Barron said well before, have historically been more, I think, legitimately free market, and saying like, hey, it's a confused political time, but this cannot be okay, right? Like, we have to assess these ideas on their merits, and I think that's what we're doing here. But I can't ignore where they're choosing to try to shop these and get support for them because it's that ugly.
Here,
go ahead.
All right. I mean, just a couple of things, which is, one, on the reverse retrans stuff, I have been doing this long enough that I remember back the original NASA, which was the Association of Independent Affiliates petition.
If only they'd researched the trademark.
Right, where they had raised this as a concern they wanted the commission to deal with when it was starting, that there was the whole retrans thing is itself sort of a fine example of government intrusion in the marketplace to favor one player over another player, and how all of these things are interrelated, which, Barron and I therefore draw different conclusions from, whereas I don't believe it's possible to divorce all of these things from government regulation of the marketplace in various degrees. So I think that the role is to try to get them to serve the public interest, as opposed to trying to eliminate them altogether, because anyway. But my point is, this is an issue that has been kicking around for a long time, and at one point it was genuinely tied to ideas of independence and localism, because at a time when there were a lot more smaller affiliates and the networks were using their power to take revenue, that was one set of concerns. And now
times have changed and it's morphed and it's become something different. And as always, you got to look and see what the what the reality is and whether we think the idea is a good idea or not and why. I mean, there are arguments for it now that are different from the arguments then, depending on what I would think would be passed on to consumers in terms of pricing. But I can also say, look, I don't know that retrans is going to be that big a problem anymore because, cable is dying, and part of the reason it's dying is because the people in it got too greedy, and prices started going up too high. So, this may be a problem that solves itself in a little while. I do, think that while normally I'm a big believer in public policy is not about getting people to do the right things for the right reasons. Public policy is about getting people to do the right thing for their reasons. I do have to say that, at some point the motivations become very, very concerning, because the fact that that's the plan means that there's an intent to do things with this which are going to be very harmful. And one of the things that what Matt's talking about in terms of how the idea is presented and where it's presented and what it's about suggests very selective enforcement in favor of one particular set of stakeholders who we like as against another set of stakeholders who we don't like. And that, for me, is toxicity. I mean, the rule of law is critical and is a necessary part of what makes this not a protection racket, not tyranny, is the idea that there are bounds that are set by the rule of law. And the fact that we have reached a point, not just in communications, but more broadly in society, where the rule of law is replaced by the rule of me and I am the law, is profoundly troublesome for any notion of rational regulation.
I want to express some sympathy to Harold and Matt here, because in some ways this must be much worse for them than it is for me, in the sense that they...
Yeah, you get to say, I told you so, so I'm not...
Well, that's not what I was going to say, but that's sort of what I was going to say. It's sort of a shorter version of what I was going to say. I mean, what I was going to say was something more like, I've always been profoundly skeptical of the FCC and whether it's a good idea and the powers that are given to the agency. And I, really would prefer that we don't have an FCC. I don't think having a specialty regulator for an industry that is increasingly less special is a good idea. Now, I would even there, I'd recognize there are some things that are still special about the FCC, and those are specifically about public safety, right? Those things I think we could have a separate conversation about. But about this general stuff, about merger review, for example, that, unless it's about public safety, I don't see why we have a special purpose regulator getting involved in that. I don't see why we don't leave this to the antitrust laws. And so I don't mean this in a condescending way. I mean this quite sincerely. I think it's harder for someone who doesn't have that view, who really wants there to be an FCC and that you want to have broad discretion given to the agency. I think it's harder to know how to respond to the current circumstance, how to rework the agency's powers. I would suggest that one way to think about that, one big question going forward, is what will the courts do with the unconstitutional conditions doctrine? Because if the courts are willing to apply it in a more robust way, I think it becomes easier to defend having an agency that has this kind of broad discretion, because the courts will provide some clarity. And I think it's worth just spending a minute here talking about that doctrine. I spent a lot of time before this event trying to synthesize the doctrine, trying to get the law professors who have written about this to speak, to join our discussion, because it's clearly part of this discussion. It was implicit in the previous discussion about broadcast licensees, and it is very much what we're going to be talking about next, about the proposal to reinterpret Section 230. And in general, the question is, when does it become unconstitutional for the government to not require a private party to do something, but to say that if they want X, then they have to do Y? And the bottom line, having looked at about 8 law review articles on this topic, is that the doctrine is a mess. I mean, truly very deeply confused, and understandably so in some ways, because it has to deal with a very wide variety of circumstances. Sometimes it's about approvals for a license transfer. Sometimes it's about spending money. I mean, clearly, for example, if the government wants to spend money on encouraging development aid in the rest of the world, and it wants to limit how that money is spent to prevent that money from being spent on contraception, that's the kind of thing that the courts have upheld. Conversely, where the issue is, for example, whether the League of Women Voters can engage in direct political advocacy, what the courts have said, essentially, is that you can limit the ability of a nonprofit to get a tax-exempt status so that its donors get tax deductibility for their donations. A C3 can get those in exchange for not getting involved in direct electoral activity, provided that the same entity can easily set up a sister organization to do the same things, right? So you're not restricting the organization's ability to speak and to get involved in politics, but you're regulating the structure of how it goes. This just gives you a flavor of how the unconstitutional conditions doctrine has been developed. So Mitchell Berman, I think, wrote the best article on this that tries to synthesize this. We were hoping to have him here today, and it didn't work out, but he boils this down to the following, and you'll see why this is sort of unsatisfying, but he says, to distill his entire article, he says, a given conditional offer, like any type of government action, and that I think really is actually the key to that concept, that it's not different from other forms of government action, that any conditional offer may be unconstitutional because of the state's purposes for extending the offer, or because of the offer's consequences, or the combination of the two. And a conditional proposal is at least presumptively unconstitutional if it violates some particular constitutional provision, principle or provision, by reason of its purpose or its effects, or if it constitutes coercion. Now that's a lot, right? How do you exactly operationalize that? It's going to depend on how the courts apply this case by case. And I think one thing I can say with great confidence is this is going to get litigated intensely over the coming years. And we're seeing this happen again and again right now. This is exactly what's happening to universities, for example, where their continued support from the federal government, whether the science lab at Duke University is going to be funded for medical research becomes dependent on whether the university plays ball on substance, on how it educates its students, right? So there's going to be a vast range of these cases that get decided. And I'll just boil this all down by saying I'm reasonably optimistic that what the courts will ultimately conclude here is that ultimately these, if they're coercive, if they're truly coercive, that they're no different from a regulatory mandate, and the same basic principles apply. And I think, to bring that back to our topic today, if what you're ultimately doing is trying to change how the holder of a license or an authorization exercises its editorial judgment, I think the courts will see through that and will recognize that that's different from saying, well, the government can limit how it spends money to not supporting abortion, but that is simply a way of coercing a change in behavior. I think that's what the courts will ultimately say. I don't have a lot of confidence that all of the courts will say that. I think Fifth Circuit and other judges that are sympathetic to this administration have enough room in the existing doctrine to say, yeah, that's no problem. That's like the kinds of conditions that have been upheld in the past, because the doctrine is legitimately messy, and it's up to the Supreme Court ultimately to clarify this.
Barron, isn't one of the prongs of that as well, though, that you do have to look at what is the public benefit? I mean, is it just a cool benefit like money, or is it something required for you to exist? I mean, isn't that factored into the analysis as well?
Absolutely. I mean, you get back to the simple example of the 501c3 and the 501c4, right? In that particular case, you weren't putting the League of Women Voters out of business, right? They could continue to function as a 501c3, and they could set up a separate entity to engage in as much electoral or political activity as they wanted, right? I mean, I think that sort of answers your question. I think that's where the courts have drawn the line. Here, when we're talking about licenses and authorizations, we're talking about the death penalty.
Right.
If you don't do what the government wants, they will, in a corporate sense, kill you. That if that isn't unconstitutional, then the doctrine has no meaning.
I just want to say, look, the doctrine, if I remember correctly, actually arose out of
cases in the 1950s and 60s when there were in professional licensing cases where you have to pledge you've never been a member of the Communist Party, and then you went and said something that they didn't like, and they say you're a communist, so we're going to pull your law license or whatever. And that's where, as Barron was saying, look, where it's effectively a death sentence, terminates your opportunity to do something, as opposed to the subsidy cases, which again have gone kind of around back and forth. They're not clear, but the notion of if you don't like the condition, don't take the money. If you don't want to build out, don't take USF funds. So I think these things will play more of a role. I think the danger and where I would want to fix things is when you get to invoke your rights. This goes back to what we were saying at the beginning about using threat, using a refusal to decide. A number of us tried to push many years ago, because part of the problem was you'd have a bureau decision and get appealed up to the FCC. The FCC would not make any decisions on it, and you couldn't go to the Court of Appeal until the committee, and it just died. We were like, okay, deemed denied. If X amount of time passes and you are not, they don't make a decision, then it is deemed denied and you're allowed to go up and have a court test this. That's where I would like to see a change around this, and where alternatively, where you would have a greater latitude, where you are under threat to seek an advisory opinion of the court. And I know we have Article 3 problems around this, but where you're, or to somehow make it easier to say, the fact that this is a very explicit, we're waiting for you to comply with our will, but we're not, and we're going to keep you under a cloud. Create an ability to challenge that and require that the agency bring something or not bring something, or show that there is an actual investigation that is ongoing.
Shot clock?
Shot clock, but enforceable shot clock, and through the mechanism, as I say, of not deemed granted, but deemed denied.
I mean, I bought my first house on the back of mandamus petitions I filed with the D.C. Circuit at the end of every year when the FCC wouldn't act on MCIs.
See, I was only an associate, but I told them not to do them because they were never granted. So, yeah, that was against self-interest. I don't know if we're up against time. I have a few quick points. I don't have any great closing, but just a couple things to go back to what Barron was saying too, and some of the stuff Harold said. I mean, for one thing, one of the problems with this, the government's allowed to fund what it wants, but can't tell you what to do with non-governmental money things, is money is fungible, right? So I think Barron said it well. If it's sort of a death penalty for a non-profit or a for-profit, that's a hard thing to suggest. It is unrelated to your activities outside of the government money. On the antitrust point, I can't resist telling this story. One time, when I tweeted and wasn't quitting Twitter, as I have now done, Barron wrote back to me when I said something snarky about antitrust, like, what was your antitrust grade in law school? And I tagged in my professor, Einar Elhage, who did not respond, so that debate ended there. But what I wanted to say was,
sorry.
It's fine, hey, we've grown. Maybe, yeah, sometimes, every once in a while.
Jury's out.
We're offline.
Yeah. What I would say about dual review of antitrust, or of deals, whether it's antitrust or not, is one of the reasons I would have pushed so strongly for that 15 years ago was we were in a time of not just, I would say, Chicago School of Ascendant, but basically unchallenged in Obama days, and now we have a very different environment. So I'm not going to sit here and say, here's what I think going forward today, but that has continued to evolve, where I do think we have, whether they're well-motivated or well-reasoned or not, a much different antitrust environment than we were in at the time I got into the nonprofit side and started challenging deals based on the public interest standard. Two more quick things. The thing about the I told you so, it doesn't sting me as much because I think we busted so many norms. And so the fact that we now have, the same guys, right, Symington and Wax, are talking about, we want to doge the FCC and nowhere is it needed more. Like, they're talking about efficiency, but really what we're seeing is nothing but stripping out protections and the rule of law so people can steal more money for themselves. It's about that simple for these guys. And I think we've gone beyond the parameters that maybe we could have expected would be abused, but I think the I told you so there is, again, doesn't sting me as much because I don't know who could have predicted this. Last but not least, the broadcasters, if they're not different from others, this is not a retort to Barron, it's to them. If they want to keep arguing, hey, we're no different than other big media companies, we don't need an FCC anymore, we're not so special, well then why do you have exclusive right to speak on 6 megahertz of increasingly, I would say of diminishingly important value, but still important. So I mean, I think that's the question we have to
Enough
answer.
you want to keep it, you know.
Yeah, well they need it, they say, so exactly.
As I've said, there's still scarcity until I get to build a television station in my backyard.
And they
or-
still want the benefits of that without the obligations of it. I think that's the real question
But
too.
also, I'll just take one real quick thing. 2 things in addition to unconstitutional condition, Bill of Attainder, and oddly enough, for odd clauses of the Constitution for 500, corruption of blood, by which I mean chasing you to punish you in your various, descendant corporate or because of your relationships with other things, kind of all of the things that, were put in the Constitution because we'd seen them happen. And while I don't necessarily subscribe to the corporations should be treated 100% as people, there is a certain extent to which, I'm going after you because I don't like you, Bill of Attainder, or I'm going after you because you helped out somebody else and therefore you have a corrupt relationship, which is the corruption of blood idea. I think those should get more play. And I know it came up in at least 1 or 2 cases that have been pressed so far where the court just said we don't have to reach that. But I think we really do have to start reaching that, and they ought to be, much more prominent now.
Well, Harold, I think you win today. That I had not thought about that term before, but you're absolutely right. That's 100%. What they're doing, and I opened yesterday by quoting the former dictator of Peru, who famously said, "For my friends, everything; for my enemies, the law." Right? That's exactly what's happening here, and I think I'm just invite all of us to think really hard about where we go from this. I don't really think we can count on the courts to fix all these problems. I think that part of what has to happen here, if there is to be a rebuilding, if there is an opportunity for that, is a really systematic rethinking, right, in the way that there was after the Nixon administration, where there was an effort, like the Church Commission, most famously, to try to rethink, what happened. We had the Privacy Act of 1974 because of that experience. And you've identified just an example of something outside the Communications Act that we should be thinking about. One of the problems with challenging the inability of or unwillingness of an agency to make a decision about a merger is that the APA says it's only final actions that are reviewable, right? I mean, what is a final action? Should that really be the legal standard? I think it's probably time to go through the kind of rethinking that not just happened after the Nixon administration, but happened in the 1940s in the lead up to the APA, to start rethinking these basic precepts of administrative law. We at Tech Freedom, we often quote Hayek, who famously to us, you've probably never heard this. Maybe at CEI you have, but Hayek said that it was in the inner workings of administrative law and those hard legal questions that the fate of our liberty is being decided. And it's things like this. Will the courts have an opportunity to decide a case or not? And some of that's judge-made, standing doctrine, for example. Some of it is statutory. And I think really that's what we should be investing in now, and people who might disagree about how the FCC should operate should be really engaging hard in those questions so that when there is a process reform act that's put forward next time, that it's really well thought through and it doesn't have the heart cut out of it in order to get enough votes to cross the finish line.
Jared, how are we on time?
We should
wrap up? Okay. So, and give quick last words down, or have we?
I've said mine.
I'll say one last thing as my last words, which is one of the things that makes this very hard is that the FCC is an agency that is actually designed to push past market rationality in the name of valuable, what we would call the social contract. Public, economics drives network deployment.
we decide we actually want all Americans to be connected to our telecommunications network. We create an agency whose job is to say we know the private investment covers this much, and therefore we're going to have to come up with a way to cover the rest. It is a question of, we have an issue of in electronic media. We have a concern that an informed electorate is necessary for a true democracy. We have concerns that there are media markets that are so small that they escape traditional merger review. There are a lot of places where the merger of all broadcast outlets still would not amount to a monetary requirement to inform the antitrust agencies under Hart-Scott-Rodino, but nevertheless, it's critically important to the people who live there. So the FCC is designed as a very strange agency that must, in order to fulfill the social contract, go outside the bounds of market rationality and do that which we think is necessary in the public interest. That, of course, is the danger that it will be perverted. It is a risk that I don't see any way to avoid unless we're willing to start sacrificing people, Well, to conclude with, it presents us with this choice. Do we want to take the risk in order to preserve our social contract as a nation as a whole, or are we willing to cast off those whom the market casts off in order to preserve the freedom of those to whom the market will serve?
Hard to follow both of those. Just a slightly different tack, and I'll try to be quick here too. It's small bore, but I think it leads into the bigger question. Representative McClellan, I believe, on Energy and Commerce, a Democrat, has now twice offered amendments that would prohibit the FCC from weaponizing its public interest standards and other apparatus to go after political opponents or viewpoint. That's been not just roundly voted down by the Republicans on that committee, but they were even questioning whether they had jurisdiction over the FCC in that regard the other night. I was not watching this in real time at 2 a.m., but this was happening in that marathon markup they had. So I think what we see there is, and we've tried to fight against this. We've worked on surveillance reform. You have a lot of people in this town, and we said this earlier, who, it's not just on one side of the aisle or the other, change their opinions based on who's in power, and we have to guard against that. And what I would say about the big picture here, Harold had a hopeful if challenging note. I'm sort of heartened by the fact that people are talking about, post-Nixon and even Reconstruction I've heard thrown around. I'm not that optimistic right now, I have to say. I just think we haven't talked much about the firings at the independent agencies and how Republicans used to criticize the administration for running the FCC, supposedly. Now they're gleefully saying, please tell us what to do and fire our colleagues. I think one of two things. Republicans who are not just okay with, but are cheering the firing of their now minority colleagues, either think Democrats will never do to us what we did to them, or they think elections, maybe we won't have them again. And I hate to be so dour. Obviously, I don't really believe that's likely, but I think the fact that it's on the table is pretty frightening, and it speaks to how much power these guys wield over mergers. But obviously, these are much bigger questions we're facing right now as well.
So short coffee break, and then we'll come back with discussion of the. Actually, we're gonna, if it's okay, we're gonna do the coffee break after the next panel.
Right.
So we're gonna go straight into will the FCC's rule violate the First Amendment? You might be sick of me, but I'm still going to be here, and Jen's going to be moderating this panel. Thank you.
The third possibility that's depressing, which I agree with. Now that we control the judiciary, we don't.
My name is Jennifer Huddleston, for those of you who don't know me, and I am a senior fellow in technology policy at the Cato Institute. Our panel today is going to discuss the FCC's authority over internet services, and particularly this panel will be focused on the constitutionality of reinterpreting Section 230, as was discussed in the NTIA's 2020 proposal as to what the FCC might do next. But before we turn to our excellent panel of experts, we're going to start with a couple of videos, beginning with a video from Professor Eric Goldman on why Section 230 is better than the First Amendment.
Hi, my name is Eric Goldman, and I'm a professor of law at Santa Clara University School of Law. And I'm sorry that I can't be with you in person, but the organizers have asked me to discuss the interplay between Section 230 and the First Amendment. Section 230 was enacted as a statute by Congress in 1996. And to summarize it very efficiently, it says that websites aren't liable for third-party content. That basic rule has been the foundation of the modern internet. The user-generated content services that we enjoy every day, multiple times a day, many times an hour, are all predicated on the legal rule that's established in Section 230. Section 230 doesn't delegate any rulemaking authority to any agency. It doesn't provide any authority for the FCC or the FTC to specifically interpret it. Section 230 is what I call a speech-enhancing statute. What I mean by that is it's a legislative attempt to supplement the constitutional protections that are already part of the legal baseline. Section 230 in that respect then extends protections for speech above and beyond the constitutional minimum or floor. And there are a couple of implications of a speech-enhancing statute like Section 230. First, it can provide greater substantive protection for content than would be required by the First Amendment. So I'll give an example of commercial speech. Commercial speech receives First Amendment protection, but it's subject to a intermediate scrutiny as opposed to the highest level of protection under strict scrutiny. Because it receives intermediate scrutiny, there are many regulations of commercial speech that are permissible under the Constitution. Section 230, in contrast, doesn't make distinctions between commercial and non-commercial speech. Its rule that websites aren't liable for third-party content applies whether or not speech would be characterized as commercial. And so in that sense, it provides legal restrictions on liability that are not required by the Constitution, where the Constitution would have allowed that commercial speech to otherwise be regulable. Section 230 also has a judicial administrability benefit. In a sense, it's a set of procedural benefits that are not required by the First Amendment. And sometimes I'll call those procedural fast lanes. They're designed to expedite the resolution of cases, especially when the outcome would be clear, compared to how the procedure would work under constitutional litigation. So because it's a statute that has a clear rule, websites aren't liable for third-party content, Section 230 provides quicker resolution of litigation over third-party content with greater predictability to the defendant. What that means as a benefit to the defendants is that it reduces their defense costs, it reduces their incentives to settle cases that they would otherwise win, and perhaps most importantly, it allows them to stand up and stand behind content that comes from third parties that otherwise they would remove in the face of legal threats. So it allows more legitimate content to remain online. And those benefits I described are actually a subset of the overall principles that are sometimes described with the term constitutional avoidance. In general, courts prefer not to interpret the Constitution where they can avoid doing so. And there's some really good reasons why. First of all, constitutional doctrines are generally indeterminate. There's lots of nuance and complexity to them, makes it harder for everyone to resolve. But more importantly, if the court gets it wrong, it's extremely difficult for legislators to fix. They'd have to amend the Constitution, whereas with the statute, the legislatures can superintend the judicial interpretations much easier. And so as a result, judges would always prefer to have a statute that they can interpret rather than turning every litigation into a constitutional battle. So because of the substantive benefits of Section 230 and its procedural benefits, any reductions in the scope of Section 230 are likely to have profound implications for speech online. And I don't believe that the First Amendment, acting as a legal backstop to fill in any reductions in Section 230, will lead to the same kind of beneficial outcomes that we currently enjoy today. Sorry again, I couldn't join you in person. Thank you for the opportunity to share these remarks.
Context for this. So the purpose of that introduction is to explain what's lost if you change Section 230, because if you don't understand how Section 230 interacts with the First Amendment, it's hard to see what was really at stake in 2020 when the Trump administration proposed that the FCC reinterpret Section 230 to narrow its protections. So I just want to briefly survey what that proposal said. Now, we don't know that that's exactly what the FCC will do now, but that proposal is still live. That docket was never closed. Presumably what they're going to do is going to look like that. So it operated in a few steps. So first of all, there are 3 immunities in the statute. C1 is the one you've probably heard about. It's the 26 words that created the internet, as Jeff Kossoff put it. C1 says that no provider or user of an interactive computer service may be treated as the publisher of content provided by an information content creator. So that's the case, the provision under which 98+% of cases are decided. That provision has been blamed by Republicans for so-called censorship. And so what they would do in step 1 would be to say that that provision would no longer protect content moderation. The only protection for content moderation would be the second provision, operative provision in the statute, which is C2A. C2A says that if you operate in good faith and voluntarily to restrict access to a certain enumerated list of kinds of content or content that's otherwise objectionable, that then you would be protected from immunity. But you have to prove that. That's not an immunity that you can generally, and certainly not in this conception, that you could use in a motion to dismiss, that you could use easily. So step 1 is C1 doesn't protect content moderation, only C2A does. Step 2 in the proposal is C2A would be narrowed, specifically by saying that the term otherwise objectionable should be construed very narrowly, essentially only to be interpreted with reference to the enumerated categories. So it would very intentionally exclude things like moderation of hate speech, misinformation, calling transgender people it, for example. Those things could be subject to suit. And in that sense, 230 would become no longer content neutral in its application to content moderation. Third, the proposal would reinterpret the term good faith to require many things, but basically neutral or unbiased or consistent content moderation, common carriage, effectively. And then, most importantly, C1, again, the provision that protects an ICS provider that is a website operator from liability for content that it hosts, that would no longer apply when that company, quote, actually publishes its own or third-party content. In other words, you would lose protection, not just for content moderation, but for hosting content if you actually publish it. Actually publish would mean that you have some sort of discernible viewpoint. In other words, if you're biased or unfair, you could be sued not just for moderating content, but you could be sued for all the content that you host. So that's the setup. That's what the rule proposed to do. There were very few, frankly, substantive comments filed back in 2020, but the best of them, I think, was filed by Dan Lyons and Christopher Terry. They couldn't be here today, so Professor Terry is just going to give us a little summary of his objections on constitutional grounds to what the FCC was proposing.
Hello, I'm Christopher Terry, an associate professor and Coles Fellow of Journalism, Policy, and Law in the Hubbard School of Journalism and Mass Communication at the University of Minnesota. Today, I've been asked to respond to the question, would the FCC's 230 rule violate the First Amendment? The simple answer is it doesn't matter, because after the Supreme Court developed the Major Questions Doctrine in West Virginia, the full adoption of the major questions doctrine in Loper-Bright, and the recent Sixth Circuit decision in Ohio Telecom, which applied the major questions doctrine to the FCC's 2023 actions on net neutrality. The agency clearly does not have the authority to do what it seeks to do. The agency certainly cannot interpret its way to ancillary authority without a lengthy legal battle, nor with any reasonable anticipation of success. That said, on the First Amendment question, the answer is yes, it would violate the First Amendment. The FCC should not, and at least currently legally cannot, be in the business of regulating internet content, despite Chairman Brendan Carr's longstanding desire to do so. The original 2020 NTIA petition to the FCC on Section 230 asked the agency to reinterpret the 26 words that created the modern internet, stating that Section 230 should not protect internet platforms that do not take down third-party content when someone objects to that content. The NTIA argued, under defamation law, failure to take down that content means the internet platform is acting as a publisher, not as a conduit. While this argument was focused primarily on defamatory content, it presumably would appear to apply to other forms of presumably objectionable content as well. Relying on subjective standards, like otherwise objectionable, the petition proposed the creation of a compelled speech mandate on platform to impose transparency in a content moderation decision by a private platform, similar to what the court remanded in the net choice cases just last year in challenges to the Texas and Florida social media laws. Section 230 itself was added to James Bluebinder of Poor and Exons Communications Decency Act following a pair of conflicting decisions over platform liability in the 1990s. Now, almost 3 decades later, Chairman Carr's chapter in the Project 2025 document detailed his desire to see the FCC eliminate immunities that courts have interpreted and added to Section 230. Friends, that would be decisions as far back as Zoran's challenge of AOL. Yes, really, America Online. That's how long this has been going on. And those cases have included cases in every federal circuit court. Such a to overturn would be no small task and would require a significant effort, even if it were constitutional. So I thank you for the time. I leave you with just 2 major parting thoughts today. First, a large amount of the debate over Section 230 reform is intended to get rid of speech that people object to for various reasons. But the FCC solution is about the worst idea I can imagine from either a legal or policy perspective. Call it whatever you want to, but implementing a fairness doctrine for the internet is crazy, but only half as insane as assuming the FCC could even hope to enforce a mandate like this. Even if you buy into the inexplicable desire to give the FCC, an agency that once went off the rails to enforce barely a half-second of video from the Super Bowl halftime show, the subjective authority to regulate online content and compel speech, remember that the speech in question is also likely protected from state action by the First Amendment. It gets you nowhere. Second, we know empirically what happens after we alter the formula that Section 230 has provided for internet speech since the decision in Reno. The first legal modification to Section 230 came in the form of the FOSTA bill in 2018. Modification to the secondary immunity provisions in 230 resulted in a large amount of constitutionally protected speech being taken down for fear of state action and enforcement, while the legal issues were resolved in a lengthy court battle. We know 230 reforms, absent a new solution to protect online expression, results in infringement for the simplest of reasons. We've already tried it. I thank you for your time today and the opportunity to submit this short video. I hope that you enjoy the rest of the conference. Thanks for your time.
It's quite a robust conversation. This panel is going to focus on the questions related to the First Amendment. I believe in the next panel regarding FCC authority over tech companies, there will be more of a discussion of how things like Loper-Bright and some of the other administrative law actions may come into play here. I'm joined by a great panel, as I mentioned. Starting to my immediate right, we have Ari Holtzblatt from WilmerHale. Then we have Enrique Arnillo from Elon University School of Law, and of course our wonderful organizer, Baron Soka from Tech Freedom. So to start, Baron, you gave us this great overview of the rule that was proposed in 2020, and of course there's not necessarily a full knowledge of what a potential FCC rule on Section 230 would look like, but that seems to be the general consensus of what would be used as a starting point. You mentioned that one of the things that this proposed rule does is attempt to narrow the application of otherwise objectionable to be something very narrow. This is an idea we've seen put forward by people like Adam Kandub and even Eugene Volokh, that concedes that this would not be a content neutral restriction, they argue that it would in fact be viewpoint neutral, even though it was context based as a speech restriction. So my question to the panel is, are they right? Has social media become the new public forum? What has the Supreme Court said on this?
Thanks. I'm happy to jump in on that. Again, Ari Holtzblatt at WilmerHale. I think that notion that that online platforms are a public forum and that can be regulated different than other private actors may well have been an open question at some point, but I don't think it is an open question now, following the Supreme Court's decision in the Moody versus Net Choice decisions, where the court applied strict scrutiny to indicate that at least certain applications of a Texas law that sought to regulate content moderations on the platforms was subject to First Amendment scrutiny and a normal speech restriction. And what the court decided in that case is that content moderation, like other forms of curation, is classic protected First Amendment activity, and that, I think, is a conclusion the court could not have reached had it thought that online platforms are any kind of forum that would be sort of subject to special rules. So I think under that holding, I think this view that you could oppose a content-based restriction or make differential treatment for the platforms in a content-based way can't hold up. Now, the separate question would be: is this a content-based, or is this a differential treatment on the basis of content? And I think that really is sort of, at least with respect to that proposal, the effectively elimination of the otherwise objectionable catch-all from Section 230C2A that's clearly a content-based restriction or a content-based treatment of the protection afforded by Section 230. The other categories of speech at issue in Section 230C2A are obscene content, lewd content, lascivious, filthy, excessively violent, or harassing. Those are all content-based characteristics, and so you're essentially saying to the platforms, you can receive protection if you restrict certain categories of content. You get no protection if you restrict other categories that you consider to be objectionable. That's a classic content-based or differential treatment. So I think at least under the Moody decision, it'd be hard to see how this would not be an unconstitutional, or at least a restriction that would subject the rule to strict scrutiny.
Just briefly, the court addressed this even more clearly in the Halleck decision, where the issue was about public access channels. And the court said very clearly that a private entity that opens its property for speech by others is not transformed by that fact alone into a state actor. And so such an entity still enjoys the right to editorial discretion. This is just very clear. So I just want to reiterate how significant this is. The general counsel of the FCC, who drafted this petition, Adam Kandub, right, admits that this is a now content-based distinction. That he would be, by virtue of this interpretation, that he would be converting Section 230 into. He admits that it's content-based, and his only hope for this to survive is to claim that social media services are a public forum, which they're not. So that just as a legal matter, that is dead on arrival. But that's not the only part of this proposal, right? I mean, that's just narrowing the application of 230C2A. Even if you take that out, shifting the coverage of 230 from C1 to C2A for content moderation is a radical transformation, right? It takes a statute that right now is interpreted by the courts consistently as an immunity, not just against ultimate liability, but an immunity against suit that can be easily invoked on a motion to dismiss without getting into hard factual questions. That's the state of the law today. It transforms us from that into something that becomes very difficult to use, because C2A says you have to show that you operated in good faith and that you acted voluntarily, right? Both of those are factual questions that are now intensely in dispute. And if you were paying attention yesterday, for example, to our discussion about the FTC and the current request for information that the FTC has pending, one of the big questions they ask is this really voluntary? Are tech companies being coerced? You can always make an argument that someone is being pressured to do something. Oh, the advertisers made them do it, the Biden administration made them do it, et cetera, et cetera, et cetera. So you've now converted that into a very difficult question that would come up in every litigation over every content moderation decision, even before you get to good faith. And the voluntary thing wasn't even proposed in the 2020 petition. That it doesn't have to be, right? Once you switch the emphasis to C2A, that becomes a question that would have to get decided on every motion to dismiss a lawsuit. It would be very difficult to do so, and so the statute would be far less useful and would no longer operate at scale.
Enrique, I want to make sure you get a chance to speak on this as well.
No, this has been great. I want to start with prediction, so that's always dangerous, but I think it might narrow the scope of the conversation, and I think it's also a note of optimism for myself, certainly, and I think it's fair to say most of the people in the room who think that 230 is a good thing, and that is that any prospect for legislative reform of Section 230, regardless of how bipartisan that seems to be, regardless of how many articles come up on my Google alert about it, I think are dead on arrival. And the reason for that is a pretty straightforward reason, at least in my mind, that I'm certainly open to rethinking, and that is that the person who would have the most to lose is Elon Musk, and Elon Musk sits at the right hand of Trump, who of course would have to sign that. So I do think when we're talking about Section 230 and what it means and what it might mean, we are talking about reinterpretations by executive agencies. And that's why I do think the next panel is probably at least as important as this one with respect to the consequences of the things that we're talking about here in this part of the program. Now, with respect to the petition from 2020, the idea that platforms and websites have to moderate or would be required to moderate in a, quote, viewpoint neutral way, I think enough has been said about that, that the non-neutrality is a constitutional requirement under the First Amendment. It is a constitutional prerogative. Platforms do not need to be neutral. They have the First Amendment right to do that in the same way that any of us have the right to not be neutral if we choose not to be. So I agree with what others have stated, that is essentially a non-starter, and it's certainly, that conclusion is certainly affirmed by the net choice case, which has really, I think, pulverized the idea that was put forth by a former friend of mine, Andy Oldham, the idea that censorship is somehow different from speech when a platform engages in it. The thing that I think that has gotten a little bit less attention, and Barron mentioned this idea of what the FCC might say that good faith in C2 means, the part of that would require platforms to provide some set of process-based rights to users before they take action on user content. And I think one thing that I really want to put as fine a point on as possible is that government-compelled reason giving is a form of must-carry. So when the government tells platforms that you have to give your users this set of rights, that is a form of must-carry. And why is that a form of must-carry? Because the remedy is replatforming of the user, right? And replatforming of the user is a violation of the platform's rights of speech and association. And we've seen this in the EU replatforming cases involving far-right groups, members of far-right groups who get kicked off of platforms. And I know we're not here to talk too much about foreign law, although it's come up a couple of times, but under lots of different bodies of law, under domestic European law, DSA, which Barron was talking about yesterday, GDPR, these courts that are applying those laws are saying that users have a right to be replatformed if they're not provided sufficient process with respect to the takedown decisions of the platforms. And that, I think, is what one of the things that this petition was trying to get at. That is a direction that this could possibly go in. And I think we really need to work hard on articulating the theory about why that government-compelled, reason-giving obligations on the platforms, why that, too, is a First Amendment problem.
Well, I want to respond to that, but I want to note here, so guess who said this? In enacting Section 230, Congress never intended to provide immunity only to websites who are neutral. It sounds like the kind of thing that some crazy Democrat would say today, but that was Cathy McMorris Rodgers back in 2019, before the Republican Party came out and said the opposite. In other words, this is not some sort of, crazy left-wing plot. This is what Republicans used to say before the administration changed its tune and decided that Section 230 would be a way to try to obscure the First Amendment implications of requiring neutrality, right? They understand that what they're effectively arguing for is a new fairness doctrine, and to make it seem less obvious, they're just trying to tie it up in Section 230 to essentially launder their censorship. Now, what do we think about the example that Christopher just raised? I mean, I mentioned this point yesterday. In some ways, the kinds of process-based concerns, if you will, due process protections that you see in the NTIA petition, if you just stepped outside of the context of the U.S. legal system, they're not unreasonable at all. They're in many ways, they're exactly what the European legislative process put into the Digital Services Act. And again, if you want to look at this at home, just look at Article 14.4 of the Digital Services Act, which says, for example, that decision-making should be non-arbitrary. It has ideas about consistency. It should be non-discriminatory. You should have to give reasons for your decision-making. You should have an appeals process. I mean, these are all the things that are essentially being said now in the NTIA petition, and that some people have proposed in legislation. But the right question to ask is not, are these reasonable ideas? Because I think in large strokes, they are actually reasonable ideas. The right question to ask is not, are they reasonable in the abstract? It's what would they mean in practice in the United States legal system, given that most of us don't live in Europe, and this is not, this is a very unique legal system. In the United States, we have the most hyper-adversarial legal system in the world. And in the United States, the legal system becomes the punishment. So you can take an idea that seems reasonable on its face and implement it and wind up with radically different consequences from what you would have in Europe. So something that in Europe, under the Digital Services Act, wouldn't be that big a deal for a company to implement, in the United States becomes a way of breaking content moderation together. That's plainly what's being intended here. And you can see that by them picking winners and losers. They want certain kinds of content moderation to be fully protected by at least C2A, and other forms of content moderation not to be protected at all, because the goal here is to open up the floodgates of litigation, right? So the best line about Section 230 was Alex Kaczynski, who was once shortlisted for the Supreme Court as a Republican appointee. In one of these landmark 230 cases, he famously said that the 230 immunity must be interpreted broadly, because if you don't, you open the door to websites dying death by 10,000 duck bites. That is exactly what this proposal to reinterpret 230 is intended to do, and that's why it's an unconstitutional condition, because it is intended to be coercive. It takes a liability protection without which websites could not operate in the United States, and it makes that conditional upon those websites doing what the government wants.
So I think it's safe to say there's general agreement on the panel, and I am going to presume in the room that FCC rulemaking on Section 230 would raise First Amendment concerns. And we've discussed how it's unlikely that we would see congressional action on 230. There's, of course, a kind of major questions doctrine and has the agency been correctly delegated to that? Any of our panelists are welcome to comment on that. But when we talk about this idea of conditioning the eligibility for immunity, is that something that the panel feels imposes an unconstitutional condition? And if it does, why does it impose an unconstitutional condition? How should the courts consider that? Should they be looking more at the motives of the FTC, or should it be more the effects of this rulemaking that matter?
It can be both.
It certainly can be both. I'm going to start with Enrique, since you went last time, to let you get the first word in.
Well, I mean, it's obviously, platforms don't have a constitutional right to a statutory immunity. I mean, I think that's clear. But what they do have the right is to be free from viewpoint discrimination, right? So that's why the motivation does matter. And we've been talking for a couple days now about, asking the question, what is this? What is this request for information from the FTC? What is this NewsGuard letter from Chairman Carr? One of the things that those documents is, or one of those things that each of those documents is evidence of viewpoint discrimination, right? And there was a time in the development of the First Amendment where the court said, well, you might remember U.S. versus O'Brien, where David O'Brien says, look, there are people on the House floor saying that this amendment to the draft card destruction statute was intended for people like me, hippies that were anti-draft. They were coming after me. And the court says in O'Brien, well, we can't look at that. We only have to look at the text and the structure. That is not evidence. That is extrinsic evidence that cannot be submitted in support of a viewpoint discrimination or a content-based discrimination claim. That's not the law anymore, right? We have from no greater defender of the First Amendment than Justice Thomas, who writes an opinion in Reed versus Town of Gilbert that says, if you can have a law that makes no reference to content on its face, if that law has a content-based purpose, it is going to get strict scrutiny. These documents that these people are making that we just read and, it's virtue signaling in search of a legal theory, right? We're not really sure what to do about it yet because there's no, it's only requests for information. I guess we'll talk more about what it actually is in the job owning panel, but it is setting the record for the motivation of the condition. And I agree with the point that if a motivation of the condition is viewpoint discrimination, then that can give rise to an unconstitutional condition.
Or content discrimination.
Aaron, do you want to go ahead and jump in? Did you have more you wanted to say on that regard? No? Ari?
Yeah, if I could just say one more thing, sorry, Ari. If I could say one more thing about the letter, and I think Barron's referring to the actual, what's in the letter as evidence, prima facie evidence of viewpoint discrimination. It's also notable who did not.
Which letter?
Sorry, this is the Brendan Carr, the NewsGuard letter.
To NewsGuard and
to the platforms about NewsGuard. Who did not get the letter? Elon Musk. The person who is moderating content in a way that Brendan Carr likes did not get a letter from the chairman of the FCC asking, tell us everything you know about how you're working with fact checkers to moderate content. I mean, obviously, the reason for that is because Brendan Carr doesn't like the fact that how these other platforms, not X, were moderating content. Again,
it's also because X wasn't working with fact checkers to do fact checking.
Right.
Ari, I wanted to bring you in on this.
Yeah, I mean, Barron, I think you made an important point earlier in the conversation about C1 versus C2. I mean, the proposed rule from NTIA many years ago actually said disproportionately a lot about C2A and less about C1. But I think as you I think emphasized, the revision to C1 is by far the most significant issue. And the reason is, as you said, that is the workhorse of Section 230. That is the mechanism that in day-to-day litigation platforms are relying on vastly more than C2A. And frankly, if C1 went away and C2A in theory was supposed to be what was available, I'm not actually even sure you would see a ton of litigation around C2A because it's very difficult to use on a motion to dismiss, and so doesn't really accomplish many of the objectives that litigants, as a practical matter, have. And so there's a revision to C1 that I want to highlight because I think it both is in some ways what I view as one of the most dramatic, would be one of the most dramatic changes to Section 230, and the one that I think in some ways reflects the biggest constitutional problem. And that's the notion that C1 would not be available if the platform engages in any kind of active moderation on the platform. Now, the petition kind of frames that by saying that This change is really because that's not, the platform is not being passive in this circumstance, and by being active in any respect, it's conveying a view, and in conveying a view, it sort of takes it outside of Section 230. I will say as an aside, that's a super bizarre statutory construction of Section 230, because that was essentially the holding of Stratton Oakmont, which was the decision that prompted the enactment of Section 230, and so you're essentially interpreting Section 230 in order to eliminate the very thing that Section 230 was enacted to accomplish. But set that aside for a moment. If you were to condition the protection on whether or not the platform engages in content moderation, what you are essentially doing is saying, if you engage in a protected First Amendment activity, which under Net Choice, the Moody versus Net Choice decision, content moderation is a protected First Amendment activity. If you engage in curation, you will forfeit a very valuable protection. And you will forfeit that valuable protection not only for things that you do, or for harms that flow from that activity, right? So not only for, let's say you engage in some kind of content moderation, and it's the content moderation that causes harm, what this revision would do would say, no, it's not just harms that flow from you having engaged in content moderation. You engage in any content moderation, you will lose protection even for things that have nothing to do with your content moderation. And that, is sort of indistinguishable from any number of unlawful or unconstitutional laws or provisions that we've seen in the past, which essentially says you have to stop engaging in protected activity, or else there will be some either benefit or harm that that will flow from that choice. Now, you might conceptualize that as an unconstitutional condition. I think you kind of put it under the USAID box that was talking about sort of restrictions in the program, out of the program. This is sort of a restriction out of the program. So you could conceptualize that as an unconstitutional condition. It might be even kind of more broadly understood as kind of differential treatment on the basis of having engaged in protected activity, which I think itself would be pretty clearly unconstitutional. But I think that is both the most significant change, if it were to be adopted, and the one that sort of most obviously would be unconstitutional under the First Amendment.
I'm so glad you brought up USAID. That I didn't mention that case earlier, but what the court said there, the court struck down a federal law requiring that recipients of federal funding intended to fight AIDS adopt a policy explicitly opposing prostitution. And the court said, of course, Congress can, without offending the Constitution, selectively fund certain programs, as I mentioned earlier, without funding alternative ways of addressing the problem. But the relevant distinction, said the court, is between conditions that define the limits of the government spending program, those that seek to specify activities that Congress wants to subsidize, those are okay, and conditions that seek to leverage funding to regulate speech outside the contours of the program itself. That's what you're getting at. And so here, that's exactly what the FCC is trying to do, right? To put it in terms of the League of Women Voters case. This is equivalent to saying, if you moderate content at all, you're liable for everything that everyone posts on your site. That's what step 4 was in my little outline of what the proposal was. That's like saying, if you engage in political speech of any kind, electioneering speech or whatever, you can't exist as a C3 either. You go out of business. You are barred from being able to participate in this tax-exempt program. You can't even set up a separate entity. That clearly goes outside of the scope of what's happening. So I think that's step 4. I think that's also a clearly unconstitutional condition, whatever you want to call it. I think the step 2 that I mentioned earlier, the narrowing of otherwise objectionable to make the statute not content neutral, that's obviously also clearly unconstitutional. We haven't talked much yet about the interpretation of good faith to require a bunch of things. There's a lot of stuff in there. It's essentially a regulatory hook for a lot. Some of that's transparency mandates. Some of it is consistent content moderation, effectively common carriage. I think the same gets said about all of that. I think the hardest question constitutionally is that first one, where the agency is just saying that they want to narrow the interpretation of C1 so that C1 would only protect hosting and not content moderation. I think their argument, their statutory interpretation argument, is wrong. They say essentially that that is compelled by the justum generis canon, which says if you have a list and there's an open-ended term at the end of the list, and it's like A, B, C, and also things that are like A, B, and C, that you interpret that catch-all narrowly to refer to those other things. The FCC's argument, their statutory argument, is that that's what otherwise objectionable does. It only refers to those previous categories, and we know that because those things are all alike, and it has to be that. That doesn't actually, I think, hold up when you think very hard about it. I think, in particular, it should be pretty clear that the statute, and the Ninth Circuit said this in Barnes versus Yahoo, that these two provisions are belt and suspender provisions. They offer robust protection to make sure that content moderation is protected, no matter which statutory provision is necessary to use. Because C1 doesn't apply, for example, let's say you edit content and then you take it down. Well, you've lost your C1 protection because you've become responsible for developing it in part. Maybe you solicited it. There are all sorts of reasons why C1 might not protect content moderation. C2A is there to make sure that there's a fallback provision. So it's a belt and suspenders provision. Having both apply to content moderation in no way renders C1 superfluous, which is normally how the statutory canon of justum generis operates. So their statutory interpretation argument doesn't make sense, and it's all in service of this unconstitutional interference with content moderation. It raises these First Amendment questions, and I think that courts will just generally tend to avoid getting into those questions and not go into that interpretation. But I will admit that it's at least a murkier question than these other three steps that I've outlined.
So I'm a Section 230 originalist, and being a Section 230 originalist is a lot easier than being a constitutional originalist, because I don't have to sit in my office and look up and try to divine what Madison meant by speech, or what or try to figure out what the DC what the Congress did with DC public schools, at the time of the ratification of the 14th Amendment. I can just ask the people who wrote it. They're still around. Christopher Cox literally wrote an article that was called "The Original Intent of Section 230," and the idea that this statute was not primarily intended to preserve the ability of platforms and websites to curate content is farcical. Like, this theory that Ari just set out that's in this petition is the exact opposite of what the statute was intended to do.
As I mentioned, I know that we're going to get into other issues like job owning and some of the administrative law issues as it relates to the FCC, but I don't think you can understand any of these issues in a vacuum. Of course, while we've been focusing on the First Amendment implications, there are questions about, does this petition in part raise a major question because of its First Amendment implications? Additionally, as was mentioned, some of the context that may color the conditioning of this amendment is comparable to some of the other questions around job owning. So I want to open it up to the panel if there are any of those other issues that of course will be touched on in some of our later panels around job owning or around the major questions doctrine or other changes to administrative law that you would like to comment on. Give you the opportunity to do so now.
So I guess you didn't mention Loper Bright, but maybe implicitly on the major questions doctrine, and I'll address that. I do think the Supreme Court's decision in Loper Bright is significant here for both the stakes and, as a predictive matter, what might happen. In some ways, and the Loper Bright decision came down in between when the first Trump administration left office and when the second Trump administration took office, and that's significant. Had the FCC promulgated these regulations in 2020, I think there would have been a massive fight over what they all mean, and whether they sort of are immediately operative and effectively bind courts to have to apply this pretty dramatic renovation gut renovation, tear down job of Section 230. To be honest, I think that right now, most courts will look at regulations that are promulgated for the FCC here and kind of say, like, these aren't worth the paper they're printed on. We might look at them for their persuasive force. If we want to reach this outcome anyway, we might wave around the regulations to kind of buttress them. I don't think there are going to be many courts that would view the regulations as anything that they have to comply with. And so I think that sort of fight that, and that's because of the Loper-Bright decision, where the court, in significant ways, in cutting back on Chevron, I think in significant ways cut back on the ability of agencies, at least outside of statutes that they're actually administering or carrying out, to kind of basically generate law, which is what these regulations would do. That sort of gets me to the sort of predictive question, which I think then brings us to job owning. It's not clear to me that this is what the FCC is going to decide is worth its energies for that very reason, because it's not clear to me that these regulations are going to change the state of Section 230 law. And there are other things that the FCC is able to do that don't come with some of those uncertainties and costs, and don't require the level of investment that I think in terms of personnel, in terms of legal capital, intellectual capital, political capital, that it would be to adopt these Section 230 regulations. As we're already seeing, the FCC is learning, as the rest of the current administration is learning, that you can lean on actors in society through lots of squishy tools and get a lot of what you want accomplished. And I think that's my guess is that we're going to just continue to see much more of that with various missives that take the form of nice company you got there, would be a shame to lose it, as the message and as the mechanism to accomplish the administration's regulatory goals. So it may well be that this is, that those of us who spend a lot of time thinking about the First Amendment and Section 230 will just get to spend a lot of time thinking about Section 230 and the First Amendment, but we will not actually see the sort of battle joined that we might have seen at the end of the first Trump administration.
Except the author of this petition, the guy who's been pushing this idea since 2017, long before he wrote that petition, is the general counsel of the FCC. And Republicans have fixated intensely on this idea. I find it very difficult to imagine that the FCC is not going to issue a rule. I don't really see what capital it costs them. They don't really care how well it's done. I'm not sure they really care what the effects are. This is, to quote Gail Slater at the Antitrust Division's event about big tech censorship a few weeks ago, what they want is action, 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 as Steve Bannon put it, she said. They need stuff to do. And this is a big thing to do. I don't think they're not going to do it. I think the only question is how they rework it. So if there's one thing that I think might change, I think it's probably that category 4, where you would lose your immunity for hosting content if you engage in moderation or if you have a discernible viewpoint. I think that has to change just because of Elon Musk and X, because that would clearly be a huge problem for X. I'm not exactly sure how they will do that, because of course the issue for Elon Musk is not so much about doing content moderation, because they don't do very much of that anymore, frankly, for lawful but awful content. I think the issue is more that if you have a viewpoint and you express that and you curate content, that you lose your immunity under the original NDAA proposal. That part, I think, has to go, or frankly, X goes out of business.
So I'm a constitutional law professor, so I don't like to think about everything in terms of politics, because I like to be able to go to work with somewhat of a conscience. But I think this is a real, and it's certainly not the only one, but it is a really stark illustration of a bump in the road with respect to the political realignment on the right. You have, the traditional conservative destruction of the administrative state, apex, in the form of Loper Bright. And then you have Trump Republicanism coming in with an even stronger sense than it did the first time, that the job of these agencies is to make people who disagree with them bend the knee. And that is absolutely a conflict. I mean, I think, maybe Loper Bright was a decision that I did not love when it came out as somebody who teaches administrative law to law students, but I'm very grateful for it now, because as Chris Terry said, it bears some consequence with respect to what the agency is actually going to be able to do with respect to the things that I think are important.
So to kind of close this out as we come to the end of the time on this panel, as was mentioned, we've based this discussion on what we saw in 2020. And Baron, you mentioned one potential change you anticipate with kind of how both the policy and the political winds have perhaps shifted in the 5 years since then. So to our panel in general, are there any changes you think might make a Section 230 rule in 2025, 2026, et cetera, look different than a rule in 2020? And how does that impact your First Amendment analysis of this potential rule? So Baron, you mentioned, perhaps dropping the kind of third party content fact-checking element. Any other thoughts?
I wouldn't be surprised if they say something about what voluntary means. Again, they don't have to. Once you're in the ballpark of having to rely upon 230C2A, you have to show that you acted voluntarily. So it becomes a question of fact in any motion to dismiss under C2A. The rule wouldn't have to say anything, but they could. And they could try to make that harder to show. And that, I wouldn't underestimate how difficult that is. And again, I just point you yesterday to the RFI raising all sorts of theories about why it's not voluntary. And I'll just stop there.
So one place I could see, despite my comments when I first started talking, but one area in which I could see actual legislative reform around 230 is the issue of non-consensually distributed sexual activity. I mean, so I think that could be, I could easily see a time in the very near future where there's a carve-out for that in much of the same way that we've seen carve-outs in other discrete areas.
Yeah, I'm a hazard to guess what the FCC will do, notwithstanding what I said before in terms of changing the rule, and I do think that ultimately this is a statute that applies in private litigation between two parties. It is not a statute that the FCC has any role to play in administering, and so I am super dubious that courts are going to give much weight to what these regulations provide. But Enrique, you raise, I think, an important question, which is what is Congress, and I do think that what we saw with FOSTA SESTA is, a conceivable path for sort of work at the edges, and notwithstanding concerns that I have about FOSTA SESTA, as compared to the alternatives, I think is not a crazy way to go, which is essentially to identify a very particularized problem and say, we think we can make a modest change to this law to address something in a very kind of rifle shot sort of way. And I do think that just as a matter of policy, that approach, rather than kind of upending the law as a whole, is a kind of more sensible place. And then I guess I will make a policy observation to go with that, which is, historically, the story goes, we have a vibrant tech sector in America, in part because we have Section 230, and I buy that story. If Section 230 were to go away, I think that the consequence would probably be something that the biggest companies could absorb, because it would require essentially hiring armies of people to carry out content moderation. The entities that would not be able to absorb the Section 230 going away are smaller companies. And so I really think that, it's just as setting aside the First Amendment for a second, setting aside political predictions, I do think that one thing that is important, I think, for people to keep in mind with respect to Section 230 is that if you got rid of Section 230, you might well be essentially creating an incumbent protection scheme where we essentially entrench the existing companies, which is a sort of, would achieve then the convergence of our concerns in the economic realm with concerns we have in the speech realm, and be very, I think, concerning.
And on that, if Ari's right, if there's no item here that actually gets voted out, or if it's significantly revised beyond what I've said, it's going to be because the lawyers at Truth Social understand that this would kill them.
Well, I believe I'm dismissing us to a 10-minute or so coffee break before we come back together for our panel on the FCC authority over tech companies. If you will take a moment and join me in thanking our panelists.
Reconvening again with more familiar faces. I'm actually pinch hitting for Corbin Barthold, who, because of a family situation, wasn't able to make the trek out. So I am pinch hitting and hitting, what, 7th or 8th in the lineup, I think, now on today. So we are now sort of segueing from one part of the Section 230 discussion into another, but also with some slightly more general overtones to it. And I want to frame this. I want to throw up my favorite quote, because one of my big hang-ups I've had for many, many years is what is the extent of the FCC's jurisdiction and the so-called ancillary jurisdiction? And there have been a couple of interesting cases. My two favorite are American Library Association, 2005. Those not familiar with it, that's the old copyright chip case.
Broadcast flag.
Broadcast flag.
We
yes.
bought, Public Knowledge bought that case.
Yes.
We didn't put our name on top, we put the librarian's name
Yes.
on top, but we bought that case and very proud of it.
And it was a very, one of my favorite quotes, because it says, great caution is worded here because the disputed regulations rest on no apparent statutory foundation and thus appear to be ancillary to nothing. And then in Comcast, versus FCC 2010, the same sort of thing where the court says, you can't draw this line to get to where you want to go. And the quote is, but if we accepted the FCC's argument, it would virtually free the commission from its congressional tether. And I think these cases are really important when we think about this, especially in light of Loper Bright, and especially in light of the fact that if you look at, for example, the Tom Johnson, his opinion letter going into the 2000 petition, really concluded that the FCC had to get Chevron deference to make this fly, and of course it now isn't going to have that. So I think we really kind of need to talk about that. But also remember who we are talking about here. I mean, we're not talking about broadcasters. We're not talking about broadband providers. We're not talking about net neutrality and things like that, which the commission has traditionally had some role, and we can argue vociferously, Title II, Title I, Title III, Title whatever. But really, when we're talking about Section 230, we are talking about the true edge providers here, and the FCC just historically has said that they don't have jurisdiction to regulate the edge providers, except in some very, very narrow cases, and yet now. Because for whatever reason, Section 230, somehow got appended into the Communications Act, suddenly all the panoply of rulemaking now, and it gives the FCC incredible authority over these people who they've never touched before. And of course, we're going to talk about 230, but also think in the back of your mind, what else could this commission decide that it wanted to do in terms of regulating tech companies and edge providers. It's been floated. Chairman Carr, when he was a commissioner, talked about, well, what about USF contributions? And things like that. What about regulatory fees? Should the edge providers be doing that? And so I think more holistically, even though we're kind of focused on Section 230, to think more broadly about what is the FCC doing vis-a-vis big tech, and does it have the statutory authority to do it? So that's where we kind of want to start, and we're also sort of sitting around after the last panel saying, well, what are we going to talk about here? But I think what we really want to focus on is, okay, what's the process at the FCC? What are we looking forward to? And before we get to the constitutional argument, what are the other arguments that we have to deal with? So I'm welcoming a great panel here. I'll have them introduce themselves, other than the guy at the end, because you already know him. But Larry, let's start with you.
Larry Spivak from the Phoenix Center.
Gigi?
Gigi Sohn, Benton Institute for Broadband and Society.
John Bergmeyer, Public Knowledge.
Great. Okay, so I guess my first question is going to be a lot of crystal balling, and we talked about it a little bit before, but what do we think's going to happen at the FCC, and we've ruminated over this. Is it going to be a public notice at seeking comment? Is the commission going to open a docket? Is the commission just going to issue a declaratory ruling? What do we think? Who wants to take it first? Where's the FCC going to go with this?
Well, they're not really talking to probably E or Gigi, so I'm not sure we're the best people on the gossip. They're kind of upset with me right now. I'm not on the team. Now, look, they could do one of three options, hypothetically. One, they could just say, and we get into the legal arguments. One, they could do a declaratory ruling and say, okay, but if you do that, then you run into a Loper problem, right? Because the court said, sorry, you can't do this. And you can go over the stuff, and I've written extensively. Okay, so option two is, well, we could do a policy statement, right? And then it's kind of Skidmore-y, and the problem with Skidmore deference is a 4-part test, and obviously you don't know how the court would apply that test until the FCC writes something, but there is one about, you make this point all the time, what have you done in the past and future? And the one thing we do know is that the only consistency that the FCC has done is the absence of any action. So I'm not sure they've got a problem there. But it's Skidmore, and of course, what one agency's policy, the next one can undo. So now we're back to just flip-flopping, which is the whole point of, dare I say, the net neutrality issue. Then, and we've heard the previous panel talk about that, out and out some sort of rules. So then not only do you have a Loper question, but then you got a West Virginia v. EPA major questions of, do you have rulemaking authority? And the whole problem is, pardon me, but nobody's really talked about this, so I may as well just run through it real quick. I mean, nobody's gone through what the statute is and then what the problem is legally. So as people alluded to, for whatever reason, they put Section 230 in 1996 under Title II. I'm sure there was some reason why, but they also put it with the Exxon Amendment, and it sounded like a good time. And I was actually at the commission when they came up with that. It's like, okay, fine. But the statute has no rulemaking authority. It is technically under Title II, but it says, it is an affirmative defense for civil litigation, period, right? So one of the reasons why they've never done that, and again, we'll get the answer in jurisdiction in a moment, but we don't regulate people, we regulate services, right? That's the key thing, because you may be engaged in a jurisdictional service, you may not be, because they're multi-pronged, right? Okay, fine. The Johnson memo tried to come up with the rules, and I've debated Tom on this, was like, well, we have the authority to interpret. Well, why do you say that? And again, this is all pre-Loper, pre-West Virginia, which is, they go back, and it's interesting, they cited a case called Community Media. And it's almost word for word what Johnson's theory was. It's like, well, it goes back to, they cite back to the, Gigi and I are laughing
Section
over this.
201.
Well, the 201, which is sort of the generic rulemaking, not the just and reasonable rate parts.
Right.
But they go back to Iowa Utilities, the Supreme Court, the original unbundling case. And somehow they said, well, that's sort of a plenary thing that you can do. Again, pre that, and then we get Chevron deference in interpreting that. Fine. But that, although it was tested in the case of Section 621 of, and actually we were involved in that case, of interpreting the Cable Act, right? It was never tested for 230. We know they did this, Trump lost the election, the Democrats dropped it, we never heard from it again. But they are talking about bringing it back, and in fact, there was they had, and it's on YouTube, they had a summit between Gail Slater and Andrew Ferguson and Brendan Carr, and somebody said there, maybe it wasn't those three, but maybe it was Adam Candid on the third panel, they still think the Johnson memo is completely valid. Okay, I'm not quite sure how you get around cases that happened last term, but they think it's valid. So where do they go? I don't know. What are they going to do it? Probably because we've seen, I've done this business for 30 years, and an agency, they don't care. It's costless to the agency. If they want to waste your political capital, and that's entirely their right to do. Will eventually get overturned? Probably, but by that time the omelet's scrambled, but we could be doing a lot of other things in the meantime.
So, well, first I want to thank Baron for inviting me, and also say, Baron, you said something a couple panels ago about how you wish the FCC would dry up and go away, and, you know, what's happening, you know, the deregulatory state or the destruction of the administrative state is actually something you don't mind so much. However, you are so principled that, you know, you've had 2 days dedicated to why it's screwed up what's happening in this environment, and firing commissioners and not allowing for dissent. So I just want to thank you for, you know, being such a principled person. You know, even though you and I are never going to agree on net neutrality or FCC authority, we do agree that there actually is a reason for government to work and not be governed by, I think somebody said, what is it, the theory of me? I think it might have been Matt Wood, right? You know, regulation by me. So I'm just really happy that you're doing this, and I'm sorry I missed Becca and Alvaro and Anna, and I give a lot of kudos to them, particularly Anna, because she's still earning a salary with a sort of Damocles over her head and speaking out, and she knows that, you know, it's not going to make a difference whether she speaks out. It does make a difference that she speaks out, because I think it's important. I'd love to see more former FCC commissioners speak out, particularly Republicans. But she knows that if she stays quiet, it's not going to make a difference. She'll either be fired or she won't. And she knows she has no choice. So I'm very proud, you know, given that I was nominated for the seat that she eventually got. I'm very, very proud that she is speaking out and doing her tour, and I'm 100% supportive. So I just wanted to say that first. So Larry said a lot. I think that Brendan will do something. I don't think he'll do the declaratory ruling, because I think that's like throwing a bomb on a fire. I do think he'll start some sort of rulemaking, and we will have, you know, months and months and months of debate where the tech companies are literally freaking out, and so it's more jawboning, right? Whether he will complete it, I think I agree with Ari that he probably won't. But that's not the point. You know, it's funny, I get asked a lot by reporters, well, you know, on digital equity, on DEI stuff, is what he's doing legal? I said, it doesn't matter. And at some point, it doesn't even matter whether it's legal or not. And again, the power is that he's doing these things that can't be challenged. There's no final decision that you can go to court with. What court's going to let you have a case, right? You don't have standing. You know, there's no case or controversy. So, you know, what he's doing is extraordinarily powerful with not actually having to do anything at all. And remember, he's got a 2-2 commission right now. So he doesn't have a majority. And this guy's in the news every single day. And people may have seen that Verizon bended the knee and got rid of any and all talk of DEI on their website. You know, I actually talked to them yesterday because they were, please, Gigi, don't criticize us. And it's frankly hard for me to do that, because, you know, they've got a transaction in front of the commission, and I don't actually have an opinion on the transaction. And they want to get it through, so they're going to do whatever it takes. And I get that. I'm actually not unsympathetic. It's not their fault. It's the fault of the chair, who is using his power as a chief regulator and chief reviewer of these kind of mergers to make these companies bow down. And they're doing it. It's working. So I don't expect him to stop. So I do think there will be a proceeding, and we'll have whatever, 6 months, a year, what have you. But I don't actually think he'll finish it, because, as Larry said, I see there is nothing. This is my copy of the Communications Act from when I was at the FCC. You can see it. I don't drink coffee. I don't know. It's probably Coke or something. There is absolutely nothing in Section 230 that gives the FCC any authority whatsoever to interpret Section 230. Loper-Bright makes it even more clear that that they don't have the authority. And I just want to read one little section from Loper-Bright that I just thought was the dagger. So there's a whole discussion about why courts are the best to resolve statutory ambiguities, and there's a little sentence on page 23 that says, "That is no less true when the ambiguity is about the scope of an agency's own power. Perhaps the occasion on which abdication in favor of the agency is least appropriate." So what I'm saying, when the FCC is interpreting its own statutory authority, that's when the courts really have to come in. That's when they have the least deference. Skidmore deference, whatever. So I just think that puts the nail in the coffin, and Brendan Carr's not going to want to lose in court. So why not just have the sword of Damocles over the tech companies' heads for whatever term of his chairmanship, and it'll all be good. And by the way, it's working with the tech companies, right? And it's not just what Carr has said, but it's what other folks in the government have said as well, right? The Facebook has changed the way the way it moderates content. Bezos has changed the Washington Post to Wall Street Journal light. I mean, it's working. So why do you even have to go to court and have a court determine that you're full of it?
Sure.
Yeah, that's hard to follow. I mean, at first, I just say, Harold and I were just like noodling on this statement like during earlier panels. But yeah, with the announced Charter Cox transaction, like a huge worry that we have is less. We're still worried about the standard cable merger. We don't like content bottlenecks and all that stuff, so that's all in there. But, we're terrified of just like what kinds of concessions is the FCC or the White House even going to try to extract from these companies and to get their mergers through. It all seems completely lawless. And speaking of lawless, I mean, I just think on the 230 point, I just like to emphasize it almost seems like legal archaeology at this point. But like even under Chevron, the FCC did not have any discretion to interpret Section 230. So this is not just like some, we were in trouble under Trump 1, and then they got rid of the Chevron deference, which I did not agree with. And now all of a sudden we're free of the agencies. No, agencies didn't just necessarily get Chevron deference because the title that something was codified in, and just because something was codified in a title that says something like the Communications Act never meant that the agency got discretion over. It just has to do with whether it's a statute that the FCC administers, and where it's codified is of secondary importance. And the FCC gets no deference over Section 230 because it's, as people have repeatedly said, it is not a statute that has anything to do with the FCC. It is simply a defense. It comes up in private litigation over there. The FCC is not involved. So also, for that same like basic reason, when Section 201B of the Communications Act says the Commission may prescribe such rules and regulations as may be necessary in the public interest to carry out the provisions of this chapter, there's nothing that is necessary for it to do to carry it out. It's self-executing. It's just something that courts apply in private litigation. So without that, the FCC would have, that doesn't give, the FCC just has no jurisdiction whatsoever. And I'd also like to say, though, even if there were some crazy theory where the FCC had jurisdiction, there's no ambiguity. It drives me crazy when people say that there's ambiguity in the phrase otherwise objectionable. That's like if I said, hey, what's your favorite ice cream? What's your favorite ice cream? Oh, different answers. It's hopelessly ambiguous. We need to go to the agency. It's like, no, it's a subjective standard. It's saying, hey, you, platform, you get to decide what in your judgment is objectionable and then just act accordingly. And so different platforms might come to a different conclusion. That's fine. That doesn't mean that there's ambiguity in the law. It just means that there's discretionary decision-making being given to the platforms, which they already had under the Constitution.
John, do you think that there's no ambiguity in C1 in what it means to be treated as a publisher? I mean, that seems to me to be a much stronger argument for ambiguity, that it's unclear whether that includes content moderation. I think it does include content moderation, but it's not crazy to argue that that's ambiguous.
I mean, I've just done so much writing on this. It's like my mind is like polluted with like reading the common law and like all these different cases. So it's really hard to know what like a normal judge would look and see. But I think, to hold something liable as a publisher means, are they being held liable for doing publisher type things, namely bringing things forward into the public or withdrawing them from the public? Those are.
I agree, but fortunately, in a way, this question's moot because we're no longer operating under Chevron. Right, so I think what the FCC would say if they were here is they would say, first of all, that their argument about the FCC having authority to interpret 230 is unchanged by Loper Bright. And I think the claim would be, what we would get into a debate about, would be whether the agency is actually responsible for administering the statute. And if they're not, I think it's hard for them to win under Skidmore. But it becomes a question about how much weight should their interpretation get under Skidmore, right? And that strikes me as a fight that they would want to engage in, because it's not so much a binary. Do they get deference under Chevron, yes or no? It's how much weight do they get? And I think if I were them, if I were an attorney working at the FCC, what I would tell them is you would shoot yourselves in the foot if you short circuit the process. your arguments under Skidmore would be stronger if you've actually gone through notice and comment rulemaking, you've taken public consideration, you've thoroughly vetted these questions, and you can at least say that you've thought through the question fully.
But
difference for what? Difference for what? That's what I don't understand.
No,
Like,
if you do a rulemaking, then you get into
I don't
major
get that.
questions, right? If you do a policy statement, you want, and that's all that is. I mean, this is what sort of gets me about the whole thing, because at the end of the day, I've done a lot of publishing on concept of the notion of regulation, and I'm hearing all this talk about jawboning. Understand that, I mean, we did a peer-reviewed paper about 7 years ago. Regulation is really a bilateral bargain between the regulated and the regulator, right? I want something, okay, what are you gonna give me in return? Here's some voluntary commitments, here's DEI, completely unrelated to the merger, right? We've had this discussion, you had the CEI case, which is the charter case, which I like to point out was actually litigated by none other than Commissioner Holyoke when she was here at CEI. It's a fun little fact, right? But what happens if everything's a bargain? And this is not unique to the FCC. This is the nature of regulation. If everything's a bargain, then precedent becomes irrelevant, because everything is, what have I done for you lately? And we've seen that time and time and time again, right? So you have that as a phenomenon. Where the jawboning comes in, and I did a piece for this one at the Fed side a couple months ago. You know, you had the NRA v. Vulo case where you had jawboning and the court upheld it 9-0. But people forget that in Murthy, where everybody said the Biden administration was certainly coercing them, social media companies, it was not colluding with them. That's almost a direct quote from the district court. But yet, they're not the ones who filed. Right? They didn't petition. That's why they got rid of Murthy and Sandy. Why? Because of the vast power of the administration. So you have this. What's interesting to me, though, so if you remember on the first day of the Trump administration, right, what was one of the very first executive orders he put out? The famous free speech order, right? We're all going, what's this going to be? It came out like, 1201, whatever it was. And he said, according to Trump, yes, the number one, I'm ordering the government to stop jawboning, and yes, there was coercion in Murthy. They basically admitted it. Sorry, I'm a musician, and I get a gig on Monday, so come on. Right, so you have this. And then they went out with another executive order that says, no more rules that have major questions. Agencies have to stay in their lane. What bothers me about this is just 6 months ago, we were arguing in net neutrality that, you got to stay in your lane. And now we're not staying in your lane. And I don't understand, because this is the problem with this, and
because it's not I got to
you're
stop
right,
you,
you're
okay?
right.
Otherwise, you're going to take up the whole panel, okay?
Sorry.
And I think Matt or Harold said this. I think Matt probably said it. Is that you have to, and I tell people this, you have to wipe from your mind that this is any kind of typical Republican administration, okay? Like, again, the whole notion of deregulation. And I think you had it in the list of questions, this threat to regulate virtual MVPDs, okay? I mean, that's something that we didn't do under Wheeler, okay, even though we were asked to do it. So, I mean, that is not deregulation, that is a regulation. So you have to wipe from your mind this is not Dennis Patrick, this is not Mark Fowler, this is not, even Ajit Pai, okay? And by the way, Ajit Pai did that Section 230 notice under great duress. He did not want to do it. So, trying to be rational about, Brendan is just not doing the things that a normal Republican FCC would do, just wipe it out of your mind. Everything he is doing, and I personally like him very much. Some of my friends don't like that I say that, but I do. He is working for one man, and he is catering to one man, and everything he does, including wearing the gold Trump head pin, is for that one man, and it has absolutely nothing to do with principle, with deregulation, with 99% of what he wrote in his Project 2025 chapter. That's what I spoke to a bunch of mayors. I told them, we know what Brendan Carr's going to do because it's in Project 2025 chapter. No. So let's stop being rational about what's going on right now at the FCC.
Yeah, I mean, I think
the question of what legal form will what the FCC does take. I mean, I'm very interested in this. That's my job. I'm a lawyer. But yeah, I don't think it matters. I think it's just the purpose is to get some document out there, and the purpose of the document is to sow confusion, get it in the hands of some magnified district court judge, and that's the only excuse he needs in order to ignore or Supreme Court justice, but just like as an excuse for a lower court judge to just like disregard the binding precedent in nearly every circuit. I mean, that was what was amazing about some of these cases going up to the Supreme Court, is that there was no split. Every circuit court had reached the same conclusion on like what the First Amendment rights were of platforms, and it goes up to the Supreme Court anyway, just because of the Fifth Circuit decides to just be crazy. And I think that's the purpose here. You just get a bunch of decisions, you get the Fifth Circuit upholding it, it makes its way to the Supreme Court, and it takes out the clock for like 3-4 years, and then where are we? I don't know.
Well, but that's was going to be my next question, which is, again, I said this earlier, lived 2/3 of my life here, and I've never ceases to amaze me that the party in power never thinks they're going to be out of power again. But in 4 years, let's say we get something out of the FCC, either a declaratory ruling or even a rule. I mean, have we now launched the next 2 decades of the equivalent of net neutrality in that?
Maybe.
Yes. But we'll be on the same side for the next 2 decades on
That's
that.
not bad.
On that one, yeah, exactly. We'll be able to argue on the same side. But how do they do something that withstands the flip-flop back to Democrats? Because if Carr can do this and it's upheld, then why can't it?
I don't think he
next
cares.
Okay.
I don't think he cares, okay? What he cares about is maximizing his power while he's in power.
But John, to your point, do you think that the ultimate end game here is to try to get some court decision that revises Section 230 pursuant to what the FCC says, so that you got some precedent on the book that can't then be overturned? Or
I think there's been a desire for a while to get a Section 230 statutory interpretation case in front of the Supreme Court, and then the conservative justices just want to have an excuse to put in some crazy crap.
But it's even more than 230. I mean, I think you really got to look at the macro. I mean, you're exactly the point. I mean, if I was Anna Gomez, I would have been here and going, first off, that's not what you said 6 months ago. Not that they care, but at least you called it, put their feet to the fire. But I would just be sitting back, as I would have the Martin Luther King moment. I may not get to the mountaintop with you, but eventually my side's going to get back in. Maybe Gigi will get a renaissance and she'll be chair, and Katie bar the door, because this happened like during Jessica's thing. A certain proponent of Section 2, they put in Title II, it gives you omnipotent power. If you take that argument to its logical conclusion, then what's to stop an FCC from telling a cable company, right, which they don't generally have jurisdiction over, to say, hey, I want you to deplatform Newsmax, or I want you to deplatform. I mean, this is where this argument goes, and nobody's thinking about it. It's very, very dangerous in terms of it's about agency power. And one of the things that I think the Roberts Court has tried to do the last 4 years is rein in that power. And again, you're right, it's irrational. I'm not disagreeing with you. I'm just calling out because maybe shame and guilt, somewhere like the Grinch, the heart is too small,
But by the way, some Democrats in Congress a couple of years ago did call for deplatforming.
That's my point. I cited that when I took down
yeah.
Joel Thayer. No, I mean, that's exactly the point. This is a very nasty cycle if we get on it. It is a rapid race to the bottom. No, I know that, and it's accelerating, and people like on this panel who are grown-ups should be going, this is where this ends. And apparently there's no desire for people to say, this is enough, this is wrong. And I've never seen agencies just sort of, I take it back, I've seen it my entire life, I've been doing this business too long. But it's just getting worse and worse and worse. And but it's not. It was the title of my 230 piece. What's good for the goose has got to be good for the gator. But it's always now. It's like, but if only I was in charge, things would be better. I'm special.
I mean, I think one thing that might be kind of an interesting point for this audience is, look, we have net neutrality, big fans and supporters here, and dedicated opponents, right? But like, even if you hate net neutrality, you don't think it's going to make all the ISPs go out of business, right? It's like, oh, less innovation, higher prices, all these bad effects, don't do net neutrality. But it's not going to destroy the industry. I think the problem with the 230 interpretations put forward by the current administration is they're impossible. Like, they can't be followed. There's no way to actually be neutral or to just do the things that they want to do. It would just means that any social media platform that exists would only exist at like the sufferance of the administration and of the courts. Like, if you're on their good side, we're not going to go after you. You know, it's very much like the TikTok stuff with Apple, where it's like currently Apple and Google are clearly violating the law by hosting TikTok. You know, they're liable on paper when I look at it for what billions of dollars in damages, and the only thing keeping them from there's no private right of action, so as long as the current administration doesn't want to enforce the law, I guess you're good. But as soon as you're on their bad side, it's like, hey, haven't you been actually hosting TikTok all along? Mm-hmm. And I feel like these 230 interpretations are just like that, where they're not possible to follow. Musk hasn't followed them the least. He's, you know, completely reversed everything he's ever said in terms of, you know, pushing the discourse in one direction or another. So he would be like the first violator of the magnified version of Section 230, but it wouldn't be enforced against him. And I think that's just where we're going to go. It's just like gangsterism and cronyism.
But that's exactly the issue. I mean, you know, like I said, I've dedicated my career sort of constraining the administrative state. And we can quibble over rents, we can quibble over whatever. But this is speech. This is almost a de facto pravda of where this is. And this is where the difference is with all of this. And I think you've hit it right on the head with that. Because, I mean, think about sort of the history. Why are we dealing with 230? Well, first we tried to do the state actor stuff, and you had Halleck. That was shot down, right? Mm-hmm. Couldn't do that. And then that was also came up in the Murthy case. Then we tried to do common carriage. That was shot down. So what's left for pain is Section 230 because it's the legal lifeblood. And then you do have de facto jawboning and de facto speech regulation.
De facto common carriage.
And
it's not even common carriage, it's just speech regulation.
And what's frustrating about the jawboning in the Murthy case is that, you know, it was such a messy set of facts. Like, I think jawboning as described in its like traditional way, coercing, it's bad, right?
It's been going on since the time of the Republic.
Yeah, but particularly when it's like done in this like extremely like coercive way, and instead of like waiting for that fact pattern to arise, you know, the conservative legal movement just like invented a case out of nothing that was full of distortions in the record. So it's like, how could I even just like weigh in on this case on a principled legal basis when the facts aren't even there, as called out by justices of the Supreme Court? Usually don't call out in a footnote the fact that the majority is relying on things which they think are false. And it happened there. So, I mean, what are we supposed to do?
You know, but the thing about Elon being fined, well, he's only fined for 3.5 years. You know, because when it flips again, and it will flip again, either 4 or 8 or at some point, you know, is he going to be out of the business by then? You know, will he be on Mars?
I mean,
you know?
I have to say, I do worry. I don't think either party, even though I don't think this is a binary argument, is in the right place on Section 230, right? I mean, I think you have as many Democrats who would love to, you know, kill it. And so, I mean, the former president himself said that at the very beginning, said he wanted to kill it. So it's, you know, the Republicans don't like the fact, they think that too much is getting taken down. The Democrats think not enough is taken down. So, you know, so both of them want to tinker with it. So I think it would just, the only thing that would flip, I mean, that's a danger if Carr were to actually do something real here, is that they wouldn't necessarily repeal the FCC's authority, which none of us believe they have, to interpret it, but they would flip it so that if you didn't take enough down, you'd be liable. So it's not a good situation, period. And I think it was somebody in the previous, was it Ari or the other gentleman mentioned that who this would really hurt if Section 230 got screwed around with would not be the Metas and the Googles of the world. They could pay the lawyers, right? It would be the Reddits of the world. It would be, you know, just ordinary, if
Yelp,
anybody blogs anymore.
Discord,
Yelp.
and anybody leaves a review, TripAdvisor,
Exactly.
whatever, you know, musician's friend, I
Right.
don't like the review of the music.
Exactly. So
There's
that's
a
what
million
would really
things.
hurt. But so, you know, I think that we have a 230 problem. It's not limited to one party, unfortunately.
So I want to turn back to what the judicial review would look like of whatever hypothetical thing comes out. And the one thing I do want to correct is I think a statement was made a little earlier today that the Sixth Circuit case in net neutrality actually talked about the major questions doctrine. And in fact, it didn't. the judge there said specifically, I don't have to get there. I don't have to talk about whether or not this is a major question because the statutory authority isn't there, period. But could Section 230 be the major questions case that finally goes up?
I don't think you need to get there because
Okay.
the statute is so clear that it's self-effectuating. The FCC doesn't have authority. However, if there was ever a question of major economic and political significance, it is in our space. It is this one.
I'll give you a corollary. Like I said, if it's just a declaratory order, which you're competing, agency interpretation versus court, court wins, LOPR, right? LOPR, right? If it's a policy statement, we're not really doing anything. We're just offering our opinion. Okay, knock yourself out. You don't have to get a commission vote for that. Just a policy statement. But like I said, if you do a rulemaking, like you must comply with this. I would commend you to look at, and I don't think it's being appealed, but under Lena Khan, they try to do rulemaking to enforce unfair methods of competition, the non-compete rule. And the district court said, wait a minute, and again, they were relying on a more generic Section 6, so, which is like, yes, every agency has to do rules. Like, these are my rules of practice and procedure. They're not substantive rules, but they're technically, you gotta have technical rules. Your filing fees are this, and garbage, right? But they hung it on that, and the court said, it is a major question whether or not you can do a non-compete rule under UMC rulemaking. You have Mag Moss, but you don't have that, and that kind of shot down everything. Now, it didn't go anywhere because the Trump administration the FTC didn't appeal it; they let it go. But it is a major question. There's a classic corollary of a major questions issue.
Yeah. But that case also said, Larry, which you mentioned in your wonderful article, which I've read many times, and Larry, that's probably the only thing Larry and I have ever agreed on in, 30 years of doing this? But it's a wonderful thing. I love it. The other thing it said is that the FTC couldn't use its sort of general authority.
Right.
Oh, okay, that's what you're saying.
Housekeeping rulemaking authority.
Which is essentially what 201B is.
Yeah, and on major questions,
it's squishy. I'm not saying
it's reformulated different ways at different times.
Exactly.
In the concurrence to West Virginia EPA, Gorsuch put forward like 3 factors. One, great political significance. Yeah, Section 230. It sure seems to be now. Maybe it wasn't back then, but it sure is now. There wasn't a time restriction there. It seeks to regulate a significant portion of the internet economy, of the American economy. I just said internet because obviously the internet is easier. No, that one's tricky because it's like, does that mean that every regulation affecting trucking is a major question because trucking is so important? And then finally, he said it seeks to intrude into an area that is a particular domain of state law. It might be weird because it's like, well, Section 230 is not state law, but publisher liability certainly is. Like the scope of like when an entity is or is not liable for the content of what it's publishing, that seems to be classically a matter of state law. And I don't know what differences there are in states with publisher and defamation liability, but to the extent there are any, those would just come back into force for platforms because it would just be different in each state.
I'm really glad, Larry, you brought up this comparison to the FTC case. The FTC case involves Section 6G, which clearly is a housekeeping rule authorization. And part of the reason we know that is that at the time, the convention in the progressive era was that where an agency was intended to make substantive rules, it was also given the ability to impose penalties. There was no such authorization in the FTC Act of 1914. Now compare that with 201B and other grants of rulemaking authority in the Communications Act. There, the agency did have penalty authority originally when it was given that authority back in 1934. But importantly, so that's a sense in which the agency is administering those provisions. The rest of basically the entire Communications Act of 1934, as written in 1934, the agency administers. If you don't do what the agency says, you're subject to penalties. The Section 230, yes, it gets dropped into the Communications Act, but there's nothing in Section 230 that opens the door for the agency to impose penalties. So it's in that sense that I think John was very correct earlier, where he was describing the ways in which the agency is not administering the statute. So I think that same logic holds here. There is no role contemplated in the text of Section 230 for the agency to administer the statute, to impose penalties, and so on. So that's why I think ultimately if the agency loses in their theory that they can issue rules under 230, it's going to be under that same logic. I think that's very easy to reconcile with the logic of the FTC case.
Just one other thing. Also remember, somebody, again, at the other panel, and I forget who, mentioned there is extensive legislative history of Section 230. There is absolutely no mention of the FCC having any role whatsoever. And I also think it
In fact,
bolsters.
it goes the other way.
Yeah, exactly.
Specifically said they don't want
It also
the FCC.
bolsters, I think, the argument.
The preamble.
Yeah.
I also think it bolsters the argument for being a major question, right? Because of the importance that there's also Ron Wyden and Chris Cox, really believed that this was going to be the thing that set the internet on fire, and they were
right.
They were right.
Jim, I'm surprised you didn't bring up your favorite quote, which is that Chris Cox at the time said, "We didn't want a federal computer commission with an army of bureaucrats regulating the internet." I mean, it doesn't get much more clear than
exactly.
that.
Well, but don't forget that. Yeah.
So whatever happens goes up on appeal, and one of the things that has me scratching my head is, all right, Section 230, part of the 1996 Telecom Act, do the math. In the almost 30 years, the FCC has never done anything. So how under Skidmore do you say you get deference when this is the first time in 30 years of a statute sitting on the book, you suddenly woke up one morning and said, we've got the authority to do this? I mean, that seems to me under classic Skidmore, pre-Chevron Skidmore, you get no deference at that point, because this is the ultimate voyage of discovery.
Jim, I would just slightly tweak what you said, just to say that unlike Chevron, where Chevron has some binary distinctions, you either get it or you don't, the whole point of Skidmore is that it's a spectrum. And so if you're doing something for the first time, the agency is going to get less deference, less respect from the court, and the court's going to be more skeptical. So I would just encourage us all to think about it that way. I think the agency has an uphill climb, but it doesn't mean that they get zero justification or that the courts would necessarily ignore them. And I think, frankly, this is just realpolitik. Some courts in the United States are so eager to do something about 230 that they will gladly accept what the FCC does. The point here is to create, ultimately, confusion among the lower courts, a circuit split, and for this to go up to the Supreme Court. So as John said, that some justices who have had a bee in their bonnet about 230 for years can simply say that Zeran was wrong and that publishing does not include content moderation because that is, quote, censorship, unquote.
And that was the point, to back up Barron, on my most recent follow-up to my original Section 230 piece with the FedSoc, where I go through the Skidmore. And again, if you're talking about forum shopping, the Sixth Circuit, Tom Johnson really took his entire theory from the Sixth Circuit case, community media. Now, when the net neutrality case went up to the Sixth Circuit, they did not mention community media, just not a word. Maybe nobody raised it, maybe people forgot it, maybe they viewed it as one of the grandfathered Loper cases, who knows. But, like I said, the Sixth Circuit, if you take, as I pointed out and as you pointed out, they never reach major questions. Like, this is a Loper question. I'm not even getting to the authority. I'm just saying you can't interpret the statute, period, full stop. Who knows? Clarence Thomas cited Adam Candu, and the paper was just wrong. But, he wanted to go do this, and he did. So we don't know. It's a black box. That's part of the risk that we all go with this. And this is, one would hope, particularly in a DOJ world where resources are constrained, that one would be more judicious in their regulatory interventions. And why you would want to spend all of your resources on this when it's the likelihood of success is low. Welcome to Washington. I mean,
Can we move on to before we run out of time, the other questions about the FCC's claims of authority over internet services? Because Brendan's made a bunch of them. NewsGuard is one of them. Brendan sent a letter to Google, Meta, Microsoft, and Apple demanding information about their relationships with NewsGuard. And he tries to tie this all to Section 230, as if that somehow gives the agency authority. So that's just one of many claims. He's also asked Google if YouTube TV discriminates against faith-based programming because it didn't carry great American media. I mean, the agency is making these claims of authority over internet services. I want to just go back to both thank Gigi for her gracious remarks and also compliment her. The best thing I think that you ever did in your career, Gigi, was bringing the broadcast flag case.
Thank you.
And for trying to draw a clear line between the FCC's authority over telecom and other communication services and edge services that are beyond the FCC's jurisdiction. It seems to me we're now in exactly the same place where the FCC today is trying to erase that line to claim essentially boundless jurisdiction in the name of 230, ancillary jurisdiction, whatever else Brendan can throw together. I'd love to hear your thoughts, Gigi.
Well, again, what's actionable? What can you take to court? A letter? I don't think so, right? Just an offhanded remark at a press conference. When did he say the YouTube thing? Was that a letter?
That's a letter.
That's okay. All right. What are you going to do with it? Nothing. That's the problem, and that's what he's doing so successfully, right? Is he's scaring the living daylights and out of these companies and making them bend, but there's nothing that they can do. There's nothing enforceable. He's not doing anything that's enforceable, right? But they don't have anything that they can take to court. So he can assert all this authority, but who's going to decide whether he's properly using it or not? So that's, again, that's what he's doing so effectively. Wrongly, I don't think he's got jurisdiction on either one to tell them, to do a real investigation or have any real enforcement. I mean, he could tell his enforcement bureau, go ahead and investigate.
Well, there is a thing that they are likely, or they may do here that I didn't call out on the last panel. On the last panel, I said there were 4 things that the NTIA petition from 2020 would do, all of which were about reinterpreting Section 230. There's a 5th thing, which is that, and this is the part that is not an interpretive rulemaking, this is a clearly legislative rulemaking. It's the very end of the petition, where they attempt to extend the rules that had been applied since 2010, transparency rules that had been applied to broadband internet access service providers, and says essentially the same rule would apply by analogy to interactive computer services, and essentially it would require that an ICS provider, anyone protected by 230, who's offering a mass market retail offering to the public, just like the definition of bias, would have to publicly disclose accurate information regarding its content management mechanisms, as well as any other content moderation, promotion, or curation practices to allow customers to make informed choices. That's a legal claim, and that would rest very clearly on this assertion that somehow 230 gives them rulemaking authority. No doubt they would make some kind of argument about ancillary jurisdiction. I think in some ways the most interesting question about what the FCC does on 230 is whether they keep this rule, because even though the rule itself is a transparency rule and seems less invasive, the underlying legal claim, if it were accepted, would give them vast authority, just as is noted here on this slide, to impose all sorts of other conditions on interactive computer service providers.
So can I just talk about ancillary jurisdiction? Because you raised it, Jim, at the very beginning. I mean, the FCC's claim of ancillary jurisdiction, it has to be ancillary to another statutory duty, right?
Mm-hmm.
So the cases that where the FCC was actually successful in asserting ancillary jurisdiction are older than God, number one.
Okay, Midwest,
and number
and
two,
stuff
and they
like
were
that.
all about retransmission consent, right? So this was before the must carry law. Like the FCC's rules requiring must carry were upheld because it was in the service of broadcasters serving the public interest, convenience, and necessity. I don't know how you get there from where Barron just, I mean,
Well,
ancillary
the argument
to
would
what?
be ancillary to 230. That has to be.
But then you're assuming you've got authority under 230. I mean, it's kind of a circular argument. You're back in the beginning.
Wait a minute, I'll throw one more temporal wrinkle into this, because when this was before, now after all the net neutrality litigation, where, to use Judge Williams' of late memory would say, like, now that we've stepped off the Title II elevator, you know, everybody's going, you guys have made the decision. They've used the word abdicate. You know, I was a long proponent, going back to the Pulver order, for those of us who remember, thank you, where it was like, no, Title I, I still have jurisdiction. It just means I haven't decided what to do. Remember, it always said, it is subject to exclusive federal jurisdiction. Nobody ever thought, like, that is an abdication, they're allowed all the states up. I'm just saying the current state of the law, you look at the Second Circuit case from the New York case, the Ninth Circuit case with California. Sorry, I mean, they're, if you read them both, they're both like, hey, FCC, you gave it up. You have nothing. Don't even touch it. It's like, it's another little legal wrinkle that, you know, the case law has moved on, and showing, once again, bad facts make bad law, but, you know, who asked me?
So anyway, so that's my answer is, you know, they're presuming authority over something they don't have authority.
Well, and don't forget, they can't even use 706 anymore, although technically 706 is still on the books.
Well, right, because it allows them to do the study.
Well, the Sixth Circuit never said to the commission, don't forget, it was hortatory, it wasn't hortatory. Jessica made it regular law again.
This was the basis for the 2010.
Right, and went up to the Sixth Circuit, and the Sixth Circuit says, I'm just dealing with lopers. Like, are you going to answer whether it's hortatory or not? No, we're not reaching it.
John is too polite to interrupt us.
Go on. It's an interesting question.
We're doing angels dancing.
I love it. Something came to my mind based on our earlier discussion about the mischief that lower courts can do with higher court opinions that they misapply. And I mentioned, the magnified, Trump district court judge. But even like reputable courts can get this wrong in pretty substantial ways. So recently, after the Net Choice case, which I thought was, very good opinion, leave the stupid debate of whether there's dicta in it or not. Like, I thought it was a very clear articulation of First Amendment principles. And it gets down to the horrific facts of the Anderson v. TikTok case, where the Third Circuit basically said, aha, so the Supreme Court has just held that content curation is expressive and protected by the First Amendment, which therefore necessarily means, out of nowhere, that it's not protected by Section 230. Where did they get that from? Where's this notion that to be a publisher means to like be neutral? It's this undying zombie idea that just like comes back no matter how many times you kill it. And here it is in like the Third Circuit right now just held that.
They got that from almost every story that's written about 230.
Oh, yeah.
Gets that wrong because it's really not so easy to understand for journalists.
Yeah, and tech platforms, they didn't do themselves any favors for years by like claiming to be neutral. And the fact is, yeah, they get to have expressive activity that they can never be liable for in terms of the curation of other people's speech. Like, I can be my pro-Trump guy, my pro-Trump message board. I delete every anti-Trump comment. You look at it, you look at what I promote and everything about it, and you see, oh, this is a very pro-Trump guy. He's communicating pro-Trumpness. And yes, that is my expressive activity that I've just communicated with it, and there's no path to liability for it. But there wouldn't have been anyway. I mean, what are you going to do? Sue someone for defamation based on this like highly attenuated notion that they have a point of view, that they kind of like this kind of content and not that kind of content? Like, it doesn't even work. But I mean, that's the objection that people basically have.
Doctrine, yeah.
And it's like, oh, how come they're allowed to have views and get sued and we can't? It's like, what are you planning on suing them over? There's nothing to it.
All right, we're coming up to the end, so I want to give last words and predictions. I mean, what do you think is going to happen? I mean, we've heard a lot of things that Brendan may not do anything, what he might do, and what's going to happen. So, yeah, 3 years from now, we're sitting around 3.5 years. We're sitting back here. What's happened and where are we? Barron, you want to start?
Yeah, chaos. I think they're going to issue a rule. It's going to confuse a lot of judges for the same reason that John just mentioned. And it's going to go up to the Supreme Court, and Justice Thomas will probably convince a few more of his colleagues to join some opinion, and this will be, and I wouldn't put out of the realm of possibility that we might get a very badly worded decision that creates even more chaos. And that's the point, that all they want to do is throw the entire ecosystem into turmoil and force them to come to the table and beg for the administration's forbearance, and maybe beg for legislative changes. So in some sense, this is not so different from this concept that's out there that has attracted bipartisan support to sunset 230 as a way of forcing industry to come to the table. This would accomplish much the same thing.
Larry?
Yeah, I mean, like I said, they're not telling me what they're doing. From whatever you hear, I think they're going to go full bore. I don't know whether or not, as I said before, a simple declaratory order, a policy statement, or all on regulatory compliance. I mean, it depends on, given the people that are over there and their desire and their whole career has been built on, being very aggressive. I'm not optimistic that you can even slightly sidestep it the way that Ajit tried to sidestep it and keep it very narrow and constrained, giving very difficult politics. I think it will end up being a waste. I agree with Barron that there are a lot of people. Justice Thomas has been very open. He's very skeptical over 230. Justice Gorsuch. I mean, I was really surprised in Moody his concurrence, given that they had all voted for the cake case, the bakery case, right on free expression. But for some reason, Barron is absolutely right. There's a lot of misunderstanding on how it works. But this is notwithstanding 2 presidential executive orders. This is a priority for the administration, whether they want to admit it or not, and there will be chaos. And I think it's unfortunate because it's to me it's more petty than it is substantive.
John?
Yeah, I think just like the TikTok ban example I mentioned earlier, if you have a chaotic situation where you have an impossible to comply with legal regime, which means effectively everyone is guilty, we've lost rule of law, and all that matters is who you know and who you've been nice to as to whether your company gets to continue to exist.
So, probably in about a month and a half, Brendan Carr will have a majority on the FCC. Olivia Trustee will be confirmed. And he will want to pivot to real deregulation, particularly of the media sector. And I think that is going to, and he also has his delete docket, right? So I'm not sure. I mean, I think he will start a rulemaking. I don't think he will finish it because I think the commission's time is going to be largely spent on actual real deregulatory matters. And again, I'm not sure his goal is necessarily to change the law in this area, and he could just as easily lose as win. I mean, I think he would lose hands down, but obviously there's a difference of opinion. So I think he'll start, he'll leave it open. We also have to think about Musk. Musk will be, if things turn out the way that Barron and John and Larry seem to think, it's not going to be good for Musk.
But here's the thing about Musk.
Well, let me finish,
Yeah.
okay? So that kind of leads me to the conclusion that he'll start, but he will not finish, and he will spend most of his time on deregulatory initiatives, particularly in the media sector, which Republicans have been trying for years and years and years. They're going to try to change the 39% cap, which is on how much coverage broadcasters can have. You can only have cover 39% of the country. I don't know how he can do that because it's a statutory mandate, but they're going to try. I think I have some ideas. I'm not going to give them to them, but in any event, so I think that's where the energy is going to go, and this will be part of the docket, but I don't think it's going to get finished. He can prove me wrong.
What's the original meaning of 39%?
And by the way, as we came up here, this panel said, well, the last panel said everything, so we're never going to be able to fill an hour. I know these people. I knew that they could easily fill an hour. So join me in thanking our panel.
expropriation or confiscation of private property or business to impose socialism on the people. Let's talk about authoritarianism here. What it means is whether you hold the deed to or the title to your business, what does it mean to do that if the government holds the power of life and death over that business or property? Such machinery already exists. The government can find some charge to bring against any concern it chooses to prosecute. Every businessman has his own tale of harassment. Somewhere, a perversion has taken place. Now that is what we're seeing today. That is what this administration is doing. It is essentially trying to convert law firms, broadcasters, private tech companies into appendages of the state because it holds over them the power of life and death. That's what the broadcast licensing system does. That's what Section 230 does. It gives the government leverage. So that's my way of setting up the conversation today for this final discussion about what's next. So that's the jawboning part of this. We'll get to jawboning. But let's just start with Gigi's prediction here. Gigi, you talked about things the agency is likely to do going forward. I don't think Donald Trump cares about deregulation unless it personally benefits him. He does care about 230. I think he's intent on the FCC doing something about that. So if you're Brendan Carr and you're looking for things to do, what tools would you use to try to pressure tech companies? What exactly is it you think the agency is going to do while it's pursuing its deregulatory agenda? What does it do on the issues we're talking about today?
Well, again, the mere starting of a proceeding can chill behavior. And I think a Section 230 proceeding is not the only proceeding that the FCC is going to launch in order to do that. I do think there's been, an awful lot of talk about whether does everybody know what a virtual MVPD is? I know you do, John. So basically, these are companies like Fubo TV, what are some of the others? Basically companies that act like cable operators, but they don't have coax, right? It's all streaming, and it's multiple channel services, right? So Peacock, Peacock is not it. Who else is virtual MVPD? YouTube, obviously. YouTube TV is obviously a virtual MVPD. I believe that he will start a proceeding to look at the question of whether virtual MVPDs should have to engage in retransmission consent. He's talked an awful lot about, trying to protect local broadcasters and, how they're getting ripped off by the networks. He's very anti-network, so there's a difference, right, between the networks, CBS, NBC. Even though they do own stations, they can own up to 7 stations, and their affiliates. So I do believe he'll start a proceeding there as well.
And that's essentially what Commissioner Symington called for in that op-ed as a way of cracking down on the business model of tech companies.
So you've got at least 2 votes, and you'll have a 3rd vote in a month. So I think at least those 2, I don't know where the NewsGuard thing goes, but again, just merely starting a proceeding without necessarily finishing it can be enough to really chill speech and bring some of these companies to heel and make Donald Trump very happy.
Yeah, we haven't talked about this, but NewsGuard was also a target for Jim Jordan. Jim Jordan demonstrated just how effective these investigations could be with his war against the Stanford Internet Observatory. So famously, after sending them a series of subpoenas, they shut down because just the process of harassment, just the legal bills in responding to that, Stanford didn't want to deal with. And I think the administration is counting on the same willingness to cave, to bend the knee, happening here again and again. So, Clay, what do you see the FCC doing next?
Well, I wanted to hear your theory about the 39% statute and how the national ownership cap, and if you don't mind.
I don't mind at all. So right now, this is something that really kind of gores my ox. So does everybody remember, so there's some different ages here, what the difference between a UHF station and a VHF station was? Okay. All right. Well, some of you might not. So back in the day, and I'm really old and I'll tell you why, channels 2 through 13 were considered very high frequency VHF, and there was better quality. Now, and then UHF was 13 to 62, something like that. It was UHF. And by the way, when I was a kid, you couldn't even click in, like, it was before remote controls, you couldn't even click in the 13 to 16. You had to tune it, kind of like a radio.
It was very fuzzy.
Yeah, very fuzzy, exactly. Anyway, the FCC, if you bought, they were trying to encourage people to buy UHF stations. So they said if a UHF station will count as half of a station for purposes of the ownership caps on the media, it's called the UHF discount. Now, when I was at the FCC, we repealed that because in the digital era, there's no difference between a VHF station and a UHF station. It's moronic to have that distinction. Chairman Pai reinstated it because he wanted Sinclair to be able to buy Tribune, and that's a whole other question why that didn't happen, why he blocked it. We can talk about that at a happy hour. The way they can get to screw with 39 is say that a UHF station is worth third of a VHF station, even though, again, it makes absolutely no sense in today's, but I think that's almost the only way they could do it without messing with the statute.
And just for everyone's clarity, 39 is?
39%, so no one company can reach more than 39% of the American households.
And that was a compromise.
That was a compromise, but that is a statutory requirement. And broadcasters believe that the FCC can somehow repeal that or weaken it. They can weaken it, again, by changing the UHF discount. Maybe they've got some other way that they want to do it.
I mentioned that on an earlier panel, too, about the NAB now in Sinclair coming in and asking under delete to get rid of that 39% cap. And one of their arguments is local journalism will improve by scalability, that if we can reach 100% of all TV households in the country, then we have more money, and we're going to plow, you can believe this, we're going to plow that money back into local journalism. And then my point was, but if Chairman Carr is going to police journalism and with the news distortion rule, are you really getting quality local journalism out of this whole system? So there's got to be something more than that. I don't know.
Enrique, predictions?
So if you had the bingo card with UHF discount on it, there was a huge payout on that, so congratulations. That was great to hear. I hadn't heard about that in a while. And if I can actually bring it back to the law of job owning, I think we've talked a lot about the Volo case, but I think Judge Posner had, to me, the most helpful discussion of job owning, where he said the differences between attempts to convince and attempts to coerce, right? So if you think about that in the abstract, then there's probably, and being mindful of some of the things that Derek was talking about yesterday, about the government has to be able to speak, right? You might not in the abstract have a problem with requests for information, comments about, please provide the agency your views on specific topics. You might not even have a problem with, again, in the abstract, the head of an agency saying, here's what I think fair, neutral content moderation is, and here is what I think you all should be doing. But I think the problem with that is, I think, again, to call a theme that we've been talking about a lot over the last 2 days, is that the law of job owning doesn't take into account when the pressured party is in litigation with the Department of Justice or in litigation with sympathetic state attorneys general, or that wants to get a deal done, right? That's true with respect to two-party job owning cases, right? So that person who wants something from the agency or fears retribution from the agency is likely not going to be the First Amendment plaintiff, right? And that's a concern that really a lot of us have been expressing over the last couple days. But that's not every job owning case, right? The job owning cases, including a lot of the job owning cases that we've been talking about, are three-party job owning cases, right? So Volo is a three-party job owning case, right? The party that's being job owned is Lloyd's of London. The First Amendment plaintiff in that case is the NRA, right? Same with Murthy. The parties that's allegedly being job owned are the platforms. The First Amendment plaintiff is the user. So I think if we're worried about this, I think we're right to not be optimistic about the possibility of the platforms themselves raising First Amendment claims, because again, they want something for the agency. I think the work to be done is, who is that third party, right? Who is the party that can say, because the platforms are being coerced into adopting things that negatively affect our First Amendment rights? Actually don't know the answer to that question. I mean, maybe, it may come to me on the plane on the way home, but I think that's the real kind of theoretical work that has to happen if the courts are going to be the place where these First Amendment issues that we've been talking about are going to be resolved.
That's really tough, though, right? I mean, imagine the letter that Carr has just sent to YouTube asking why they're not hosting this Christian broadcaster. In the old days, you could imagine where there were limited channel capacity, you could imagine some other channel operator bringing suit and saying they have standing because forcing carriage of someone meant they didn't get a slot. That doesn't seem like an argument that works today. I mean, maybe it does. Maybe I don't understand how YouTube works. But if you can have infinite offerings, who has standing to sue in that circumstance?
And that was obviously the problem in Murphy versus Missouri, right? The temporal nature of that, and they said the independent incentives that they have to moderate content, irrespective of what the Biden administration may or may not have been doing. And so I think one of the problems, obviously, in the Murphy case was they threw everything up there, right? They threw all these things up there, almost like a giant class action from everybody. Yeah, you got 2 states and 5 individual plaintiffs. But if you're going to have one of these and make it succeed at all, it's got to be more of a, if you go for it, it's got to be more of a pinpoint strike where you actually line up the sequence of real statements, right? And it's going to have to be one single person who has this, because I think that was the problem in terms of the case that went forward. They threw everything out there. They didn't have their facts lined up. They couldn't show it. And so, I mean, the test officially is for this, it is coercion, right? And you either have to show a threat of adverse legal consequences. It doesn't have to be explicit, but it can be a thinly veiled threat, or it can be an inducement, right? I can induce somebody by saying, hey, here's the offer you can't refuse. I'll give you blah, 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 and you're going to take that offer. So it's either one of those two things, but it's going to have to be a much more, as somebody used the term rifle shot the other day, it's going to have to be that kind of precise strike if it's going to be successful. But I think Gigi's point is right. None of these have to reach fruition. It's the cost and litigation and just dragging it all down. And I think it's the flood the zone, right? That's the big theme for not just this, but it's everything, all the litigation out there, whether in whatever area it is, it's flood the zone and throw people off and make them spend money.
I mean, as a person who's gotten thrown out of court many times for standing, when it's probably much more legitimate, I just don't see how somebody can challenge, a third party particularly, challenge a letter like that. I don't see how a court would say you have
Of course, I'm not so much referring to the letter. I'm referring to more like, okay, let's say they get carriage, there's something you can point to that maybe you can argue is some actionable thing. It's not a final agency action, so
right.
It doesn't seem to be what the APA contemplates, but you can imagine there will be a range of scenarios where something will actually happen. It won't just be a letter. And we're going to get into these harder questions about whether these are questions that can be reviewed by a federal court, not just understanding, but is there an action?
Is it final agency action?
Is it right?
Yeah, is it right?
I mean, I think all these questions of administrative law and of constitutional law and standing are really going to be critical to whether the rule of law really means anything here.
Yeah, agreed.
Now, our themes are investigations, jawboning, and remedies. So do we have anything else to say about what's likely to happen on investigations?
I can tell you that I know for a fact, because I've talked to people inside the building, that it's been made clear that they're encouraging people in the Enforcement Bureau to go to the media part of the Enforcement Bureau. So that's kind of been a dead letter for a while. Like, there's all different divisions in the FCC's Enforcement Bureau, right? There's privacy, there's telecom, and there's media, which is kind of, again, how many media enforcement actions have there been, like serious ones, in the last 20 years? Not many. But they're encouraging people to go from some of the ones, for example, privacy, where there's not going to be nearly as many investigations to media. So you can best believe that there will be, the threats of investigations that are going to media companies will be realized.
I guess I'm just concerned every time that Trump doesn't like a story, right? And then he'll threaten some news distortion complaint, and let's open it up. And that's really that's the formula right now. Like the other day, it wasn't just the CBS 60 Minutes, it was the CBS 60 Minutes on Ukraine, right? That came up in Greenland. He didn't like the story on that, and he says, let's go and investigate that. I just see it endlessly happening.
Well, he didn't like the coverage, MSNBC's coverage of Abrego Garcia, even though MSNBC is a cable channel, is not subject to FCC jurisdiction. However, of course, NBC's stations, not NBC the network, is subject to that jurisdiction.
So this is worth spending just a minute on, because this really critical distinction gets lost, I think, to outsiders. Of course, the media landscape has moved to cable. Most of what matters is not broadcasting, it's cable. What would you say about the FCC's ability, given that distinction, to exert leverage over cable companies, which they're trying to do?
That makes an interesting question. I was thinking about the jawboning thing, right? If we go back to that, because one of those questions is the direct authority of that person that came up. Does the person who, and so in Vullo, Maria Vullo had direct authority over those insurance companies, right, to mete out things. If the FCC doesn't have direct authority over, you see what I'm saying, over cable to enforce a news distortion rule, which it doesn't, and if it doesn't have direct authority over internet companies and social media platforms, I don't know, it raises that's an interesting question.
Well, again, you'd say, well, it's the same parent company, right? Same parent company, even though what I didn't like was on cable, still NBC owns it, NBC's a licensee, I'm gonna go after their licenses.
So I think we should be careful about drawing lessons from the first Trump term with respect to what might happen, but I'm sure everybody remembers that last time Trump threatened to take away CNN's licenses, which, as Barron just said, is not a thing, right?
And he threatened to take away NBC's license.
And he threatened to take away Comcast. He called Comcast and NBC. He said they were committing country-threatening treason, right? I guess it's impossible to tell whether or not that chilled coverage critical of the president, or whether or not it will. But I think my hope is that some of these larger media outlets that also have FCC licenses because they own affiliates will take these issues seriously.
So let's talk about remedies. What do you think the commission might try to do in terms of remedies when it actually brings legal action? So those could include things like trying to cancel a license. That could include imposing conditions. What do you think we should be afraid of here? What should we be paying attention to? What do you think would be most problematic as a threatened remedy?
I mean, in terms of the remedy itself, but just the actions themselves are enough probably to change the conduct in some cases, because you don't have to even get that far, I think.
Yeah,
but if you think about,
but the larger the remedy, if there are fines at issue,
right,
for example, even if they're never used, it's the threat of the remedy,
right,
that exerts leverage.
I mean, I think the most vulnerable piece for the companies are the mergers. I do not think Brendan Carr is going to take away licenses. I really don't. I mean, that really is, I mean, you know, and I've been a person who would have preferred that the FCC have more scrutiny over licensees, you know, over the years. But I just don't see it, okay, because that really is like the death penalty. But I could see extracting major conditions, like if Paramount settles with the president, he will let that thing go through. That is what he's waiting to do, okay? I could see either conditions, or I could see it being blocked. So I'm going to tell the Sinclair Tribune story. And again, I don't have proof, but all I can say is Chairman Pai was well on his way to approving that merger. And he was, you know, he loosened the media ownership rules. He was looking at loosening the 39%, was doing everything in his power so that Sinclair could buy Tribune. And I'll never forget the day I woke up and it got blocked. And I was absolutely shocked. I couldn't believe it because the skids were being greased. The story I've heard, and again I have no proof, was that Rupert Murdoch went to the president and said, I don't want this merger to happen, because he didn't want the competition, right? Sinclair would have become a conservative broadcast juggernaut like Fox is a cable conservative juggernaut. So, you know, that was an instance where, again, assuming this is true, that basically Trump had Pi do something that he was not inclined to do. Same thing with Section 230, by the way. So, you know, if there's, you know, if the president tells Brendan Carr, you know, Paramount hasn't settled with me, you should put the kibosh on this merger, I fully expect that that will happen. So I think the transaction area is where the companies are most vulnerable, and as we just saw, again with Verizon, most willing to bend to the will of the regulator.
So, for example, the Charter-Cox deal that was just announced today, can you walk us through concretely what kind of mischief do you think a deal like that might allow the administration to get up to when it's two cable companies?
I mean, I don't know. Does Trump have a beef with either Charter or Cox? I think Charter is a pretty conservative company. I just don't know. Does he have a beef with them?
But critical detail, do either of them have media holdings?
Cox does. Oh, no, did Cox sell their broadcast stations? I don't know.
Well, there you go.
Cox owns Axios. Muy interesante. Lots of opportunity for mischief.
Going back to like Commissioner Gomez's talk this morning, I was thinking about things like to try to, how do we tie back some of the things, you know, she was like, speak out, you know, and have the courage to, you know, speak out and don't be fearful, because fear kind of begets fear, but courage begets courage, which I thought was a good line. But I realized too, like when we leave here, if I were to go down the street or to get on my airplane tomorrow, and I were to tell somebody about any of this, their eyes would just glaze over. And so, I mean, we can have this conversation, and that they would not know. And I mentioned this last night to somebody. I've got a cousin in California, and it's just the different worlds. I think, how do we make people see the one world versus the other world? And he's a Republican. He's 72, and he runs his own business. He's college educated, Cal State Northridge, smart guy, and he's successful. And he emails me the other day about what he likes about Trump. Okay. What he likes about Trump is DOJ, and he likes the fact that DOJ has uncovered fraud and graft and everywhere and bringing money back. He likes the fact that the border has been closed off and shut down, right? And he likes the fact that boys and men can no longer compete in girls and women's sports. And that's what he's focused on. It wasn't focused on the things that I think we're all focused on, the authoritarian power grabs and the lawlessness. And when it comes to the FCC leveraging the regulatory authority of a commission to prop up his own lawsuits in that symbiotic relationship. And so I just got to think about it. When I get on the plane tomorrow, you know, this is great and all fine and dandy, but how do we really make, because the commissioner had a great point this morning, people understand that, and I have no answer to that. Maybe I'm just, you know, I don't know.
I think you're right. I think you're right. And I do think it has been a frustration of mine, and Baron, you helped me. So I tried to get a bunch of former FCC commissioners on a filing in the CBS News Distortion docket, and asked about 17 formers, many of whom are just retired. Like, they don't have any more, you know, they don't have to be nice in Washington necessarily. And Baron tried to help me with some of the Republicans. We got 5. And I had one former say to me, when I showed them, I'm not going to say what their gender is, you know, that I had 5, they said to me, oh, 5's a good number, go with 5. So people have to.
Now, five total.
5 total.
Of those, two were chairmen, right? Or two chairs.
2 chairs.
2 Republicans.
2 Republicans.
Yes.
2 Republicans, 3 Democrats. And with some of those 5, I really had to, you know, put the hammer to them. So we do need people who are in positions of power and really know what this agency was like to speak out, and not just be on a filing, like to actually, like, I give Al Sykes and Tom Wheeler a lot of credit for being
Al
out
was
there.
President Herbert Walker Bush's FCC chairman.
Right, but it would be nice. I mean, obviously Ajit's not going to do it. He's running a trade association with a lot of business for the FCC right now. But there are, you know, a bunch of others who just declined, just to sign on to a pleading. So I do think it's much more powerful to have people who are in those positions of power than it is, frankly, for us to say this is wrong.
Well, Gigi, I'm working on it, and
I know.
I actually have some reason for optimism. I don't want to give away anything right now, but stay tuned for more from Tech Freedom on this. I think you might be pleasantly surprised. You know, Jerry Fritz was here today as really the Republican who orchestrated the unraveling of the Fairness Doctrine to explain that what's happening today is far more intrusive than what Republicans were against in the 1980s and had been against for decades. And I just want to say, don't give up hope. There are some people out there who I think will speak out that might surprise you. And I think it will become more and more necessary. We're only going to see more of this meddling in the media, because this is not going away. This is the top administration priority for the FCC.
But also, obviously, it would be nice to see more members of Congress speak out. You know, we don't have to get into that. And that it's just, I mean, one of my obsessions is trying to get the states the BEAD money, right? The Broadband Equity Access and Deployment money. I don't want to go too far off topic. And this directly affects the constituencies of largely red states, right? Because they're the ones that are, you know, that have, you know, all these huge gaps. And other than like 2 senators, it's like crickets.
Well, since the closing here is really about what's next, a thing we haven't talked about at all is it is possible that control, at least of the House, might change in the next election. If you were advising congressional Democrats about what to do, what would you tell them? How can they be most constructive here in both in exercising oversight functions and also in proposing real substantive legislative reform? Clay?
Go ahead. Go ahead. No, go ahead, Clay. Go first.
No, because I was thinking about so far what we've seen is more symbolic things about saying, the FCC should not do this and the FCC should not do that. That legislation goes nowhere, right? So I don't really know how they're going to do that. I think you're right. In the 2 years, we typically see a switch, right, in the House, especially this time. We probably will, I think. In the meantime, to get there, I'm not sure what they need to do, but they need to be ready to go with something when they get in there.
So when I worked for Wheeler and the House changed to Republican, I think the Senate was also Republican, he was up there every week testifying. And I would say they would, and it would be it wouldn't just be House Energy and Commerce, it would be like small business, and it would be, Homeland Security. And that's what Democrats should do. They should bring Brennan Carr and the Republican, all of them, up every single week and have a massive hearing with everybody showing up and press. And even though they can't pass any laws, it takes you off your game. I could just say it takes you off your game. It takes up a lot of time. So that's number one. Number two.
Can I just interject?
Yeah.
I mean, I think in some ways Brennan would love that opportunity, right? In some ways, what he wants is to fight, right? It doesn't take him off his game if all your game is just fight all the time.
Well, except you're publicly having, again, if Democrats do a good job of asking sharp questions and pushing back, which, by the way, they generally don't do, then it could make him look not so great, okay? But the point is that if you're constantly, again, I know this from personal experience, if you're constantly prepping for hearings, you can't get all the bad things done.
But that assumes that you have some sense of shame, that you are expected to be consistent, that you care.
I also don't think, I think people also in this town put way too much stock into hearings. Hearings are like a 24-hour news cycle. So I don't think it's going to make Brennan Carr look good. Nobody's going to give a darn unless they're watching C-SPAN, okay? But what it does, it slows them down.
Okay, so I interjected. You were going to say a second thing.
The second thing is Democrats have to come up with a plan. And not just for, communications / tech. They need to come up with a plan, period. We need our own Project 2029. Democrats don't know what they're about. They really don't. In this space, it's not just net neutrality. It's the whole, it's all of it.
So, Gigi, you're the right person to ask this question to. Look at what happened on voting rights reform, where you had, this HR1 was this compendium of all the ideas that everyone in the Democratic Party had about voting rights, and it failed to prioritize the things that were really, really essential, right? And Democrats got tied up in this idea that the real problem was that you couldn't hand out water bottles to people in line, right? And so the result was we didn't deal with the things that actually were very, very clear interferences with the fairness of elections. And I'm concerned here that what's going to happen in a Democratic Project 2029 is it's going to be, you know, the laundry list of the battles from the last 30 years, and not.
If that's the case, then Democrats will be out of power forever. Okay, I'm just saying.
Yeah.
Okay?
So
I
how do
mean,
we-
it needs. Look, I'm the last person to tell the Democratic Party what to do, but I think you have to focus on pocketbook issues. You have to focus on working people. I mean, you know, the things that Bernie Sanders and Alexandria Ocasio-Cortez say, they're right. Whether or not they're the candidates you want to put forward,
But in this context,
they have the right idea.
But in this context, this is not about pocketbook issues. This is about
Yes,
the
it
role.
is.
Well, I'm not sure what you mean by that. What I mean is, this is about the role of the government in meddling in media.
Mm-hmm.
How do we make sure that the Democratic response just focuses in a laser-targeted way, such that you could get, you know, ideally, what you'd have a Republican former commissioner who goes up to say, this is a problem and this is why I'm in favor of X, Y, and Z reform that's being proposed by Democrats. How do you get to a point where the focus is on things like that and not on a laundry list of other issues that are not about these core abuses of power?
Yeah, I don't know. I mean, I agree with you. I mean, I think that they need to they need to narrow down what's important and get to the nub of what's going on right now. Whether they have the capability of doing it, I just don't know.
On the hearing point, I was going to suggest precise Elise Stefanik inspired yes, no questions, right? So I could, you know, I don't know Brendan Carr at all, let alone as well as many of the people in this room do, but I think, you know, if you were to ask him a question like, can the FCC shut off 60 Minutes for doing an interview with a presidential candidate and make him answer the question yes or no, right? I think that there could be some benefit in that. And if that is a fight he wants to have, like Barron says, let him have that fight, because there would be parts of him having that fight that could be portrayed in a way that could cause problems for him and his agenda.
We've talked a lot about in the last 2 days the pendulum swinging back and forth, right? And my fear is, and I think this is what Gigi's getting to, is how far now, because we've swung very far, right, on this pendulum, kind of off the scale. When the Democrats get control at some point in the future, and they will, then how far does it swing back? And what are those issues? I think, what are the ones to not swing so far away that it just, you know, it's just as bad as it is now? And that's.
What else haven't we covered here?
I mean, I think the synergy between the FCC's regulatory authority, the public interest being used as a political tool to prop up and help Trump out in his litigation against CBS. I think that symbiotic relationship, and then we talked about the Center for American Rights filing the complaint initially. Trump sees that. Trump files lawsuit. Then Rosenworcel dismisses the complaint. Then they're resuscitated. Is they come in? Then they're resuscitated shortly after that, right? It's everything is working together. And I think that's.
So where are the Joe Rogans of the world, right? Why doesn't this trouble somebody like him? Like, he's not really a partisan, right? He's a personality. He tends to the conservative, but he's not I don't consider him a MAGA. Like, so the folks that are actually changing a lot of minds, and not just right-wing minds, are the podcasters. Where are they on this? How come they're not covered? Kara Swisher does talk about this, but a lot of the sort of the very popular podcasters, they're nowhere on this.
It's a great question. I would assume that the initial answer is they don't see themselves being affected by this. And unless that changes, I wouldn't expect many of them to speak out.
But why couldn't it? I mean, it's almost like the logical conclusion, right? I mean, a podcaster gets very, let's just say Rogan, you know, goes off the reservation and starts really criticizing Trump. What would stop Trump from going after him? And again, even if there are not the same regulatory tools, why not ask Brendan Carr to if Brendan Carr can send an investigatory letter to YouTube TV, why can't he send one to Joe Rogan?
Claim jurisdiction over podcasts.
Or,
Yeah, yeah,
well, it may not be
Yeah.
Joe Rogan, maybe it's the podcast hosts and platforms. Or
Right, or
advertisers.
Spotify, yeah,
That's-
or Apple, or yeah.
Well,
mhm.
that goes to the jawboning point
Right.
in a way, because
And
now
then maybe Apple's like, oh man, you know, Joe, you're not worth the $96 million or whatever you're paying you, you're out.
You're
you
done.
know? Yeah, sort of a.
the speech
roundabout way.
intermediary is just, a third-party speech intermediary.
Well, to wrap up here, Enrique, what do you think is most important? What have you taken away from this event overall?
This has been terrific. I'm so glad to have been invited. I guess in terms of strategy, my suggestion would be to retire the hypocrisy argument, because the hypocrite doesn't care that they're being hypocritical. Like, I don't think anyone is, and I don't think other people are being persuaded by the hypocrisy argument. I mean, everybody on every panel has been great, but not only does Brendan Carr not care what he said 2 or 3 years ago, nobody who's thinking about Brendan Carr cares what he said 2 or 3 years ago relative to what he's saying now. So I just think we have to take these things on their merits. I mean, to quote Logan Roy, I think we think that, on the merits, these are not serious people. Like, we know that, but that does not mean we shouldn't take them seriously.
Yeah, I guess my big takeaway was that basically on these issues, Chairman Carr and Donald Trump have united people who are conservatives and united people who are liberal on particular issues here that probably we never thought possible. Probably never agree on net neutrality, things like that. But when it comes to the actions right now that we're seeing, I think we're all kind of unified by that sense. It's this lack of a rule of law and an unwillingness to follow certain procedures. And somebody we were talking about, who doesn't like Bush the second, wow, he looked normal now because he played within at least a certain realm. And I think that's the thing that's missing right now. So I think the unity that many of us feel, at least on some issues, comes through. And thank you both, CEI and Tech Freedom, for having me. It's been great. I've learned a lot.
Thank you so much. And look, I've had people say to me, well, I don't know if I want to speak out and blah, blah. It's like, if there's ever been a time, it's now. But I also agree with Clay that we have to shape a message that is more broadly appealing to people. Like, I think, unfortunately, I think the American people don't give a darn about First Amendment rights. So how do you craft a message that makes them care? And I think it's a major challenge.
It is. It's like, how do I get my cousin to focus on those things? Because I get where he's coming from on the other things, but the other part, it's like, no, there's a lot going on that's you're not talking about. So yeah.
Well, I'll just note here that a person that we invited to participate in this conference, who had been a senior Democrat at one of these two agencies, wrote me back and said that after some soul searching, that he decided to bow out because it just wasn't comfortable, presumably because of the pressure that would be brought to bear on the university that he's involved in today. And I can't fault him. I understand why someone would take that position. But, Gigi, it's not, Gigi, you noted that you only got 5 of 17 former commissioners to sign on to your excellent comments in the news distortion proceedings, and many Democrats didn't sign on. And I'm just pointing out here that it's not just that we don't have enough Republicans speaking out. We don't have enough Democrats speaking out. There are all sorts of reasons why, in the face of authoritarianism, people just decide that they don't want to pick that fight. It's not worth it to them. They don't want to get involved. This is how authoritarianism succeeds. Everywhere in the world, that is the pattern.
No, and when the law firms, I wouldn't say caved, but they bunch of them early on. That was astonishing. I was astonished by that. I thought, and kudos to those brave young associates who were walking out on those firms. I give them credit for it. I guess when you're young, you can do that, and I give them credit though for doing that. And I think the Perkins Coie who fight this, good, because again, it's all the voices of dissent, whether it's in academia, and I think he went after Harvard for more money today, or cut more funding from them, whether it's the Associated Press and squeezing them out of the press pool and Air Force One. No matter what it is, everything, Voice of America, NPR, PBS, all of these claims, It's any voice of dissent. And so I think somebody used that phrase yesterday about, diminish the opposition and amplify your own view. And that is really it. And like the access part, that's the chokehold, right? We're not going to allow you in, Associated Press. And I saw another thing too, that on his latest trip to the Middle East, there was not one wire service reporter on Air Force One, from not just the AP, but Bloomberg and Reuters weren't allowed on that plane either. And so that's it. You deny access, you control that message and what goes out. So, sorry, it's beyond the scope of this.
Well, as President Reagan said, again, time for choosing. He was calling on everyone to take a stand. I think he would have been appalled by what's happening today, and he would have said, as he said, and as I quoted earlier, that somewhere a perversion has taken place, and the American system of government doesn't mean what it used to mean. Private property doesn't mean anything if the government can make you do what it wants. And there we are. So with that, thank you, all three of you. And thank you very much for coming. I'm going to ask my colleague Jim to just come up just to share your final thoughts as we wrap up here. But thank you very much, and let's give the panel a round of applause. Thank you so much. So we'll keep this brief and wrap up early. Jim, this is why we do what we do. At the end of the day, these are the most important fights, not just the fight over Title II. You want to come in a little closer to the mic? Or for the camera. So what did you learn? Any surprises here? Anything change your thinking?
So, a lot of thoughts on today, but the last panel especially, and I'm going to say something that's probably not going to be well received here. But I've talked about, and I think I started the whole pendulum analogy. And part of the problem is when you're looking at a pendulum, you can see it swing if you're standing orthogonal to the pendulum. If you're standing parallel to the pendulum, you can't see it swinging because all you're looking at is this ball coming and going away. You can't really measure what the oscillation is. And I think both sides has to recognize that they are in fact instigating that oscillation. And I'm really bothered when there's a difference between a First Amendment warrior and a First Amendment opportunist. And I think people on both sides of this issue are far too often First Amendment opportunists, which means you are all for the First Amendment when it works for you, and you're willing to look the other way when it doesn't, or the opposite. You're all screaming for it when you feel like it's come down on you, but you're okay when it goes against the other guy because it doesn't impact you. And I think both sides are guilty of that. And I think, we were talking about why aren't more people talking about, this issue. I mean, I can come from it from 40 plus years of fighting these fights and having been in the trenches on the fairness doctrine. But it's also just kind of ingrained in me as an Arizona libertarian Republican, that this is how I was brought up. But I think until people recognize that they are in some ways hurting more than helping on this, it's going to be tough. And very specifically, I think until Democrats kind of recognize that conservatives, at least in their own minds, have a reason for feeling like they've been crapped on for the last 4 years, you're not going to get that oscillation down, and it's just going to exacerbate. And there is this sort of subliminal, theme running through here, and every time I hear lawful but awful, I'm almost thinking of that as a dog whistle now, as to you deserve to be taken down because you're lawful but awful. And until we are willing to say that no, it's lawful but awful is actually fine. It's okay. You know, on both sides of the equation, then we're never going to get that oscillation down. And just to say you deserve to be taken down because what you said was idiotic, I'm sorry, is fundamentally against what the Founding Fathers originally said. More speech, not less speech. You know, let the marketplace of ideas decide instead of you deserve what you got by being deplatformed.
Well, I think it's easier to see your point outside the U.S. and the example that I cite, and I just cited last week in Brussels, was the reaction to the abuse of the Digital Services Act. So in 2023, Thierry Breton, who was the commissioner who was responsible for enforcing the Digital Services Act, threatened on social media, on Twitter. He put up a post and sent a letter threatening that if X didn't take down hateful content during riots, that the service could be shut down. Now that's clearly an abuse of the Digital Services Act. That's not what the law says. In fact, fundamental rights law in Europe is very restrictive as to when you can shut down a service, and there's case law on this. So it wasn't surprising that 67 civil society groups from Europe wrote to oppose what he was doing as a clear abuse of the Digital Services Act. And that was great. That was Europeans standing up for free speech in a very principled way. But a year later, when it was Thierry Breton once again threatening Elon Musk with an enforcement action under the DSA, but this time it was because Elon Musk had hosted a conversation with then candidate Trump, and Musk was saying, Breton was saying, well, there might be hateful content that goes out, and that might violate your duty under the Digital Services Act to prevent systemic risks. Some of those groups stood up. Electronic Frontier Foundation stood up. Article 19, which is sort of the European version of that, stood up. And Tech Freedom led a letter with the future of free speech. And so there were a handful of groups that stood up, but it wasn't 67. You know, it was less than 10. Point being, there's definitely a double standard, and I see your point, right? And that there, I would absolutely agree with you. If the issue is whether we're going to use the law against Elon Musk for having a conversation with a political candidate, that's clearly an abuse of power, whether it's in Europe under the Digital Services Act or here. 100% agree with you. And it proves your point that some people don't see the problem. And in that sense, J.D. Vance was right, you know, to criticize not just particulars of European law, but the mentality of free speech is definitely wrong. If they don't see that there's a problem with trying to suppress a conversation with a political candidate they don't like, that's a problem. And that same thinking, it does happen here. So I agree with you. You know, as to the lawful but awful, you know, it's a shorthand. When I use it, I'm referring essentially to otherwise objectionable, right? Private companies are making decisions about speech they don't like, and it's just not for me as a lawyer to say whether that's the right decision. It's their call to make, and we should defend their right to make that decision. But I see your point, that between that sort of shorthand about the law and the moral question getting blurred, these conversations become very hard to have. Do you have any advice about how we collectively can make those distinctions better?
You know, I think we can't let our own personal biases and where we come from as to the content ever get into the discussion of it. I mean, the story I like to tell is in constitutional law class in Georgetown 44 years ago, we had the ACL lawyer come in who argued the Skokie case. And I believe he was Jewish. And one of the members of my section was Jewish and lost her entire family, other than her father, who got out. But basically, everyone, her whole entire family tree was wiped out. And she just stood up and argued and argued and argued that the Nazis shouldn't have been able to march in Skokie. And he kept saying, you know, you have to defend the speech that you hate the most to defend the First Amendment. And after that class, they hugged, you know, and I actually got people out of the classroom because they needed, you know, that time to talk to each other. But unless we get back to those fundamentals that you have to protect the speech you hate the most, we're never going to stop this oscillation, and it's only going to get worse.
Right. Well, anything else to say about how we can work together with the folks that we brought here together today to talk about, let's say, legislative responses on the Communications Act, on administrative law?
Yeah, I think we have our hands. We're going to have our hands full on this one, and I truly believe that the FCC may be doing nothing for the next 3 years other than processing news distortion claims, because I think a cottage industry is forming right now, and you are going to see, the same way that Jerry Fritz this morning was talking about 2,191 whatever fairness complaints. You're going to see 10,000 news distortion claims, and that's all the FCC is going to be able to do for the next 3 years, is figure out what to do with those.
I'm not sure they'd be unhappy with that.
So, no, I think they would be unhappy with that. I mean, because it would percolate back up to the top floor, that you're ruining our lives by stretching this out.
Okay, final word.
No, I've said it.
Okay, well, in that case, I want to thank everyone for tuning in. I want to thank everyone that came. I want to thank the folks at CEI and our staff, my colleagues Dan and Jared at Tech Freedom, who made this event happen. Jess Lelujan, our partner at CEI, Amanda France here at CEI. Thank you so much for putting this together. And thank you all. We will be doing this in some form in the fall, I suspect, so stay tuned for more. Thank you.
Thank you.